Well, hello. Let me know if you guys can hear me. I hope you guys are ready. I'm ready. I'm ready, but I'm not ready. I'm ready, but I'm not ready. This is going to be a lot of information, you guys, but I'm glad we finally have it. Sandy, hello. Wendy, hello. Toby, how you doing? Toby said, it paid to Payne to make that symbol with his hands. Oh, there's been a lot of symbolism stuff in this case. Hey there, Amanda. Danny, how you doing? Miami News already hit it. I mean, it's important. It's important, so it's not surprising. Hey, Chief. JS. Deb. Elise. Deb again. Simply Solo. Yeah, you'd be questioning, right? Hey, Marie. Sallyport. I can't wait to read this stuff. I'm getting like comments on my community post about certain things that are in here. And this is going to be crazy. Hey, Dawn. Sarah, how you doing? California Grandma. Valerie, how you doing? Gannon, we're going to say hi for about 5 minutes, then we're just going to get right into it. Johanna, how you doing? See, this is my big question right here. This question that Sallyport just asked. So can the defense still keep stuff out with motions? They mean in limine. That is what the state is supposed to be filing. And I have so many questions for that, because if the state gets their motion in limine like approved, I don't think the same thing happens. Like if the defense would have gotten the IGG or any of the stuff suppressed, then any of the other evidence that came from that stuff would be considered fruit of the poisonous tree and it wouldn't be allowed in court. But the same thing doesn't happen with the state whenever they have something taken out, I don't believe. That's my biggest thing that I'm really trying to figure out, because they said no now, but the state, you guys that are here, that have been here, no. The state has been trying to get this IGG stuff suppressed, taken out of court, taken away from evidence, taken away from everybody's consideration since before he even got back to Idaho. It's in the information Don Daniels wrote to search his apartment. Okay? Everybody needs to be keeping that in mind. I've got something to say. How you doing? Robin, I know Delphi 2.0 is exactly what I'm like. For real. Echoes, how you doing? Ample Spark, how you doing? Hey, Ro. Look, all I know is a comment that was left, and I'm not going to say it out loud because I don't want to get confuzzled or confused. So we're going to get to there. Hey, Claire Bear. Hey, Nothing Half-Assed. Yeah, something about, well, I guess I'll just say it. Somebody left a comment stating that there's something in here about in the IGG portion that mentions something about 4 brothers, but 2 of the brothers not having the same last name as Kohberger. And I'm like, what in the actual shit is happening? That'll be crazy stuff. And I'm just going to preface this now before I get on with the rest of my hellos, because I have about like 2.5 minutes left. I have been very, very clear that if puzzle pieces start to come together and they start proving their case and there's things that start making sense, that's what we're going to follow, because the evidence is what the evidence is. Right now, they have failed to do so. Now, I'm not saying that there's going to be anything in these documents that might change the trajectory of thinking here, because I haven't been able to do nothing but read the very conclusion to know that everything got denied and know that we needed to come and talk about stuff. I have no idea what the details are. I was busy doing mom things, and now I am doing us things. So now we're all going to find out together. If anything is in this, I'm going to be honest about it. So I don't want to hear anybody crying if something comes out in here and I'm like, oh, well, hold on a minute. Y'all already know what it was going to be if something real came out. But they failed so far with literally everything. Hey, Joey, how you doing? Wheezy? Hey, Lenore. Hey, Stephanie. I also am going to show you guys what it says on, hey, Falcon, what it says on the summary, the case summary, because it does talk about the transcripts, but it mentions something about audio. You think I would have like checked to make sure you guys could hear me before I ran my mouth for almost 5 minutes straight. I am just kind of like, hey, Legendary. Hey, Caroline. Hey, Gail. Hey, Ransom. Hey, Doc. I'm just like, wow. Tommy hearing. Yeah, I'm just really surprised. Like, just with the stuff that the public knows, I don't understand how, with the judge knowing so much more. Oh, I know. Give yourself a pat on the back. back. Hey, Deborah. Hey, Laura. Okay, you guys, we're at right past 5 minutes. So, hey, hi, hello to anybody and everybody that is in here that I have not gotten to. It's going to be a wild ride. I hope you guys are ready. I told my friend earlier, I said, this might end up an all-night situation because if there's this much information in here, that is this much information, like not just a bunch of boo-boo, not just a bunch of repetitive and case sightings and bullshit. If it's real, true information, we're going to be here till the last page tonight. Because the first one is like 30-something pages. Then the other one is 36 pages. And then one of them is like 11 pages. We might just be here all night. I don't give a damn. I honestly work better on less sleep. So if I only get like 4 or 5 hours of sleep before I have to work tomorrow, then I'm going to be just fine. I'll take a nap. Yeah, I saw that they're trying to say now. Do you remember which one that was in? Because I know that the IGG is the one that mentioned something about the brothers. Do you know, Kate, which one talks about DM apparently carrying something the shape of a vacuum? Oh, Joey, no, look. And I got some Southern Butter Pecan liquid stuff for my coffee from Amazon today. I'm ready. Hey, Jackie. Hey, Jennifer. Hey, Meg. Hey, John. I know I'm ready. Okay. It's in the Franks one? Okay. I was going to let you guys vote, but I think that the Franks hearing one is probably, I don't know if I want to do the Franks first or the Franks last. I feel like the IGG is probably the most important one because everything stems from their basis that the DNA was illegally obtained and placed at some point. So I feel like the IGG one needs to be the first one. I think that's what I'm going to do. I'm about to open it. Oh, that's the one we're doing. Okay, that's the one we're going to do. Okay, so I'm going to go ahead and show you guys the thing on the case summary portion first. Let me go ahead and open this page up. Oh, man. Okay. Girl, I don't know. We're going to get to it. I don't know what we're hearing about brothers. I'm hearing some crazy stuff in the comments because I don't know. But we're all going to find out together. Okay, let me get this thing situated because right now it is not where I want it. That's not how I want it either, but we're going to fix that here in a second. Okay, let me show you guys the case summary real quick. So in case you guys didn't see my community post, you can see where it says something about the transcripts. There's like redactions going to be filed, but then it mentions something about audio. So that would be freaking amazing to get audio of the closed hearing, because then it wouldn't be so difficult to read if it was just like written out transcripts. Okay. I'll make this bigger as we go. Oh, thank you, John. I'm trying. We're going to get through this. I promise. Thank you for the $10. We're going to get through it. Okay. I don't know what this word means right here, but let me catch up on the rest of the stuff. So we did see that we had these pop up. This is the rebuttal to the defendant's supplemental response to request for discovery regarding expert witnesses, and then motions to seal all of the things. And again, those aren't important. You can't see literally anything. I don't know what a pro whatever this word is, so I'm going to Google it real quick. Okay, so pro hos, I don't know how to say that. This is interesting. Okay, hold on a minute. This weird term is a legal term for adding an attorney to a case in a jurisdiction in which they are not licensed to practice in such a way that the attorney does not commit unauthorized practice of law. For example, an Ohio licensed attorney may practice pro hos vice in a New York case, although normally they would be engaged in the unauthorized practice of law in New York without admission to the New York bar. So there's an out-of-state attorney? Pro hoc vice? I believe you. I don't know. Thank you, Jackie. Thank you for the super sticker. That's very sweet. So who's coming in from out of state? Because that means that they're trying to bring in somebody from another state. See, the Karen Reed case is one that I haven't, I mean, I know enough about it to know that there's like a lot of questionable stuff and like cell phone evidence that says something about going up and down a flight of stairs and how his injuries look a lot like dog bites. But like other than that, that's really all I know about the Kara Reed case. See, that's what, maybe it's a Pennsylvania lawyer coming in specifically for Bryan's side. That's very possible, Salty Grace. That's very possible. Very possible, but it's not that this isn't out yet, and I don't know if we're going to be able to see anything in it. It'll be interesting to know for sure, because we also have to remember that we have Dylan and Bethany involved in this stuff too, and we know for a fact that we've seen the name of Bethany's lawyer. So I'm wondering if if it's somebody for that. I don't know. I don't know. Interesting though. Then we have, see, this is the one right here. Motion to authorize release of court record regarding the audio recordings, and I'm assuming that means for the closed hearings, because it also goes on to talk about the redactions for the closed hearing transcript. So I'm like, okay, if they're going to release an audio, is it going to be beeped out, like muted out on the words, or just like completely cut out? I wonder what that's about. Right, Denise, I know she's not the defendant, so I guess then it wouldn't be for one of the witnesses, right? Oh, I'm not even showing you. Thanks for telling me. Yeah, right here. This is the one that we were just looking at. So then it would maybe be a Pennsylvania attorney coming in for Bryan? Or a Washington attorney maybe? Or maybe it just didn't even need to be something specific like that. I don't know. Thank you for joining, Mrs. Lankford. Thank you for joining and becoming a member. I don't know. I have no idea. But you see right here how it says audio? How it says audio? So I don't know how they're going to bleep stuff out that they're redacting, but they also have like this part right here. So I don't know. I don't know if we're going to actually get audio or if it's going to be a transcript that we're going to have to read. It sounds like audio, but it would have to be heavily edited, which I don't trust. You know, I don't trust anything if we don't watch it live anyway. So C Tires, thank you for the $4.99. I appreciate it. Thank you. So I don't know. It's very interesting though, but they're sealing all of that stuff. Let's see. And then the defendant has no objection to whatever redactions that I guess the state submitted. They're sealing this something else for the defendant's supplemental response to requests for discovery for expert witnesses. And then we have the orders for Franks and all the stuff that we're now here to freak out about, I guess. Okay, so this is the IGG one. Yeah, okay, so this one is 29 pages. And let me get down to the bottom here. Okay. So the AT&T, Google, USB, Apple and Amazon is 36 pages. Okay. And, oh, see, I need to learn how to go back over to the next tab before I close it. Okay. And then the Frank's hearing one is 38 pages. 38 pages. And then the arrest warrant one is by itself, and it's 11 pages. It's not that long. But I'm really wondering how much of the orders are going to be repetitive. You know what I mean? Like how we always have like the same portions and then it gets to the information. I'm wondering how much of it's going to be like that. So we are going to start with the IGG one first. I'm ready for some info. You didn't miss a dang thing, Tracy. We're literally just now starting to read the documents after going through a little bit of the case summary to see what's been going on. So we are going to get started now. And now I'm not going to be, I need my foot thing. I'm not going to be staring at the chat unless I stop and like, I'm like stopped for a while and glance over. I'm probably not going to see a lot of these comments because I want to try to get through the information. So I'm going to pull an Andrea Burkhart and try to read as much of the document as I can before looking over. If there's something that you want me to see, put like hearts or something colorful in it so that it'll maybe get my attention a little bit more. Don't be doing it just to say hi though, love you, bye. But for stuff that's important that you guys see what's going on and you want to ask questions, you want me to repeat it, try to do it that way. I just moved my damn camera. I should have figured this all out before I got on here. Okay. Wait, what happened? Vinnie Politan literally Just asked why Bryan's defense don't use the DNA genealogy to test the unknown DNA profiles because they have the same access as prosecution. I don't really know if that's true. I don't really know if they have the same access because there's like warrants and stuff that got signed off on for the state to pull all their bullshit. So I don't know. But I don't know why there hasn't been a court order by now anyway to get the damn things tested. Like, if there's blood DNA or any sort of DNA at all in a case like this, like, you should have to come to conclusion and answer that. You know what? Like, treat it like an actual test. Do the testing on the DNA and come to an answer. Yeah, see exactly. Like, the FBI used a bunch of crap that the state itself doesn't even have access to. So there's that. Okay. I think I'm ready. Let's get ready. Okay. This is the order on defendant's motion to suppress genetic information. All of this was written by Judge Hippler. Introduction. Defendant is charged with 1 count of burglary and 4 counts of murder in the first degree. It is alleged that defendant entered a residence at 1122 King Road in Moscow, Idaho, in the early morning hours of November 13th, 2022, and that Maddie Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle with a knife. Now, for those of you who don't know, I'm going to have to speak YouTubese for some of these words because I'm not mainstream, so I can't get away with using real English, just in case you didn't know that. Okay. Left at the crime scene was a knife sheath from which single source male DNA was extracted. Using forensic investigative genetic genealogy, or IgG, law enforcement was able to identify defendant as a possible suspect weeks after the crime occurred. Weeks, meaning more than one. And we also know that it was almost like a month, at least according to the dates that the public has been able to see. Subsequently, law enforcement conducted a trash pull from defendant's family residence and obtained DNA tying defendant to the DNA found on the knife sheath. Defendant was subsequently arrested pursuant to a warrant and charged in this matter. Defendant asserts law enforcement violated his constitutional rights by failing to secure a warrant before conducting the IgG and trash pull. He seeks to suppress all evidence obtained through these searches, as well as all evidence obtained through subsequent warrants as fruit of the poisonous tree. The state disputes the defendant's constitutional rights were violated. Yeah, they've been saying that. But what did Judge say? What did Hippler say? Well, the evidence shows that. And twice on Sunday. Okay. That's what he said. That it shows that all those things happened. So how can you sit there in court, Hippler, and say that that's what it all shows? That's what the evidence shows, but then not allow this? How can you say that in court and then deny everything? That doesn't make sense. That's back-ass words. Completely back-ass words. A suppression hearing was held on January 23rd, 2025, during which the court received testimony from members of law enforcement and experts in IgG, each of whom the court found to be credible and reliable. That's what Fake Mallory was talking about. Okay, now there's a footnote. Specifically, the court received testimony from Detective Corporal Brett Payne, Rylan Nolan, Matthew Gammett, Daniel Helwig, and Leah Larkin. I feel like I've seen that name right there before, but I can't picture the person like I normally can. I'm not sure. I'm about to look that up in a minute. Following argument, the court took the matter under advisement. The court finds defendant has failed to demonstrate his constitutional rights were contravened by the IgG and trash pull, and therefore suppression is not warranted. Blah, blah, blah. Thank you for staying a member for a year. That's awesome. Thank you, Carrie. Yeah, this is going to be, I saw somebody say earlier that they went to go read it and were like, I'm just going to wait for you. I'm totally fine. This is how I ingest it better anyway, by talking about it out loud. 2, standard. The standard of review of a motion to suppress is bifurcated. The power to assess the credibility of witnesses, resolve factual conflicts, weigh evidence, and draw factual interferences is vested in the trial court. Oh, there's another one. 5 memberships. Thank you. That's very sweet. Congratulations to those who get it. That's awesome. Thank you. Then he cites State versus Valdez Molina from 1995. A trial court's ruling on a motion to suppress evidence combines the issue of law and fact, and the trial court's factual findings will not be overturned unless they are clearly erroneous. And then he cites State versus Conant from 2007. Thank you for the $20, Carrie. That's very sweet. That and memberships. You're awesome. And a member. You're just doing all the things, doing all of the things. When a decision on a motion to suppress is challenged, the application of constitutional principles to the facts found will be freely reviewed. And then they cite Veneroso from 2003. 3, finding of facts. Okay. Everything is denied, Tracy. Everything. What's Willie going to do? I'm going to have to scroll up and see what Willie's going to be up to. Okay, this is going to be where the information is. This is the finding of facts. This is where some crazy shit's about to probably happen. Okay. On November 13th, 2022, law enforcement found the bodies of Maddie Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin inside a residence located at 1122 King Road in Moscow, Idaho. All 4 victims died from apparent knife wounds. A K-bar knife sheath was found on a bed next to the bodies of Miss Mogen and Miss Goncalves. Law enforcement seized the knife sheath and swabbed around the button of the sheath for DNA. A sample of DNA, identified as Q1.1, was extracted from the swab by the Idaho State Police Forensics Lab and subsequently tested using standard DNA STR or short tandem repeat methods. The STR profile developed revealed that the DNA came from a single source male profile. Law enforcement uploaded the DNA profile to the CODIS database, but it resulted in no hits to known offenders. And there's the second footnote after CODIS. CODIS is the Combined DNA Index System, a national DNA database. Yeah, I actually have these 2 websites that I'm going to end up doing like a video on, and it tells you like a really... It's like in-depth but simplified explanation of how like CODIS works and what it actually is and what it like the results actually mean whenever something is actually ran through CODIS and how it stores stuff. And then it also, the other one is like the FBI CODIS information that comes with the like step-by-step instructions for how everything goes in. And then the other one is step-by-step how an STR profile is actually created. And it's like I really like how it's written. Like it was really simple and like to the point and not very, very long and super easy to understand. So we're going to go through those. We're going to go over those like pretty soon here. Let's see where I was. Okay. Subsequently, law enforcement made the decision to pursue forensic investigative genetic genealogy testing on Q1.1. Such testing begins with the generation of a large amount of raw sequencing data from the DNA sample, which is then organized into SNPs or single nucleotide polymorphisms. Using bioinformatics software, the SNPs associated with ancestry and genealogy can then be pulled out of the raw data and organized into an SNP profile that can, in turn, be uploaded to commercial genetic genealogy databases to search for a genetic match. Depending on the strength of the match, law enforcement can start building a family tree to identify potential genetic relatives of the uploaded SNP profile. These genetic genealogy databases are hosted by private companies and populated by hundreds of thousands of members of the public who voluntarily submit their own DNA and publicly share personal information to allow the database to better match them with potential genetic relatives. Notably, at all relevant times, only 2 commercial genetic genealogy databases permitted searches by law enforcement: Family Tree DNA and GEDmatch Pro. The databases MyHeritage and GEDmatch purported to disallow such searches, but that's the one that we were told that they used, right? We were totally like informed that these are the ones that they used. And whenever they talked about GEDmatch, I don't remember them saying GEDmatch Pro. That looks different. That looks different. The IgG process essentially attempts to ascertain identity through genetic associations. Unlike STR profiles, which can only reveal whether a person is genetically male or genetically female, the SNPs in their raw form have the ability to reveal a trove of personal information, including sensitive health information, such as whether the person has traits indicating an increased risk for cancer or Alzheimer's. However, IgG does not target these particular SNPs because, according to defense expert Daniel Hellwig, okay, so he was for the defense, okay, they are neither relevant nor probative nor appropriate to the identification process. In fact, gleaning medical information from SNPs is not possible for a layperson to do and would take a forensic scientist like Mr. Hellwig a lot of research. And then it goes down to footnote number 3. As defense expert Leah Larkin noted, however, it is possible for a person to upload an SNP profile to a third-party site called Prometheus, we did hear about that one, which for a fee will look for medically informative SNPs within the profile and generate a health report. There is no evidence or contention that that was done here. So that's just something that was said in passing. So then why are you even mentioning it, Hippler? The IgG was first performed by Othram Labs, a company with which the Idaho Department of Purchasing had an existing contract for such work. Othram was asked to develop an SNP profile from Q1.1, upload it to those public genealogy databases permitting law enforcement entry, and submit a preliminary report of its findings. Othram was not asked to ascertain medical information associated with Q1.1, nor is there any evidence it tested for such. Why do they keep mentioning medical testing? Why do we keep talking about medical testing all of a sudden? Or are they looking for a suspect with a certain disease or something? Like, why do they keep talking about medical testing? I don't understand why they're asking about medical stuff or talking about medical testing. Okay, well, I don't know. Law enforcement did not obtain a warrant for Othram's work. Is that because there was no results found, so they didn't have to? Is that why they didn't have to get a warrant for anything that Othram did? Because there was no results? I mean, I know, Shelly, that's my point, though. I just don't know why he's but no one's, like, ever accused them of anything like that, I guess, is what I'm saying. Or maybe they're gonna, well, I mean, somebody just mentioned HIPAA, but maybe, are they maybe using that as a way to, like, show that this isn't, like, super private information because there's no HIPAA-related stuff? Maybe that's what it is? I just don't know why he's even, like, mentioning it if it hadn't even been a thing. I don't understand that. But the whole, like, them not even getting a warrant, is it because there was no results? Because we were told that Othram could not find anything at all. The Idaho State Police delivered Q1.1 to Othram on November 22nd of 2022. Othram developed an SNP profile from Q1.1 and searched Family Tree DNA and GEDmatch Pro. And there's a fourth footnote. Matthew Gamet, the systems director for the Idaho State Police Forensics Lab, testified that Othram searched 2 databases that allowed law enforcement searches, but then named GEDmatch as one of those 2 databases searched, which does not permit law enforcement searches. He later clarified that GEDmatch has 2 databases, GEDmatch and GEDmatch Pro, only the latter of which allows law enforcement searches. Thus, given Mr. Gamet's clarification, it is apparent that Othram searched GEDmatch Pro, not GEDmatch. Okay, but you're assuming that just based on the guy explaining the difference, not him correcting his statement? So you're just assuming that they searched the right one instead of making the guy clarify that they used the right one? Yeah, right? Like, it's a total assumption if he's not claiming that after he clarified it, he then corrected his statement. Okay, now this is where it's going to get crazy. Ready? This work revealed 4 brothers of interest, all of whom were low matches to Q1.1. Now, this is a 5th footnote, and it says these brothers did not share defendant's last name. Okay, I thought that the comment I had said that 2 of them didn't share his last name. So Othram did, okay, see, this makes it more confusing. If Othram actually did get some sort of matches, how come there was no warrant to get their information? The Idaho State Police delivered the Q1.1 to Othram on 11/22, a freaking 22. Can you believe that shit? They brought it to Othram on 11/22. The profile was created, and Family Tree DNA and GEDmatch Pro assumption was searched. 4 brothers of interest. But they were low matches. So how can you be considered a brother, but it be a low match? I mean, wouldn't it be a higher if they're saying brother? I don't get it. Let's keep going. To further its family tree building, Othram asked the Idaho State Police to contact one of the identified brothers to provide a DNA sample to upload into either of the 2 databases. Despite Idaho State Police request, the contacted brother declined to provide a sample. Kohberger doesn't have a freaking brother, bro. He has 2 sisters. Remember, they got fired from their freaking jobs whenever all this happened. We've never heard anything about him having brothers. They would have to be blood. They would have to come from the dad or the mother. So unless the mom had kids and got rid of one, adopted one off or some crap like that, or the dad was just out there being funky. No. 4 brothers with low matches to Kohberger's apparent sample. Because we have to remember through all of this that Kohberger's swab did match, according to what they're claiming, the actual DNA on the knife sheath. And the defense team has never once said that it was not his. Somebody also said in the over here in the chat thing, did y'all ever hear where that weird aunt that said all the crazy stuff about like veganism and stuff apparently like tried to blame or point some blame towards like an uncle or a cousin or somebody else in the Kohberger family? Because somebody posted that on the thing. It's just too wild. So who was I want to know who this person was that was contacted too. That's crazy. 20 memberships. Thank you, Lenore. That's very sweet. Congratulations to those that are going to grab those. That's awesome. Thank you. Okay. I'm going to read this again. The Idaho State Police delivered the Q1.1 to Othram on November 22nd of 22. Othram developed an SMP profile from Q1.1 and searched Family Tree DNA and GEDmatch Pro. This work revealed 4 brothers of interest, all of whom were low matches to Q1.1. To further its family tree building, Othram asked the Idaho State Police to contact one of the identified brothers to provide a DNA sample to upload into either of the two databases. Despite Idaho State Police request, the contacted brother declined to provide a sample. Okay, so maybe it's not a brother. It would have to be like a cousin. Because there's no way that brothers would have low matches. It would be high. See, and as soon as I said cousin, I look over and RV Keeper Roland said, remember the cousin who did the rap song? And Ample Spark said, wasn't his cousin previously arrested for something? I don't know. Yeah, they would have to be brothers that are cousins to Kohberger. That makes more sense than him having some siblings out there that he didn't know about. It would have to be cousins or uncles or somebody with a low IQ match. IQ. A low DNA match to him. So do we know of 4 brothers together in that family that are related distantly to Kohberger? I mean, I did watch one where these twins, they were identical twins. Their DNA was 99.5% accurately, like genetically the same. And one of them apparently came from Poland and the other one didn't come anywhere from near Poland. And they had a whole bunch of stuff about their stuff that didn't even make any sense. Everyone's saying the dad sign. In Nevada. That's interesting considering a lot of things. Okay. So so it had to have been, I'm looking at these dates right here. This is November 22nd and this is December the 10th. So somewhere between then they would have been having to like contact that person. And that's the only one that they identified. One of the identified brothers. So they knew of more than one of their identities. Obviously, they knew like all of their identities at that point, and they only contacted one to provide a sample. I wonder if they were able to get another one. On December 10th, 2022, members of law enforcement, including the FBI, had a meeting to discuss Othram's work. As a result, a decision was made to turn the IGG work over to the FBI. Okay, so Othram technically did come up with information. If Othram came up with the identities of the brothers with a low match to the sample, where's that work? Or did the FBI just basically steal that information? And that's why there's only stuff from the FBI being talked about. And we've been being told this entire time that Othram couldn't find anything. Because that's what we were told this whole time, that Othram didn't find anything. This sounds like they found something. Okay. That same day, so on December the 10th, Othram was instructed to stop work and turn over its S&P profile and search results to the Idaho State Police. Othram did so along with a preliminary report of its findings. The preliminary report did not contain any medical information associated with the S&P profile. I don't know, why do they keep saying that? I don't know why they keep saying that. The Idaho State Police then turned over the information to the feds, including the information from Othram. So Othram gave ISP the report that has the 4 brothers' information that have a low match to Kohberger, and then handed everything to the feds. Shouldn't they have to have a warrant? If they have to get a warrant to get information out of their own lab, shouldn't they have to have a warrant to use anything that actually came from Othram? Sounds to me like there was information that there should have been a warrant for. The Idaho State Police then turned the information over to the FBI, which was able to use Othram's profile to develop a significantly larger S&P profile. The FBI uploaded the larger S&P profile to multiple genetic genealogy databases, including GEDmatch and MyHeritage, the two that you're not supposed to use, which purport to disallow law enforcement searches. At the time, the FBI had an interim policy issued by the United States Department of Justice related to IgG analysis and searches by its agencies. Example or Exhibit D19. On the one hand, the interim policy required that investigative agencies conduct IgG searches in genetic genealogy databases, permitting law enforcement use. However, on the other hand, the interim policy also stated it was intended only as internal guidance and did not impose any legal restrictions on investigative agencies, noting the interim policy is not intended to, does not, and may not be relied upon to create any substantive or procedural rights or benefits enforceable at law or in equity by any party against the United States or its departments, agencies, entities, officers, employees, agents, or any other person in any matter, civil or criminal. This interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. So this policy just lets them do whatever they want. Agencies conduct IgG searches in genetic genealogy databases, permitting. Basically, they can do whatever they want, but they're not allowed to use it for anything. It's just like a guide. That doesn't even make sense. It's stupid as shit. Stupid as shit. Okay. From the information it acquired through the database search, the FBI was able to build a family tree and arrive at a potential match. And that's where we have footnote 6. There is no evidence that in developing the larger S&P profile, the FBI targeted or even had access to those S&Ps that can reveal sensitive health information. They're going to have to explain to me why they keep talking about that, because nobody tried to say that nobody tried to match cancer types or if you got flu A or flu B. Like, nobody said any of those things. So I just don't understand really like why they keep talking about the medical stuff, because this has only been like, I understand that like DNA, blood, it's all like medical in the end, but it's all personal information. Hopefully they get to why they keep talking about that. Okay. On December 19th, this is a date that we were aware of, the FBI provided defendant's name to Idaho law enforcement as a possible source of the DNA. So they didn't hand over a tree. They handed over Kohberger's name directly, the feds. The FBI instructed that the identification of defendant as a person of interest was to be considered solely as a tip. No. The FBI was literally sharing office space with the local police department. We heard from both Mowry and Payne that the homeboys were sitting next to him. They were touching elbows in the Moscow Police Department up on that second floor. Okay? It's not a tip whenever you have been actively getting warrants. Like, the cops are the ones filing for the search warrants, and yo asses are the ones getting the responses. So how is it a tip? You are actively investigating this case. It's not a tip. You are working this case. I just don't get it. So no warrant for Othram's work that came up with the original low matches, but still 4 of them, and enough to where they were reached out to and spoken to and asked to. And see, I said something. I said it'd be really kind of weird and make no sense if the defense was trying to claim that his DNA was illegally obtained and all these backdoors and loopholes were created, if in the long run they ended up just like getting a family member to run their DNA and put it into a program, because that happens all the time. That happens all of the time. So I don't know. This is wild to me. Because now we're learning that Othram, and the judge is hearing this. Like, how can the judge be the one writing this and not being like, oh, this is like a little bit strange, because both the feds and Othram had information. Both the feds and Othram created information that is submitted reports and analysis and opinions and evidence in this case. And neither one of them had a warrant. How is that not a problem? Is Hippler related to Gull in any way? They're both kind of funky looking, like old, leathery. They look like their souls have been just like wrenched from their body. Are they related? Starting to wonder. Yeah, me too. I'm very disturbed. I don't know how this fool can sit in court and literally say to the state, not just the state, but the special prosecutor that came in from the state, okay? How can he sit there and say deny? Well, that's what the evidence is showing when it comes to all these rules that were broken. He said that shit, bro. He said that shit. I don't get it. Okay, you ready? No warrant was obtained for the FBI's work, and subsequent warrant applications did not include the IgG results to inform probable cause. You're a damn liar. I almost said the F word. It's in Don Daniel's search warrant, sir. Like, do I need to pull it up? Raise your hand if you ain't seen it. Oh, yes. I have got my pirate cup and my Kroger waters because I'm going to be here for some hours. Yes, exactly. He just ruled against his own words. We all heard it. He ruled against his own words. You hypocritical shithead. That's what he is. And this is also a lie. Like, this is a damn lie. Judge Hippler, you are an effing freaking liar. Just because Don Daniels is in Washington and is a WSU police officer and she's the one that used this information doesn't mean that it wasn't used. You cannot unring the bell. You know that as a judge. Your ass knows that. You cannot unring that damn bell. You cannot have a document that has a narrative written by an officer who executed a search, not just of Kohberger's apartment, but the storage locker and his office, and asked for the magistrate judge to forget about the IgG match. Yeah, I know I told you about it, and I know it's written in here in black and white and triple copied, and you have to sign everything, and it's going to be filed and permanent and forever, but forget I said it. That happened. That happened. Oh, I guess Andy. Oh, that's you and you. I'm going to give it to you. I'm going to give it to you right now. Is it going to open right up to it? Probably, because we were just on this. Actually, it did, because this is Blaker's copy of the PCA that Don Daniels attached to her ish. Okay. Let's see. This is the search warrant right here. Keep going. This was written by Don Daniels. I need to get to the bottom. Right here. Oh, 118, baby. Let me go ahead and just put this little link in here. For those of you who need to see it for yourself, the Judge Hippler is an idiot and doesn't know shit about his own damn case. Okay. Look at this right here. This was written by Don Daniels. Here is her information all over this thing where her magistrate judge signed it and all of the things. Okay. Supplemental disclosure regarding the DNA test. All right. Make this as big as I can for those who really need to see it. Ready? I have been informed by Detective J.R. Talbot of the Idaho State Police That on November 13th, 2022, a sheath was recovered at the King Road residence under or next to the body of Maddie Mogen. The Idaho State Crime Lab obtained a male DNA profile, suspect profile from the sheath. This is also referred to in Sergeant Blaker's sworn statement, which is Exhibit A. On December 27th of 2022, law enforcement officers in Pennsylvania recovered trash that originated from the Kohberger residence. That trash was sent to the Idaho State Crime Lab for testing. On December 28th of 22, the Idaho State Lab reported that a DNA profile was obtained from the trash. It was compared to the suspect DNA profile. The lab personnel concluded that the source of the trash DNA profile was a male and was not being excluded as the biological father of the source of the suspect profile. At least 99.9998% of the male population would be expected to be excluded from the possibility of being the biological father of the source of the suspect. This information is being provided to the court pursuant to my duty and obligation to be fully candid with the court. I do not believe this information is exculpatory for the suspect. However, if the court believes it is exculpatory, then the court should consider this supplemental disclosure in its evaluation of the existence of probable cause or lack thereof. Now, are you ready, Andy? Are you ready? But I am specifically asking for the court to not consider this supplemental disclosure as evidence supporting the existence of probable cause. The reason for this request is that if the DNA test results are held inadmissible at some point, such a ruling will not impact the finding of probable cause for this warrant, so long as this court is satisfied as to probable cause regardless of the DNA test results. There it is. But I can, Tara, and I will, because I just gave you the proof. Okay, it's right there. He's wrong. And he ruled against himself. So sorry, whatever. Yes, I can, because I just showed you the proof. He's an idiot. And he's lying in his own order. He's lying in his own order. It's plain and simple. He cannot say that whenever the information is in the order itself, and then the officer has to come back in and be like, but don't consider it, please. Just don't consider it. I know it's there. But just forget about it. Please forget that it was even mentioned. Full of shit. Full of shit. This is sick. This is sick. No warrants for all of the information that where it came from. Daniel's also misplacing DNA information, from all the DNA that had no match. And, she didn't do nothing with it for 10 days, didn't tell Ann Taylor shit about it. This is ridiculous. This is stupid. Absolutely stupid. Okay. Let's continue. As the investigation ensued, law enforcement discovered that defendant had driven from Pullman, Washington to its parents' home in a gated community in Monroe County, Pennsylvania. At the time, Monroe County's municipal waste ordinance required homeowners to dispose of their garbage by placing it out for collection or delivering it directly to a licensed waste hauler. Only an authorized trash collector could collect garbage left out for collection. Law enforcement decided to conduct a warrantless trash pull. More warrantless stuff? From the Kohberger residence, which, we were kind of told that they got into a conversation with the garbage company. Didn't they say that? I know they talked about this, but I can't remember if they said that there was no warrant whatsoever. They made it sound like they talked to the trash company. The trash company went in, picked up the trash cans, and then they met up with them after the fact. Okay. Law enforcement decided to conduct a warrantless trash pull from the Kohberger residence. Arrangements were made with the local trash collector to isolate and turn over the Kohberger's garbage to law enforcement for testing. Articles of trash were retrieved and sent to the Idaho State Police Forensics Lab to conduct standard DNA testing. A DNA profile developed from one article of trash was determined to be from the biological father of the source of Q1.1. Another article of trash revealed a mixture of male and female DNA. According to defendant's expert Gary Schulter, the male DNA from the mixture was consistent with the Q1.1 profile. So they not only pulled his dad's DNA from the trash, but he also pulled Kohberger's direct DNA from the trash? Why didn't they just say that? I don't understand that. Okay. And then it talks about December 19th, 2024. There's a footnote. Because the DNA was a mixture, the Idaho State Police Forensics Lab standards and protocols prevented it from doing a manual comparison of the male DNA to Q1.1. So the state itself couldn't do the testing, but the defense is having people test stuff. Because if they're saying right here that ISP lab standards and protocols would not allow them to do a manual comparison of the male DNA, then the only way that they can say that the male DNA from the mixture was consistent with Q1.1 is because the defense does have people testing DNA. So have they tested the unknowns? Have they tested the unknowns? They got somebody doing something. Importantly, defendant has not claimed ownership or knowledge of the knife sheath from which Q1.1 was taken. So you're going to sit there and tell me that you are pulling trash from your suspect's family's trash can, and there's a mixture of, there's like one sample of blood or DNA somehow that has both a male and a female on it, and you're not allowed to test that whatsoever. But you want us to believe that this knife sheath had nothing on it besides a speck of nothing on the button when it's laying under a body. I'm sorry, but that doesn't make no sense. No, it sounds like it's the opposite. It sounds like the one that was a match to being like the dad to the sample was the first one. And then the second one was a male and female's DNA mixed together. And according to the defense expert, who must have tested it if ISP's protocols wouldn't allow them to test it, that sample matched Bryan. But I mean, duh, it's his freaking parents' house. Oh, but they didn't actually compare it to Bryan's at this point. Okay, so whenever they tested the mixture of male and female DNA, all they knew was that it perfectly matched their original knife sheath profile, and at that point they hadn't taken a swab yet. That's still crazy to me that the defense is the one testing this stuff, but ISP couldn't. I just don't see how there wasn't any blood or anything on the knife sheet. That's my biggest point. Is all this talk about mixtures and contamination? You're trying to tell me that this knife sheath was squeaky clean, minus this little bitty speck of nothing? Okay, after obtaining a search warrant, law enforcement collected DNA from a buccal swab obtained from defendant. A traditional STR DNA comparison was done between the Q1.1 profile and defendant's DNA. The comparison showed a statistical match. Specifically, defendant was 5.37 octillion times more likely to be the source of the Q1.1 profile than an unrelated individual randomly selected from the general population. Defendant was subsequently charged in this case. I love how they give you a statistical number that doesn't even match the amount of human beings on the planet. Why couldn't they just give us something a bit more realistic? I mean, again, they're not claiming that it's not his DNA. So I can't argue that. I don't have an argument for that. Yeah, saturation. You're trying to sit there and tell me that it didn't have nothing besides this? I don't see how. I really just don't. trying to get this bigger. There we go. Okay. Okay. Conclusions of law. The Fourth Amendment to the United States Constitution protects the rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. U.S. Constitution amendments. I honestly am not good with Roman numerals. And there's an 8 footnote. The Idaho Constitution offers protection for unlawful search and seizures as well, which defendant cites as an additional basis for his motion. Idaho Constitution, Article 1, Section 17. However, with the exception of the trash pull argument set forth of his opening memorandum, defendant does not explain how Idaho's Constitution provides greater protection than the Fourth Amendment or otherwise explain how the application of the Donato factors support a divergence from Fourth Amendment law. Did he just like continue a footnote? That's wild. Okay. Observing that where greater protection has been afforded under Idaho's Constitution, it has been based on the uniqueness of our state, our Constitution, and our long-standing jurisprudence. Thus, the court's analysis of his arguments, with the exception of the trash pull, is limited to Fourth Amendment law. Well, doesn't that like trump state stuff regardless anyway? Okay. In seeking suppression of evidence based on a warrantless search, which seems to be like all of them, warrantless Othram, warrantless feds, warrantless trash. That's already 3. The defendant bears the evidentiary burden to show that he had a legitimate expectation of privacy in the item or place searched. This involves a 2-part inquiry. 1, did the defendant have a subjective expectation of privacy in the object of the challenged search? And 2, is society willing to recognize that expectation as reasonable? The former is a question of fact, the latter a question of law. When a defendant makes such a showing, the burden will shift to the state to show an exception to the warrant requirement exists or that the search was reasonable under the circumstances. And it cites State versus Rebo from 2021, where here defendant challenges 3 allegedly unlawful DNA-related searches: the development of an S&P profile from Q1.1, the trash pull from the Kohberger residence and subsequent DNA testing thereon, and the search of the commercial genetic databases using the S&P profile. He seeks to suppress not only the genetic information obtained by law enforcement, but all other evidence obtained as a result of the alleged illegality. And then there's a 10th footnote. Defendant asserts that all evidence collected after he was identified through the FBI's IgG search, i.e. December 19, 2022, must be suppressed as fruit of the poisonous tree. I know, we know that. We didn't need a footnote for that. We knew that. In response, the state argues defendant has not yet met his threshold burden of demonstrating that a constitutional violation occurred with regard to any of the 3 searches. The state is correct. How can you do this? How can you do this? I mean, I don't really care how honestly you feel about me calling him stupid. This is stupid. When I have video proof of you literally admitting that all of the evidence proves this was an actual thing, and then you write an order and file that order going against the words that came out of your own face, I'm going to call him stupid. With an extra id, okay? That's just what's going to happen. You literally just got caught slipping. You said something on a live. We all heard you say it. And now you backtracked while telling us that there was no warrants for anything that actually put this man where he is. And yet none of this is proving that he is guilty. None of it. So there's that. Okay. Let's see now. The state's not correct. Again, in my opinion. No warrant for Othram, no warrant for the feds. They are knowingly, purposely, and boastingly using illegal databases that they are not supposed to be using. The judge is even telling us in the order that he knows that they use databases that they're not supposed to be using. And they used every little bit of that information to get to Bryan. They cannot say that Othram came up with nothing, because Othram came up with 4 names. 4. And then they gave all that information over to ISP. They made us believe, that the feds walked into Othram like they went to Houston, bro, with their badges just a shining, and took everything from Othram and took it back to wherever the hell they went, wherever they did all this stuff at. That's what they were making us believe. No, Othram found information, gave it back to ISP. Then ISP turned around and gave it to the feds, including the report that had the information from Othram. And then gave Moscow not a family tree to then reverse engineer and try to whittle away names until you got to the end. No. Nay. They gave him right over to Moscow. His exact name. Not a tree. The name. So much different than the original story. So much different. How wild. Okay. A. Defendant has not yet established a Fourth Amendment violation with regard to the development of the S&P profile. Defendant first asserts that the extraction, you know what? I can barely see. I am already I can feel my words not coming out the way that they need to come out. And I know it's because I don't have my glasses on. And I don't have my glasses on because Xana likes to get up here and bat my stuff around. And earlier, she got into my Cool Whip because she likes to try to eat my Cool Whip off the top of my coffee cup. And she got some Cool Whip on my glasses. So now I guess I gotta clean them. My astigmatism is messing with me bad. And I want to be able to read all this stuff. So hopefully this helps a little bit. Not really. Holy crap. Let me try this way. Yeah, I love her too, but she's a menace. She runs a whole damn house now. We kept her away from running all over the house for a little while because she was super hella injured. And we didn't know if she was going to be able to keep up with the dogs. But now she's like a big bully. She goes and bats them to try to get them to chase her. And now she makes Lily, because we adopted 2 border collie siblings, and Lily was like the runt and Boomer's like ginormous. And she wants to cuddle with Boomer all the time, but then she'll go and she'll bat at Lily to try to get her to chase her everywhere. She's just crazy. So that's why I had Cool Up on my glasses. Okay. I think I can see a little bit better now. Yeah, this is wild. Okay. Defendant first asserts that the extraction and testing of DNA from the sheath to develop the S&P profile constituted an unreasonable search mandating suppression, noting recent advances that have made DNA capable of revealing prolific and sensitive information, as well as the fact that humans continually shed DNA into the environment. Exactly. Defendant asked the court to find that he had a reasonable expectation of privacy in his DNA, the testing of which through S&P methods required a warrant, despite the fact that law enforcement was lawfully in possession of the object containing the DNA, i.e., the sheath. He further posits that his privacy interest is not subject to the doctrine of abandonment because the shedding of DNA into the environment is not a voluntary or knowing act. I mean, yeah, we all I had to go to the store today because I needed cream cheese for my sushi, and we were out of half and half for our coffee. And I know that I probably picked up 50 people's DNA and brought it home with me because Walmart's a cesspool. So there's that. So I guess they're not wrong. Not wrong at all. Okay. The state denies that the testing of the DNA from the sheath was a search, pointing out the DNA was lawfully seized evidence from the scene of the crime. Yeah, I haven't seen you in a while. Congratulations for being a member. You've joined the smart ones. Joined the crew. The state further contends defendant has not demonstrated he had a reasonable expectation of privacy in his DNA because he abandoned it and or because he has not shown the existence of a reasonable privacy interest society is willing to recognize. This is a matter of first impression in Idaho. However, applying well-settled principles of Fourth Amendment law, the courts find no constitutional violation. First, defendant abandoned any privacy interest in his DNA by disclaiming knowledge or ownership of the sheath from which the DNA was extracted. Second, even if no such abandonment occurred, there is no reasonable expectation of privacy in DNA found at a crime scene, which is subsequently analyzed to identify an unknown suspect. I mean, I honestly don't agree. I mean, I don't disagree with that fact. Because I know that, like, if something happened to me or somebody that I care about or just like anybody, you want every bit of DNA tested. But you don't want, just because somebody's DNA is found at a scene, to be the only reason why somebody ends up in prison for the rest of their life or pew-pewed by a bunch of strangers. Right? Exactly. Usually the DNA will lead to more evidence, and that's not happening. That's not happening. That's my problem. So far, they have not proven anything else. Like, somebody could have literally came behind me today at Walmart and used the pin pad, where I just used the pin pad and touched the little thingy where the baggies are, the way that I touched the little thingy where the baggies are, or went and used my Walmart cart after I put it back in the thing and have my hand DNA all over their stuff, and then go do something crazy. Or let's say that they used my basket after I was done with my basket, and then they met up with somebody in the store. Hey, seen you in a minute. You know how that happens normally whenever you're in a place where you know people. I can't relate. And they shake somebody's hand. Now my DNA from the cart is now on this other person that never even touched that damn cart. And now what if they go do something crazy? That's not a joke. Like, that's Lucas Anderson. Homeboy shared an ambulance ride. Walmart is always involved. Always involved. Lucas Anderson was in an ambulance prior to the body of a victim being in an ambulance. And even though this person was like already deceased whenever they were put in the ambulance, somehow or another, Lucas Anderson's freaking DNA got under this man's fingernails. Under this man's fingernails. Okay? DNA under fingernails usually means somebody fought. Somebody tried to get away. No, Lucas Anderson even admitted to the crime because he gets so blackout drunk and passes out all the time. He thought he might have actually done it and forgot. And he didn't do nothing. He didn't do nothing. This is wild. I'm going to literally start wearing like head to toe gear everywhere, just so I don't have to like worry about picking up anybody else's DNA and nobody taking my DNA and taking it anywhere. Because at this point, you got no proof that this person was at the crime scene. No proof. All you've got is something that could have been picked up in passing. And you, no warrants. No warrants. No warrants, no notes, no proof, no original profile so that anything can be compared because they deleted it. So do we only have like Othram's profile that was handed back over to ISP is what it sounds like. So I wonder if they've done anything with the stuff that Othram gave them when it comes to the defense trying to make any comparisons to stuff. Just how wild. Okay. 1, defendant cannot establish a subjection expectation of privacy in the DNA found on the sheath due to abandonment. it is well settled that a person who voluntarily abandons property prior to a search cannot be said to possess the requisite privacy interest under the Fourth Amendment. And they are citing Stark versus State from 2023. When one abandons property, there can be nothing unlawful in the government's appropriation of such abandoned property. And they quote Abel versus United States from 1960. In the Fourth Amendment context, abandonment occurs through words, acts, and other objective facts indicating that the defendant voluntarily discarded, left behind, or otherwise relinquished his or her interest in his or her property. Disclaiming ownership or knowledge of an item constitutes abandonment. State versus Melling from 2016. In Melling, for example, officers reported to the defendant's house after reports of a fight. Well, it's interesting they're using this citation, I'm just going to say. While officers were speaking to the defendant, his girlfriend gave officers a lockbox that she said belonged to the defendant. The defendant told officers he had never seen the box before, had no idea who it belonged to, that nothing in the box was his, and that he did not know what was inside of it. The court held that by disclaiming ownership of the lockbox and its contents, the defendant abandoned any privacy interest therein. Okay, so now I understand why they're claiming that. Okay, so Bryan's team has never, ever, ever stated that the DNA wasn't his. They've never tried to deny the match. Like literally ever. Never tried to deny the match. But he is not claiming the knife sheath. So they're saying that unless he can claim that it's actually his property and that somebody else placed it there, that he wasn't the one that put it there, like he would have to say, yeah, that's my knife sheath and I didn't put it there, I guess, for it to count. I think that's what they're saying here. Moreover, a person need not specifically disclaim knowledge or ownership of the contents of a container to result in abandonment thereof. It is sufficient to disclaim knowledge or ownership of the container itself. See, yeah, I think that's what they're talking about. Like he would have to be like, yeah, that's my knife sheath. That's why my DNA is on it, but I didn't put it there. And here's the proof. But because he's saying it is my DNA, but it's not my knife sheath and I still didn't put it there and I don't know how it got there. I think that's what's happening here. So that's how they're telling the difference. Okay. State versus Zaitsva from 2000. By denying ownership of the bag in response to the officer's inquiry prior to the search, the defendant essentially relinquished or abandoned any privacy interest in the contents of the bag. Okay, and we hear that all the time. Like whenever people get pulled over, I think even in the Emma Bailey stuff that we watched, whenever she got pulled over for DUI or whatever, there was stuff in the vehicle and she kept like denying ownership of certain things. Like we see it all the time. We see it a lot, so that makes sense. Okay. There is no dispute here that defendant has not claimed any knowledge or ownership of the sheath, thus resulting in its abandonment. Defendant concedes as much, but argues that abandonment of any privacy interest in the sheath did not result in the abandonment of the DNA found on the sheath. But they also can't say that just because somebody doesn't claim something, that means that they are abandoning the thing. Because in order for you to abandon something, it has to belong to you to begin with. That's how I understand that. Like it has to actually like have some sort of like connection to you to begin with for it to be considered abandoned. That's how I'm interpreting that in my brain anyway. Okay. He contends that unlike the voluntary act leaving the sheath, leaving DNA on the sheath is not voluntary because a person has no way to know that their DNA has been left behind. DNA, he points out, is shed everywhere. Humans have no ability to keep their biological material from the environment. Yeah, we're nasty. We just spread ourselves everywhere. We're gross. Consequently, he reasons, a finding that the DNA on the sheath was abandoned would mean that a person voluntarily gives up privacy in their entire genetic makeup every time they interact with the public. I mean, I understand why he's saying that, because like we always talk about, we're leaving our stuff everywhere. In support of his argument, defendant relies exclusively on a concurring opinion in State versus Carbo, which is factually similar to this case. And this one's from 2024, so last year. In Carbo, the evidence at issue was, I don't know if I can say that on YouTube. I don't know if I can say that on YouTube. So I don't say it in the Delphi case either. The liquid stuff that only a guy can create, okay, was deposited inside the deceased crime scene and skin scrapings from underneath her fingernails. That's this case that they're talking about, Carbo, not the Idaho case. In an attempt to identify the suspect, law enforcement contracted with a lab to conduct a genetic analysis of the DNA extracted from this evidence. Like here, the lab created a S&P profile from the DNA and utilized commercial genealogical databases to determine a potential source. It also generated a report that provided information about the suspect's physical traits and ancestral origin. This information ultimately led law enforcement to the defendant. Law enforcement then created a DNA profile from trash discarded by the defendant, which matched the DNA profile from the crime scene. It is a lot like it. Jesus. Subsequently, the defendant provided a voluntary DNA sample, which matched the profile from the crime scene and the garbage. Yeah, those are a lot alike. But the match was not voluntary. That was from trash and then a search warrant for the swab. The defendant moved to suppress evidence of his genetic information left behind at the crime scene. He argued, as defendant does here, that although he may have abandoned his privacy interest in his liquid and skin cells, it did not equate to an abandonment of the vast trove of genetic information that biological material contained. Making short work of this argument, the Minnesota Supreme Court found that by voluntarily leaving his stuff and skin at the crime scene, he abandoned any subjective privacy interest in his genetic information contained therein. In the concurring opinion relied upon by defendant, one justice disagreed with the majority on this issue because, given the sensitive genetic information revealed by S&P testing, he would have required a warrant before allowing such testing. He further opined that the concept of abandonment, which requires voluntariness, is an ill fit for genetic information because it is virtually impossible for humans to prevent leaving personal genetic information everywhere they go. Yeah. Yep. Sounds like this point he's just kind of repeating himself. To this end, I know that's a word for analogy, and analogized DNA to the cell phone site location information, or CSLI, at issue in Carpenter versus United States from 2018, where the United States Supreme Court reasoned that CSLI is not voluntarily exposed, given that virtually any activity on a phone, which is essential to participate in modern life, will leave a trail of location data. Yeah, you can't do anything. Like literally, Google reads your thoughts. Let's be for real. He observed there are no similar safeguards for DNA, thus rendering the case against abandonment all the more clear. When we venture into public spaces, we simply cannot help but shed our DNA. Yeah, exactly. The majority, however, pointed out that the inquiry as to whether the defendant abandoned his subjective privacy interest looks to his specific action. When viewed in this way, the majority found Justice Procacani's logic inept, given that the defendant's DNA was not collected from a shed skin cell or a flake of dandruff, nor was it a mere consequence of the defendant venturing into the public sphere. It was collected from that stuff he voluntarily left inside the victim, and skin cells he voluntarily left under her fingernails. I mean, I would say that that's probably not the same thing. They cannot really honestly sit here and compare something that takes a very, very, very intentional act, okay, to leave behind, whether with another person or by yourself, okay? They cannot compare leaving something like the male liquid behind to something like touch DNA. They cannot compare the two. So while the man seeds, that's what I'm going to call them, man seeds, they cannot compare the two. They cannot. Even though parts of the sequencing and patterns of this case is similar, they cannot compare that. Just the fact that they're trying to compare something like that to touch DNA is so wild to me. Okay. Okay. I saw this guy's last name and I was like, did I just read that part? Okay. Defendant argues that Justice Procaccini's case against abandonment is particularly appropriate here. Defendant argues the biological material left on the sheath was not blood or man seeds or some bodily fluid that the Carbo court found could be voluntarily left behind. Instead, he argues it was more likely shed cells, which humans cannot help but discard. I mean, yeah, huge difference. You cannot compare the two. Yeah, apples to oranges. Like, this judge is taking back his own words and then making comparisons to things that you can't compare. Okay. However, as the state points out, there is nothing that distinguishes man seeds voluntarily left at a crime scene from the sheath. Both were abandoned vehicles carrying DNA. No, one is DNA. What you mean? One is DNA. Not a vehicle for DNA. It is literally one half of what DNA becomes. What do you mean? Two completely different things. I cannot believe he just called that a vehicle. No, it is DNA. Stated another way, the man seeds in Carbo and the sheath were both containers of DNA. I know he's not. He's little spermies are not vehicles for DNA. They literally are half of what DNA is. This guy is whack. This guy is whack-a-doodle. Vehicles. No, the knife sheath is a vehicle. Okay. Now, if there would have been like a rubber with the stuff inside of it, then they could use that as a comparison. Knife sheath to rubber, but not knife sheath to actual man seed. I'm sorry, but you're not proving your point here, Hippler man. You're not proving your point here, broski. And I'm no little dummy. You're not making a point. Nope. You need to like get some biology lessons or something so that you can understand the difference here. Exactly. They're actually future people. Let's be for real. They're actually abandoned future people. It's just wild. I can't believe he's saying this. The male body part would be the vehicle if we want to get technical. And unless somebody cuts it off and leaves it there, you can't use that comparison either. Sorry for the guys who just had to listen to that and probably had some phantom pains, but that's just the truth here. His comparisons are whack. Like, I'm impressed by how ridiculous this is. Let's be serious. As discussed, disclaiming ownership or knowledge of a container results in abandonment of a privacy interest in its contents. Zayatseva supra. Thus, by effectively disclaiming knowledge or ownership of the sheath, defendant necessarily abandons any privacy interest in the DNA it contains. Indeed, Carbo is not an anomaly in finding abandonment. Huge difference. That guy is full of it. Your male stuff doesn't end up anywhere unless you put it there or somebody's really, 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 really dedicated to screwing you over. Like, let's be serious here. Courts uniformly hold that a person abandons any privacy interest in their DNA for purposes of the Fourth Amendment when they abandon property that contains their DNA. And we have an 11th footnote that's long as hell. Long as hell. People versus Sterling from 2008. Once defendant drank from the milk carton, which was thereafter lawfully obtained by police, he no longer retained any expectation of privacy in the discarded DNA. McHurley versus State from 2022. Reconsideration in Bonk, I can never say those Latin words, denied. Petition for discretionary review refused. Holding defendant did not maintain a right to privacy in his DNA evidence obtained from the abandoned cup. And then Love Chick versus Commonwealth from 2020 in Virginia. When appellant abandoned the items that carried his DNA, he not only relinquished any objectively reasonable right to privacy in those items, but also any such right to privacy in the DNA profile developed from those items to identify him. That's wild. So is that the excuse that they're going to use for why the feds got rid of the DNA profile, because he didn't have any right, like, at all to, like, know anything about it? Okay. United States versus Hicks from 2020. Defendant abandoned the cigarette butt containing his DNA sample, and in doing so, surrendered any expectation of privacy he had in the DNA profile that could be extracted from the sample. State versus Athen from 2007. Holding defendant abandoned DNA when he sent the envelope in the mail because the envelope and the saliva contained on it becomes the property of the recipient. I don't want your spit. I'm so glad I don't do postal mail. Jesus, gross. We used to send our spit to people, bro. That just really hit me in the head. We used to literally lick sticky, weird Elmer's glue boo-boo on the back of an envelope and then put it in the mail and send our spit to people. We did that, guys. We did that as a human race. We did that and thought it was fine. That's wild to me. I'm kind of done with this footnote. Let's go back to the actual document now. Where is that little 11? Right here. Okay. In State versus Burns, for example, law enforcement extracted DNA from a blood-stained dress of a victim and created a genetic profile, which was run through genetic genealogy. The defendant was identified as a suspect through this process. Officers then followed him to a restaurant and collected a straw that suspect deposited in the trash. Testing of the DNA on the straw indicated that the DNA extracted from the dress could be the defendant's. A subsequent test confirmed. Okay. The defendant did not move to suppress the extraction and analysis of his DNA from the bloodstained dress, but he did unsuccessfully seek suppression of the DNA extracted from the straw. On appeal, the court had little difficulty finding that any privacy interest he had in his DNA profile developed from the straw was abandoned. First, by failing to make any effort to preserve the straw as private, he relinquished any subjective privacy interest therein. Second, even if he retained a subjective privacy interest, it was not one society would recognize as reasonable, considering he voluntarily left the straw behind in the restaurant. Further, the court rejected the defendant's attempt to distinguish the DNA on the straw from the straw itself, finding no practical difference between the two. By abandoning the straw, he also abandoned any DNA on the straw. Okay, but you also have his DNA on a bloody dress. This guy, this person that they're talking about. I don't think he needs to be comparing this case to this either, because cool, you had DNA on a straw, but then you were able to go in and take blood off of a dress. And that's like serious. Yeah, you really can't compare these because you haven't told us that there was any other DNA of Bryan's literally anywhere but on this knife sheath. And until you change that, you don't have an argument here. The Burns court additionally rejected the argument defendant makes here that DNA cannot be voluntarily abandoned due to involuntary shedding. In doing so, the court aptly there's that word. Analogized. That can't be how that's said. Analogized. DNA shed to fingerprints, something individuals also unconsciously and continually shed. That's true too. First, the court observed, you literally, again, like say you're going to go to a store and they don't have like a regular old handle, or you have to catch the door because somebody's holding it open for you. I mean, I've put my hands on the glass or on the metal like frame of the door and left my little fingerprints. Like all the time. I'm getting some gloves. I'm getting gloves. I'm going to have to get some gloves. First, the court observed all the different ways a person can shed DNA is irrelevant for Fourth Amendment purposes. What is relevant is the DNA left on the particular item the defendant abandoned, i.e. the straw, or here, the sheath. Second, the court noted that DNA shed is no different than latent fingerprints. Like DNA, latent fingerprints are left, typically without volition, everywhere humans go. Yeah. Like DNA, they are powerful means of individual identification, not visible to the human eye, and must be developed through the use of specialized technology. And this is a quote from Novel Features of Considerable Biological Interest, the Fourth Amendment and the Admissibility of Abandoned DNA Evidence from 2019. The court concluded that because the testing of latent fingerprints does not raise Fourth Amendment concerns, neither should DNA collected and tested from an abandoned item. We'll see, there's a difference. There's a ginormous difference. It's really difficult for some layperson to transfer fingerprints to another location. Like if they were to say that Bryan Kohberger's freaking fingerprints were at the crime scene, we'd probably be singing a completely different tune. Let's be serious. Let's be for real. But they're not doing that. There's a huge difference between somebody being somewhere and doing normal things and leaving a latent fingerprint. And like I probably just flicked like 4 people's DNA off my jacket now. There's a difference. Yeah, fingerprints means the person would have to have been in the vicinity, arm's length, enough to touch something. Cannot compare the two. Cannot compare the two. Okay. The court finds the analysis in Burns compelling. Well, I don't. And consistent with Fourth Amendment law. The court recognizes that a distinction can be drawn given the fact that Burns, there was no question that the defendant abandoned the straw, and here, defendant argues it cannot be conclusively stated that he abandoned the sheath. It can't, because you have to prove ownership. You have to prove that it was his. Like, you can't say that you abandoned something unless it was yours to begin with. I mean, it doesn't even have to be yours. It would have to have been in your possession, period. You could have stole it from somebody. You could have stole it from the store. But you would still have to prove that it was in your possession, and then you relinquished that possession of it in some way, shape, or form. Like, you can't abandon something that you never had in the first place. However, as the state notes, this distinction does not preclude a finding of abandonment for 2 reasons. First, as discussed, abandonment does not occur solely by discarding an item. It also occurs by disclaiming ownership or knowledge or otherwise relinquishing an interest in the property. Okay, but that's crap. If I say that I don't own something that's not mine, it's probably because it's freaking not mine. So if I say that something, if I were walking around and saw this vape like sitting outside on the ground, but knew it wasn't mine because mine was in my pocket, and I said, well, that's not mine. How is that me abandoning something that's not mine? So how does somebody saying, but that's not mine, mean that you abandoned it? That's not how that works. That's not how that works. This is who wrote this shit? This is wild. And this guy's full of shit. By not claiming ownership of the sheath or any knowledge as to how his DNA arrived on the sheath, defendant abandoned any privacy interest in the DNA. No, because it's his DNA. It's his DNA. So if it's his DNA, but it's not his knife sheath, he's probably going to be like, well, how the hell did something that belongs to me get on something that doesn't belong to me? I mean, I'd be wanting to know too. Second, the fact that a person does not knowingly expose his DNA to the public does not contravene a finding of abandonment. Like DNA, fingerprints and bodily fluids are left unknowingly on surfaces of public places merely as a consequence of venturing into the public sphere. Yet, I'm sorry, hold on a minute. I mean, fingerprints cool, but what kind of bodily fluids do you think are just being left all willy-nilly everywhere? Like, people sweat, sure, but unless they're like rubbing their bodies up against stuff, they're not just leaving like their sweat particles in places. They're not like spitting on things on purpose. Like, if you're just walking around normally, you're not just leaving liquids all over the place. So no. The fact that he is trying to compare something like this touch DNA boo-boo to something so severe like actual bodily fluids and blood and man seed is stupid. I'll say it again. Hippler is stupid. This is so dumb. I'm gonna start like watching people and see if I can see bodily fluids just getting flung all over the place as they walk down the cereal aisle. Because no, that's not normal. That's not normal. Okay. No. As noted in Burns, this does not raise constitutional concerns. Well, I'm sorry, but if you're just spreading bodily fluids all over the place, it probably is a lot of constitutional concern. The manner in which humans shed cellular material is not fundamentally different from the manner in which the oils comprising fingerprints are shed. Okay, well, that's about the only bodily fluid I can agree with is if you're able to leave fingerprints on things, you're definitely leaving your oils because even if you don't feel oily, your body creates its own oil. That's just naturally what it does. Even if you can't feel it and you don't feel oily or nothing, it's there. It's definitely there. Let's see. Okay. What matters is that the material was left in the public domain. Applying this rationale, the Maryland Supreme Court concluded that the defendant abandoned any privacy interest he had in his shed DNA collected from a chair in which he had been sitting. Something so simple. In doing so, the court rejected that notion that abandonment required an explicitly voluntary knowing act. Okay, it's the punctuation kind of tripping me up. Okay. The court rejected that notion that abandonment required any explicitly voluntary knowing act, noting. We're going to just go right past it. The fact that one has not knowingly exposed to the public certain evidence does not by itself demonstrate a reasonable expectation of privacy in that evidence. While Katz says it is no search to discover what one knowingly exposes, it does not declare the exact reverse of this proposition. That is, the Supreme Court does not say that discovery of what was known these glasses are gross, of what was not knowingly exposed is inevitably a search. Is this Katz? Like, what's his face? Who's the guy from Making a Murderer? Because isn't the lead investigator in there? Isn't that Katz? No, this is a Maryland case. Is that in Maryland? No, his last name's not Rayner. Search and seizures from 2012. Okay. Likewise, here at some point, defendant apparently interacted with the sheath to a sufficient enough degree that he left his DNA. No, he didn't even have to touch it. He didn't even have to touch it. Whether he knew he left his DNA behind is of no consequence. It is only relevant that he exposed his DNA to the public by leaving it on the sheath, thus forfeiting any reasonable expectation of privacy in the DNA left behind. That's not true. At some point, defendant apparently, that's not a concrete. That's not a concrete. Apparently means a possibility. Here at some point, defendant apparently interacted. That's not a concrete. This is a stupid sentence. Again, Lucas Anderson never once interacted with the victim, with the victim's home, with the victim's family, with the victim at all. Even after death, never interacted with the victim. Yet somehow his DNA was under the man's fingernails. Apparently interacted. No, that's not a concrete. This is so dumb. Who wrote these rules? I am not happy with the way that we are learning that our rules are written. This is wild to me that these are things that passed several different votes to come into law. And it really makes you wonder how much of this crap that they actually read before they sign off on stuff, because this is the stupidest crap. This is wild. Okay, number 2. Even if not abandoned, defendant has not established his subjective privacy interest in his DNA is objectively reasonable. A Fourth Amendment search occurs when the government seeks to gain information by infringing upon a person's reasonable expectation of privacy. And again, it's Katz versus the U.S. from 1967. An expectation of privacy is objectively reasonable when it is legitimate, justifiable, and one society should both recognize and protect. State versus Fancher from 2008. It is true that DNA testing, particularly S&P testing, can unlock a wealth of intensely private information about an individual, including family relationships, ancestry, genetic disorders, and the propensity for health-related risks. Again, with the health-related. Like, isn't it separate, though? Like, I know that there's specific DNA portals that do the, like, health stuff to see what you're, susceptible to genetically, because some things do run like in the blood, like in the family, right? But ancestry ones are separate. I mean, I'm sure there's ones that maybe offer the exact, like offer both things. But as far as I understood, whenever you did an ancestry test, you did an ancestry test. If you did a health test, you did a health test. Like, it's two completely different things. Then again, I would never try these things, so I could be wrong on that. But I could have sworn it's like two completely different things. Okay. Such highly private information is already protected under the law in other contexts, including in Idaho through the Genetic Testing Privacy Act, which prohibits genetic discrimination in employment. They blood test you to get certain jobs? Well, that's odd. I didn't know that. Okay. Given the privacy interest implicated by DNA testing, defendant argues that DNA can lawfully in possession of law enforcement, cannot be tested absent probable cause and a warrant. I mean, yeah. Yeah, like you kind of have to have like all the legalities, dotted I's, crossed T's, all the things. Yeah. In defendant's view, the breadth of information S&P testing can reveal is analogous. I don't use these words. Analogous to the CSLI at issue in Carpenter, where the United States Supreme Court held that a person maintains a legitimate expectation of privacy in the record of his physical movements as captured through CSLI data maintained by the person's wireless carrier. Why are we talking about that in this one? This is about the IgG. The Carpenter Court reasoned that those detailed encyclopedic records, which provided an all-encompassing record of the defendant's location over a course of 127 consecutive days, can give law enforcement an intimate window into the person's life, revealing not only his particular movements, but through them his familial, political, professional, religious, and sexual associations. And again, this is not about this case. This is about this Carpenter case that they're talking about. These location records hold for many Americans the privacies of life. And this is Riley versus California from 2014. Defendant also relies on Riley, where the United States Supreme Court held that police may not search digital information from a cell phone seized pursuant to the search incident to arrest exception exception to the warrant requirement. The court observed that unlike physical objects, digital data on a cell phone does not implicate the same government interest justifying searches incident to arrest, i.e., preventing loss of evidence and threats to officer safety. Further, the court found that the extent of personal information digital data would reveal about a person implicated significant privacy interest, noting that while an arrestee has diminished privacy interest, it does not mean the arrestee has no Fourth Amendment protections. By analogy to Riley, defendant contends that law enforcement should be required to obtain a search warrant to analyze the DNA from the sheath despite being in lawful possession thereof. And yeah, isn't that the whole point? Like, so many things get thrown out because a warrant's wrong or something simple was missed. I mean, look, we had that piece of shit. What was his name? The blonde guy who took out all of his kids right in front of his wife and his stepdaughter. Blonde guy, I think from Ohio. I don't remember his damn name. I talked about him once and we went over the body cam footage of him getting arrested. Anyway, because the officers were such like in an emotional, traumatic state of seeing that asshole, Dorman. So because the arresting officers were in such a traumatically emotional state, because I mean, you really have to think about the scene, okay? They rush up to the scene. They have a little girl running around screaming her head off. People calling saying that they're hearing shots. They're right there next to the fire department. And so they've got all these things happening. And then they get there and there are these just like these little bodies just on the ground. And this piece of shit sitting on the step smoking a cigarette. If for somehow his heart would have stopped beating right there, I'd have been sending the officer money for the rest of his life in jail. Because those kind of people right there don't deserve to live. That's the situations I support the DP for. Okay, I don't care. I don't care. He doesn't need to be breathing. They missed one little bitty thing whenever they were telling him his Miranda rights. And it screwed up their case to the point to where he's basically like, he's not getting away with it, but he's not getting the punishment that he freaking deserves. Because they were in such an emotional situation that they skipped something. And it was stupid, dumb, something that shouldn't even matter in my opinion. But we have to follow the rules. And it's funny to me that somebody who does something disgustingly horrible, their mental health can be taken into question when they do such horrid acts. But what about the officers that skip a sentence in the Miranda rights because of the emotional trauma they're dealing with at the time of seeing these little babies taken out by their daddy? What about their mental health? Why can't that ever be talked about whenever it's deserved to be talked about? Yes, exactly. The poor cops that had to process that scene. And they don't take that into consideration. They should be taking all of that into consideration. And that's why stuff like this makes no sense. Somebody like that, all the proof is right there. All the proof for that Dorman dude is right there. And something so simple is going to let him get a lesser punishment than he deserves. But we've got no warrants for Othram, no warrants for the feds. The DNA profile that was actually used to give Moscow his name has been completely deleted. There's no warrants for the trash. There's no protocols. And no proof. And this is where we are. Doesn't it make you sick? You know what else really makes me sick? And I'm going to get back to this thing. The stuff going on in Delphi, I have a whole video. I have a video for my Delphi, my opinion on all this crazy shit with Ron Logan and Keegan Klein and this Reese Davis guy. I have a video about that I'm almost done editing. And then tonight was actually supposed to be my reaction video to the interview that Seth Rogers did, Sebastian Rogers' dad, with Laura Lodge. That one was supposed to come out tonight, but then we got this information. So it'll be coming out tomorrow. But the stuff with Delphi, this is so like disgustingly sick. There's so much stuff in that case. And I'm like, are we going to see all that stuff happening here? Like, are we going to end up getting a conviction? And then all of a sudden we're going to get all this information. Oh, this guy confessed to this dude, and they had this guy confess in writing and just a few months after the case happened, but he was all the way over here. Like, are we going to get that kind of stuff? Yeah. Gull already denied the motion for correction without having a hearing. The information about Ron Logan, literally having like information down to arteries, bro. Like, there's no way. No way. Like, how can you sit back and see what's going on in Delphi and then see what's going on in this case and not be like, damn, deja freaking vu. Vu, however the frick you say it, deja vu. Like, somebody commented under the community post about all this that like this is like their last straw, that they really like didn't want to keep following the case because you can already see exactly what's going to be going on here. And I'm like, this is exactly the reason why you should be paying even more attention, because we've already seen where this goes. It's just so wild. I could complain all day. I don't want to, but I could complain all day. Okay, let's see. I think this is where we were. With regard to the SNP testing of DNA in particular, defendant relies on Skinner versus Railway Labor Executives Association, where the United States Supreme Court held that the collection and subsequent testing of an employee's legally obtained urine constitutes a Fourth Amendment search. Okay. Again, a bodily fluid that takes some effort and is not effortless and involuntary completely, like skin cells and other things. So I don't really know that you can really compare those two either. The court observed that while a physical intrusion into an employee's body to collect the urine is an obvious infringement of the employee's reasonable expectation of privacy, a physical intrusion into the employee's body? Like they put a catheter to get urine? Is that what this is about? This is so far from what this case is about. I'm very confused. Okay. The subsequent chemical analysis of the urine sample to obtain physiological data about the employee is a further invasion of the employee's privacy interest, given that such testing can reveal a host of private medical facts about an employee, including whether he or she is epileptic, pregnant, or diabetic. What does that have to do with employment, though? And see, and I know that like the defendant is the one relying on this case, but I'm not going to sit here and act like I understand why the defendant is trying to rely on this case. Nobody went into his body unless they're trying to talk about the swabs. I mean, yeah, the employee would have the right to refuse us, but it's this wording right here. It's this wording. Where's it at? Intrusion into an employee's body to collect. That sounds like they're forcing it, like they're doing some crazy stuff. Come at me with no damn intrusion of nothing. That's just insane. But then again, I don't understand why you would be testing an employee to see if they were epileptic, pregnant, or diabetic. Because why is any of that your business unless they're like a pilot or some shit? You know, based on Carpenter, Riley, and Skinner, defendant contends that because S&P testing of DNA is even more revealing than CLSI data or urine testing, it should be allowed only upon a warrant, regardless whether the DNA was lawfully obtained. Defendant argues that this is precisely what the Fourth Circuit did in United States versus Davis when it held that the extraction of DNA and the creation of a DNA profile result in a sufficiently separate invasion of privacy that such acts must be considered a separate search under the Fourth Amendment, even when there is no issue concerning the collection of the DNA sample. At this issue in Davis, which is the case that a lot of people were questioning when it came to the motions from January, because there's a mention of clothes in a bag, And a lot of people thought that they were talking about this case because of unfounded and unproven, as I showed you guys in the video about it, rumors that Bethany might have seen a naked guy throwing clothes in a bag, blah, 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 whatever. People were thinking that had to do with that. And no, it was Nye, the special prosecuting attorney that's helping, Thompson and Jennings' stupid self. He's the one who was talking about the Davis case with the clothes in a bag. It was just them making a reference. It had nothing at all to do with the case whatsoever. So I just wanted to clarify that one more time before we continued on talking about Davis so that there's no more confusion. At issue in Davis was DNA extracted from the defendant's clothing, which had been lawfully seized 4 years earlier when the defendant was a crime victim in an unrelated case. Relying on Skinner, the court reasoned that the extraction and analysis was a search because the analysis of biological samples, such as those derived from blood, urine, or other bodily fluids, can reveal physiological data, and a host of private medical facts. Such analyses may intrude upon expectations of privacy that society has long recognized as reasonable. That's actually really wild that they were able, I don't know what the Davis guy did. But just the simple fact that they went back to a situation where he was an actual victim and extracted DNA, that has to be some sort of illegal. It would have to be illegal. That's rude. That's wild to me. Okay. However, these cases lend no support to defendant when applied to the specific circumstances presented here for 3 reasons. And I skipped this 12 footnote, but we should probably go back to it because I see something about a swab. So let's just make sure we're not missing anything. Okay. Defendant also cites to the recent decision of State versus Mitchum, where the Arizona Supreme Court found that the DNA testing of a blood sample lawfully collected from the defendant during a DUI arrest constituted a search. The blood sample had been voluntarily provided by the defendant after his 2015 DUI arrest for purposes of testing for alcohol or drugs only. The defendant was informed that the sample would be destroyed after testing. A month later, a woman was murdered, and law enforcement developed a male DNA profile from biological swabs from the crime scene. CODIS did not return a match. 2 years later, law enforcement initiated a familial DNA investigation of the male DNA profile, which pointed law enforcement to the defendant. Officers then performed a DNA test of the blood he had provided in connection with his DUI arrest, which they had not destroyed. The court found the DNA test was a search based on prior Arizona precedent, holding that the DNA testing of an arrestee's buccal swab was a Fourth Amendment violation. It further found the search was unreasonable because it exceeded the scope of the defendant's consent when he provided the blood sample. I guess because he only actually agreed to it because they said after they were done testing it that they were going to destroy it. Mitchum, however, is distinguishable for the same reasons as Davis. It is the status of the individual providing the sample that frames the reasonableness. Although the defendant was an arrestee when he provided the blood, he was not robbed of all privacy interest in his blood. And Riley has a section here explaining arrestees only have diminished expectation of privacy. As an arrestee, he consented to search of his blood only for alcohol and drug purposes and anticipated the blood sample would thereafter be destroyed. Yeah. When officers failed to destroy the blood sample and then subsequently tested it for entirely different purposes, it not only contravened his consent, but also the reasonable expectation of privacy he maintained in his blood at the time it was provided. Here, however, officers tested discarded crime scene DNA from an unknown murder suspect, a circumstance that is outside the margins of Mitchum. So Bryan's team is citing that case. I mean, I don't really see a match for that. I don't really see a match for these two cases. And I mean, I've said it a lot. Again, I'm not a lawyer, so I might not see the reasonings why his defense team uses certain cases to try to make points on stuff. Because to me, this is another one of those things that's like it's apples to oranges. It's not the same thing. This is a situation where a guy was arrested for a DUI, gave his blood over for a drug test, and it didn't get deleted. It didn't get destroyed, but then he ended up, I mean, is this guy guilty? Did he actually like kill the lady? Then I'm not mad about it. I mean, obviously there's rules and the stuff should have been, deleted if that was the case to it, but there's a reason why they're supposed to follow the rules so that if somebody is stupid enough to do something crazy, there's no issues like this. So was this guy innocent? And somehow there was some sort of like crazy thing that happened and his DNA got somewhere, or was he? Can y'all hear them? They're watching YouTube shorts together. Okay, maybe he'll stop now. Again, I don't really feel like this is the same because this is a sample of blood that was taken from a previous offense. And then he did something crazy later, apparently. And that's not the same thing. So I don't really feel like they can use that either. Okay. However, these cases lend no support to defendant when applied to the specific circumstances presented here for 3 reasons. 1, there is no reasonable expectation of privacy in identity. What? There's no what? Everything about your identity data, there's a ginormous expectation of privacy. What do you mean? Defendant has not shown his DNA was tested for anything other than identifying purposes. That's why they keep mentioning the medical stuff. It's almost like the exact same thing for the document about why the Moscow traffic stop is being submitted, because the 4 reasons why they want that submitted into evidence is literally for identification, address, phone number, and car. It has nothing to do with planning, motive, preparation, or any of the things whatsoever that are in the law for that we read. It's literally just for identification purposes and demographics, basically. Even if the DNA analysis revealed sensitive personal details, there is no reasonable expectation of privacy in crime scene DNA. Again, I don't disagree with you, but it can't be the only thing you have and expect for us to take you seriously. It can't. It cannot be the only thing here. They've got to do more. They've got to prove he was there at the time that it actually happened. Because again, he doesn't have a time machine. He doesn't have a freaking DeLorean. He doesn't have Stretch Armstrong arms. Okay. He can't like phase in and out of dimensions and break through the 4th wall. He can't do any of those things. So unless he was at the crime scene at the time that these people were taken, why are we here? Like, I agree, it's probable cause to bring him in, check his information, get his phone data, find out every little damn thing that you possibly can about where this man was. I don't argue that. But for all of this that happened, popping up in the middle of the night with a freaking military grade vehicle, holding everybody at gunpoint for 3.5 hours or so before you even take him off to the police station. What the hell was going on? This is insane. This is crazy. Crazy. All right. I'm going to keep reading. Now, I'm going to tell you right now. Hold on a second. I got to go handle this zombie child. 1 minute. Okay, not a zombie, a dinosaur apparently, but whatever. Okay, now I'm going to go ahead. I'm going to read all of the ones in this one, but what I'm probably going to do for the rest of these is just read like the factual information, because that's going to give us the case facts. That's, where we learned about like the brothers that had a low match to the sheath DNA, and apparently where we're going to find out about Dylan seeing somebody holding something that looked like a vacuum. It's just crazy to me. And if anything else in like this other stuff, like all this case stuff, if anything like this is special that I read by myself after the fact, then I'll do a video about it. Just a short one. But we're probably just going to go over the case facts when it comes to the rest of this stuff. Okay. First, there is no reasonable expectation of privacy in our identifying characteristics, such as fingerprints. Some French or Italian name, I don't know, from 1973. This is because the analysis of such physical characteristics involves none of the probing into an individual's private life and thoughts that marks a Fourth Amendment search. That's from a long time ago. So much technological stuff has changed. So many things have changed. On this basis, courts have held that testing of DNA for identification purposes does not run afoul of the Fourth Amendment because it is no more revealing than fingerprints. Where DNA testing is not obtained by means of a physical intrusion into the person's body, there is no more a search of purposes of the Fourth Amendment than is the testing of fingerprints or the observation of any other identifying feature revealed to the public. Visage, apparent age, body type, skin color. And it mentions burns again. Likening DNA analysis used for identification purposes to analyzing latent fingerprints. Again, if it's just touch DNA, you really just can't compare the two. Can I make this bigger for y'all? Oh, look at that. Okay. The Idaho Court of Appeals has all but followed suit. In Pirro versus State, a post-conviction action, the Court of Appeals addressed whether the petitioner's counsel was deficient by failing to argue his client had a reasonable expectation of privacy in his genetic material left behind on a water bottle. And this is from 2008. In rejecting the claim, the court first noted that since the issue of genetic privacy in DNA was a novel theory in an undeveloped area of law, counsel was not ineffective by failing to raise it. Moreover, the court cast doubt of the substantive value of the argument, noting that in other jurisdictions, courts have held that the use of DNA for identification purposes only does not infringe on a privacy interest in one's genetic identity because the DNA is not being used to reveal personal information. But doesn't it? Like I know that like the criminal part of it is really just like doesn't match. Like doesn't match. It doesn't really matter the rest of it other than bring the person to justice, because then you have to find out their personal information. You have to identify that match. So I don't know if that's really true. Because I mean, like I said, like the match is really the only thing that matters, but bringing the person that does match it to justice, you have to identify them. So I don't know if that's true. I'm just not seeing it the way he's seeing it. Second, in Maryland versus King, decided after Skinner, Riley, and Davis, the United States Supreme Court confirmed that the objective reasonableness of a privacy interest in DNA depends on how the DNA is actually used by the government, not what it is capable of revealing. At issue in King was a Maryland statute which permitted the warrantless acquisition of a buccal swab from an arrestee to obtain a DNA sample. Because the testing was for identification purposes, which is constitutionally permissible, and did not reveal genetic traits or private medical information, the court found it did not contravene an arrestee's privacy in any way. Notably, the DNA testing in King was of the STR alleles, which, unlike S&P testing, are not known to have any association with a genetic disease or any other genetic predisposition. However, the court signaled that this is how the DNA is tested that is legally relevant, not what is capable of revealing, to wit, And even if non-coding alleles could provide some information, they are not in fact tested for that end. It is undisputed that law enforcement officers analyze DNA for the sole purpose of generating a unique identifying number against which future samples may be matched. This parallels a similar safeguard based on the actual practice in the school drug testing context, where the court deemed it significant that the test at issue here look only for drugs and not for whether the student is, for example, epileptic, pregnant, or diabetic, which is the same thing that we just read a second ago. If in the future police analyze samples to determine, for instance, an arrestee's predisposition for a particular disease or other hereditary factors not relevant to identity, that case would present additional privacy concerns not present here. Thus, under King, testing of lawfully obtained DNA samples may run afoul of the Fourth Amendment only if law enforcement uses it for purposes irrelevant to identification. Otherwise, it is no more a search for Fourth Amendment purposes than the testing of fingerprints. See also Burns, which they've talked about like a whole bunch. And it states, noting that if law enforcement had tested the defendant's DNA to reveal... Why does this word always like stop me? Physiology. I don't know why that word always stops me. Physiology and health conditions, such as a genetic predisposition to cancer, it might implicate privacy interest, but law enforcement did not do so. Now it's quoting Rayner, that petitioner's DNA could have disclosed more intimate information is of no moment in the present case because there is no allegation that the police tested his DNA sample for that purpose. And then State versus Athen from 2007 in Washington. While DNA has potential of revealing a vast amount of personal information, no privacy interest was implicated where the testing of DNA was limited to identification purposes. Here, defendant provided no evidence that the S&P profile developed from Q1.1 through IgG revealed any genetic predisposition or physiological or medical conditions. As Mr. Hellwig testified, the S&Ps that carry such sensitive information are not targeted or revealed in IgG because they are neither relevant nor probative nor appropriate to the identification process, which is the goal of IgG. Rather, IgG only implicates those S&Ps associated with ancestry and genealogy in order to determine genetic associations, build a family tree, and identify potential genetic relatives of the uploaded S&P profile. It is simply an identification tool. In this regard, Carpenter is unavailing authority, as has been found by other courts addressing the issue of privacy interest in DNA generally. And there's a 13th footnote. Okay, so People versus Mendez from 2021. The extraction and analysis of DNA for the sole purpose of developing a profile is not, like the cell site location, information at issue, deeply revealing, or of substantial depth, breadth, and comprehensive reach, since the genetic information obtainable from DNA that is deeply revealing and comprehensive is neither sought nor revealed in the process. Burns, again, distinguishing Carpenter on grounds that DNA analysis used for identification does not provide police with the type of comprehensive surveillance at issue in Carpenter. Then talks about State versus Hartman from 2023. Cell site location information is distinguishable from DNA. Why are we even talking about these two things together? Like at all? One is biological and one is your cell phone. I don't understand why they're trying. I mean, unless they can match his location over there. I don't know why we're talking about this because we already know that they can't. The CLSI in Carpenter was not used as an identification tool. It was used as a comprehensive surveillance tool after a suspect had already been identified. At best, Carpenter can be applied to technologies that provide the government with comprehensive surveillance of known persons' physical movements. This is not the type of information the DNA provided in this case. Well, no shit. Duh. Why are you having to tell us that? We know that the DNA doesn't exactly tell you a person's physical movements. I feel like some of his argument is just kind of stupid. I'm just going to keep saying it. Law enforcement here extracted and analyzed the DNA of an unknown suspect solely for identification purposes. It provided no information as to location of a known person and does not begin to approach the surveillance described in Carpenter. And we have a 14th footnote. Further in Carpenter, the United States Supreme Court expressly limited its holdings to CLSI. Our decision today is a narrow one. We do not express a view on matters not before us. Okay. Where were we? Okay. Riley is distinguishable as well, as it was context-driven, focusing on the lack of connection between the justifications underpinning the search incident to arrest, exception to the warrant requirement, and a search of digital data on a cell phone. The court noted that after an arrestee's cell phone is secured by officers, the digital data it contains cannot harm the officer or be destroyed. How can digital data reach out and harm someone? It's just strange wording. Okay. Thus, a search of the digital data becomes solely a fishing expedition without justification. And now we have a 15th footnote. Further, the court did not hold the law that law enforcement is always required to obtain a warrant to search a cell phone, and specifically noted that other exceptions to the Fourth Amendment could apply to allow such a search. I think in this case, you definitely would have to. I think you definitely would have to. Because there's no like emergency situation here. It's not like it's just like unlocked and open to like a text message that's incriminating. You know what I mean? Like you would have to. You would have to do a search warrant. Here, by contrast, law enforcement analyzed the DNA from a crime scene item associated with a weapon for purposes of identifying the perpetrator with a weapon. Through all of this, all I'm looking for is something that's going to at least validate that they believe that the wounds match the sheath. I want something to validate to me that they think that what matches the inside fitting of that sheath is actually one, if not the weapon. They haven't been able to do that. So if he says something in here, he better mean it. But at this point, he's not saying associated with the weapon. He's saying associated with a weapon. Verbiage matters. Okay. Identification is an accepted justification for testing DNA. Moreover, even assuming there were sensitive genetic details revealed by the IgG performed here, the fact that the DNA was obtained from a crime scene and analyzed for purposes of identifying the perpetrator displaces any reasonable expectation of privacy. The Court of Appeals of Washington recently came to the same conclusion under similar facts. Of course, Washington did. In State versus Hartman, law enforcement extracted DNA from man seeds and hair left on a murder victim's body. The DNA was then sent to genealogy consultant who uploaded a genetic profile to various genealogy databases for analysis. From that analysis, law enforcement learned the suspect had alleles related to substance abuser, bipolar disorder, and baldness, and was approximately 9% Native American. So they are looking for all that stuff whenever they do DNA stuff. So, I mean, I guess it would make sense for them to be able to get like some sort of physical idea about what the person looks like. But that's wild that they can go in there and see from the alleles the substance abuse. Like, I understand the bipolar disorder and maybe even the baldness, because like normally that is sort of like genetic, but not really, because I know some people that started going bald like hella early in their lives, like mid-20s, and their fathers and grandfathers have heads full of hair in their 80s. But then I also know people like the opposite, like their parents, their fathers, their grandparents, their uncles, they all went bald early, but then they have hair until the rest of forever. So how accurate can that be? The Native American thing I sort of understand, because like there's all kind of testings for that stuff too. But then again, people that are like really deep into genealogy will even tell you, and I mean like the scientists, like the sciencey people that run corporations, they'll even sit there and tell you that that's entertainment science and that they're really just guessing. They're really just guessing. This is wild. Okay. The genealogist used the information obtained from the databases and other resources to begin building a family tree, from which she learned there was an instance of misattributed paternity in the suspect's family. Her research ultimately pointed law enforcement toward the defendant. And again, that's about a different case, not Idaho. It's just something that they're quoting. Like here, the defendant in Hartman argued he had a reasonable privacy interest in the DNA extracted from the man's seeds, which law enforcement violated through its analysis, revealing private personal details. In declining to recognize his privacy interest as reasonable, the court observed it was a well-established rule that analysis of evidence left behind at a crime scene does not require a warrant where the abandoned evidence contained DNA, even though DNA contains a wealth of personal information. The court observed that the DNA was not only abandoned, the analysis performed by law enforcement was to determine the killer's identity and nothing more. Thus, even though the analysis revealed personal details, they were identifying characteristics that served to narrow the suspect pool and therefore did not run afoul of the Fourth Amendment. So I really wonder what other information like that came out whenever they ran the sheath DNA and got information. Like, did the guy... Like, does Bryan match his personal profile? I wonder what it says. I'm super, super curious. Super curious. This holding highlights another important point. It is the status of the individual whose DNA is tested that helps frame the reasonableness of the privacy expectation. In Davis, relied upon heavily by defendant, the Fourth Circuit's holding rested entirely on the fact that the DNA tested was taken from clothing police seized years earlier when the defendant was a crime victim. Yeah, that's the Davis case. Noting, we agree with the district court that a person who is solely a crime victim does not lose all reasonable expectation of privacy in his or her DNA material simply because it has come into the lawful possession of the police. And although Davis later was arrested because the police seized his clothing when he was solely a crime victim, we concluded that his later arrest does not eradicate his expectation of privacy in his DNA material, which I do agree. Like, even if this guy is hella guilty, it's just not okay that you went and took DNA from an instance where this person was a victim, because that was not the reason for you having his information in that aspect in the first place. It was not to do anything of him harm, but for that person who caused him to become a victim to have justice brought to them. So again, even though this guy was probably guilty, I mean, I don't know whatever happened here. If he was actually guilty, it's still not okay that they went back and took information from a situation where he was a victim. Like, that is wild to me. That is just super wild that they thought that would be okay. In fact, the district court affirmed in Davis drew a distinction between the analysis of crime scene DNA and other DNA, stating, this finding would not, as the government argues, require the police to seek a warrant in order to analyze any items recovered from a crime scene for DNA evidence. No one would argue, for example, that a R-worder retains a reasonable expectation of privacy in the DNA contained in the man seed that he leaves on his victim. Society considered it reasonable that if one has committed a crime, any evidence one leaves behind while doing so is fair game. Okay, but stuff that you literally sneeze out of your face that lands on another person that then gets transferred somewhere, or again, your skin cells, your dead skin from your dandruff or whatever the heck's going on with you, where things flake off. You're walking past somebody, you touch something somebody else touches. That is not the same thing. He doesn't realize, I guess, that he's messing with like the court jester of DNA, the one piece of DNA that literally means nothing. Does he not comprehend that? Because in order for him to actually know what the hell he's talking about here, he actually has to know what the hell he's talking about here. And that means all aspects of all the things. So this doesn't even make any sense, the things that he's saying, or the things that he's trying to compare in this situation, because they are not the same. Not the same at all. Absolutely wow. Where was I? Okay, fair game. The intentional, volitional act of committing the crime itself supports the theory that the criminal intends to abandon any privacy interest he has in his blood, fluid, cells, etc., that he may leave behind at the crime scene. Furthermore, the very fact that a given area is a crime scene changes the balance of interest relevant to a Fourth Amendment analysis of crime scene evidence. Okay, cool, but why didn't you do the exact same stuff to the blood that was found? Y'all went hardcore, everything in, all cards on the table for some dusty stuff found on the inside of a button. But y'all didn't run the blood DNA down to an answer? If they would have treated all of the DNA samples the same way and had no unknown DNA and everything was done and treated the same, then I couldn't argue on a lot of stuff. Like I couldn't literally sit here and complain about a lot of things if they would have done things to protocol, if they would have tested everything out to the end and then done all of their work. But they can't bring us somebody whose dusty little crusties were found on a freaking button snap and nothing else is against him whatsoever and expect me to believe that he's where he belongs. It doesn't make sense. It does not make any sense. I'm not even going to read the rest of that. Okay. This distinction between crime scene DNA and other DNA likewise renders Skinner of no use to defendants. In Skinner, the urine was collected from employees for workplace purposes and subjected to testing. It was not obtained to be tested for identification purposes. It was obtained to test whether the employees had drugs or alcohol in their system. Had it been urine that was left by an unknown suspect at a crime scene and then tested to determine identity, the result would undoubtedly be different. Okay, so yeah, he's not wrong here saying that this argument that the defense, Bryan's team is the one using this case as an example, and they can't. So I'm not disagreeing with Hippler on this part, because anything that has anything to do with anything other than touch DNA, I don't give a damn. And they need to be working harder to find cases that actually match the situation here. Touch DNA. Why are they not talking about Lucas Anderson? Can we ask that question? How come Ann Taylor's team is not talking about Lucas Anderson in all of these citations? They're talking about things that don't matter. Things that, and I've said this before, this is not the first time, if y'all been here, it's not the first time you're hearing me say that about the things that the defense is using to argue. Why aren't they using cases about touch DNA? I don't understand that. Coffee Master, thank you for the $3 super sticker. That's very sweet. Thank you, thank you. So yeah, I don't disagree with this. I don't disagree with this part. They need to be doing better to find cases that are more relevant to the situation. Like, I understand that the other one that they talked about was very similar in the way that things happened, but again, you cannot compare some dusty, crusty stuff to man stuff. You just can't. You can't. It's like insane that they're even trying to. Okay. Even legal commentators who advocate for increased protection over DNA evidence agree that the Fourth Amendment does not prevent law enforcement from analyzing genetic evidence left at a crime scene. And then it talks about a genetic privacy and latent crime scene DNA of non-suspects, how the law can protect an individual's right to genetic privacy while respecting the government's important interest in combating crime. A whole book. Okay. If the DNA was found in the victim on a murder weapon or on another object closely related to the crime, that DNA may be analyzed without implicating the Fourth Amendment. Palma Pacquiao, I think that's that same name from earlier. Okay, yeah, this is the doctrine. Yeah, we read that title already. Okay. Okay, observing that her proposal requiring a warrant to test all DNA samples discarded by crime suspects would not apply to DNA collected at crime scenes or in testing of R kits, because there is no reasonable expectation of privacy in DNA deposited at a crime scene. And then another book called Reclaiming Abandoned DNA, the Fourth Amendment and Genetic Privacy from 2006. Requiring a warrant to test DNA recovered at a crime scene would be pointless, for there is nothing for a magistrate to consider. Then why do you need a warrant to get something out of your own lab if you think that you don't need a warrant for external labs to then take something that you're supposed to be in control of, in command of, that whole chain thing, Why would you not need warrants for that and paper trails and things that make more sense than that? What are you doing? Okay, hold on a second. Tell me why my 6-year-old felt the need to come in here and tell me he just saw a McDonald's ad with Snoop Dogg in it. And I needed to know that. He loves Snoop Dogg for some reason. I don't know if it's because of his name or what, but anytime he sees Snoop Dogg on TV, he has to come and tell me about it. That and Gordon Ramsay. Strange combination. Okay, let's see. Where were we? Okay. Yeah, I don't understand this part because, again, like they're not doing their own work. They're sending it off to technically 2 different places. Because ISP is the one who did all of the evidence collection. We know that from knowing all the protocols and stuff about the timeline that people got there. But then they sent it off to Othram. Othram gave them back their stuff, and then they sent it back off to the feds. And no warrants for none of that. No warrants for any of that, and that's totally fine. I don't understand. Okay. In sum, defendant's argument finds no support under the law. Any privacy interest he can claim in his DNA was abandoned along with the sheath, to which he claims no ownership or knowledge. If it didn't belong to him in the first place, he's not gonna lie and say it did to make you happy. You cannot say that it was abandoned if it never belonged to him. That's my problem. That's where my disconnect is with this. They have not proven that it was his. So how can he abandon it if they have no proof that it belonged to him in the first place? The DNA does. And those, just like I said, they're not denying that it's his DNA. They want to know how it got where it is, how it was placed there. That's their words. So if they can't prove that the sheath is actually Bryan's, then they can't say that all of this goes under this abandonment law, in my opinion, because you have to prove ownership in order to abandon something. I don't understand why. I mean, isn't that like common sense? Like, isn't what I just said like more common sense? Like, you should have to prove ownership in order to be able to prove that it was abandoned. Like, you have to own it. Right? Like, you should have to prove ownership to then be like, oh, so it did belong to you, but you're telling us it didn't belong to you, therefore you've abandoned it. But they're not claiming that they have proof that it even was his. That's probably why they have Nancy Disgrace over there, like pounding down on the freaking Amazon warrant, and Chris McDonough over there lying to people about there being something in the Amazon warrant, and he's pulling up the same bullshit that we have. And all it is their generic, serial numbers from Amazon that have nothing to do with nothing. It's just dumb. Just dumb. Okay. Even if no such abandonment occurred, defendant has not demonstrated it is reasonable to recognize a privacy interest in DNA left at a crime scene, particularly when it is analyzed for identification purposes and nothing more. Further, to find the defendant retained a reasonable privacy interest in DNA left at a crime scene, indeed on an item intimately associated with the suspected weapon, Meaning all this time they haven't been able to validate that the wounds were made by a K-bar. That's what that means to me. Suspected weapon means they have not proven it. Okay. Would have the untenable effect of eliminating the use of abandoned DNA as an investigative tool. As observed by the United States Supreme Court in King, this tool has utmost importance. Since the first use of forensic DNA analysis to catch a R-worder and murderer in England in 1986, law enforcement, the defense bar, and the courts have acknowledged DNA testing's unparalleled ability both to exonerate the wrongly convicted and to identify the guilty. It has the potential to significantly improve both the criminal justice system and police investigative practices. Neither society nor this court are prepared to go where defendant seeks to take us. Therefore, because the development of the S&P profile did not contravene defendant's Fourth Amendment rights, suppression is not warranted. B. Defendant has not established a Fourth Amendment violation with regard to the trash pool and testing of DNA therefrom. Defendant next asserts that law enforcement's trash pool from his parents' Pennsylvania residence and subsequent DNA testing thereon constituted warrantless and unreasonable searches mandating suppression. I agree, because if the trash was on the road and they walked up to the trash can and got it off the public street, then that'd be one thing. That's what I thought for so freaking long, that that's what they did. I thought that's what they did, that they went up to the trash can, grabbed some old trashy trash, and then snuck it off for testing. The story that we're being told now is different. So how do you not need a warrant if the company that owns the trash can that the trash is in has driven into the neighborhood, taken the trash from the trash cans that belongs to their company, that's technically just being rented and used by the residents of this neighborhood, okay? And then they went and took the trash out that trash truck. How do they not have to have a warrant for that? That doesn't make sense to me. That makes no sense to me. He argues he had a reasonable expectation of privacy in his parents' garbage that was violated when law enforcement arranged for a trash pool. The privacy interest, according to defendant, is predicated on not only Monroe County's municipal ordinance prohibiting anyone other than a garbage collector from collecting the Kohberger's family's curbside trash, but also from the fact that the Kohbergers resided in a gated neighborhood and the garbage cans were on the driveway as opposed to a public area. Not on the street. Not on the street. Number 16, defendant provided no evidence that the garbage cans were on the driveway as opposed to the street curb. All of y'all's freaking surveillance footage proves that, Hippler. What do you mean? You forget that we just read that on Christmas these mofos were sticking cameras all over the property? Are you for real? And wasn't the 25th before they pulled the trash? How do you not have cameras? Even the trash trucks has the cameras. The defendant doesn't have to prove anything. Y'all have all the footage. What you mean? And again, I want to know in this residence if the neighbors had ring cams. There's no way that somebody facing that house doesn't have ring cams. And to say that there's no evidence of where they were parked, the trash can, whenever it came to pick it up, would have it on the camera. They have cameras all over those trash trucks, especially in a neighborhood like that. Gated community, so technically the roads wouldn't be public anyway. Well, that's probably true. That's probably true. I know that me and my ex used to do like dumpster dive stuff behind businesses and stuff like that. You'd find all kind of crap that wasn't even open, purses, makeup, all kind of shit. Like these people just threw stuff away. It's gross. It's gross, the stuff they throw away. And the shit was fun. Treasure hunting, I loved it. Loved it. We got pulled over one time by a cop. We got pulled over one time by a cop because we were behind the Dollar General, and I guess they thought we were up to no good. And so he pulled us over, and all he said was, You can't go dumpster diving and digging through trash at commercial businesses, but you can go to any of these neighborhoods and dig in their trash cans as long as they're at the road, and we can't do shit even if they call the cops. Isn't that wild? You can't go to these businesses, but you can be all up in people's trash up in their house. Yeah, it was a wild night. I thought we was going to jail. It would have been wild. Okay. While defendant acknowledges, binding precedent holds otherwise. Okay, well, let's read number 17. California versus Greenwood. Warrantless seizure and search of garbage did not violate Fourth Amendment rights because the defendant did not have a reasonable expectation of privacy in the garbage he placed out for collection. I'm sorry. I pay a garbage bill because my expectation is that the garbage dude is going to show up around 4 o'clock in the afternoon, take my garbage can, pick it up with his arm of the truck, dump it into the back, and then place it back on the street where you're supposed to put it so they can pick it up. I then don't expect for them to then pull over on the side of the road and allow some willy-nilly warrantless bullshit to happen to my trash. That's what I don't expect. That's what I don't pay $100 a month for. Okay? So what you mean? And especially if it was on the driveway. I mean, granted, gated community roads probably not considered public. I completely agree with that. But it's worse if they're on the driveway. It's worse if it's a private company and there's no warrant. How is this okay? There's no rules here. There's no rules. There's no rules. Let's just be serious. There's no rules. No rules. Okay. While defendant acknowledges binding precedent holds otherwise, he asserts it is time to rethink these decisions and find a reasonable expectation of privacy exists, if not under the Fourth Amendment, then under the increased protection afforded by Article 1, Section 17 of the Idaho Constitution. Alternatively, he argues that even if the trash pull was lawful, the testing of the DNA found on the items of trash was not under Skinner and Davis. Well, if it was lawful and they had a warrant and they did it right, then the DNA is good to go, right? Right? Like if they got a warrant for this private freaking company to go into this private freaking neighborhood and pick up this freaking private trash, then the DNA testing's not a problem. That's a good question. How the hell did they get in there? How did they get in there? Susie Mack just said, who or how did they get into the gated community? Was it with a warrant? I don't believe so. That's what this whole argument's about. But a gated community normally means that you have to have like a code to get in, right? Like I don't know what the front gate of that place looks like. So I don't know if it's like an actual security gate and there's like somebody at the gate and you have to like pass through, show residential proof. I don't know any of that. But if it's a gated community, you think there'd be some certain like protocol that, right, like usually a guard or a code. But then again, local law enforcement, in order to get into the gate for an emergency situation, there's like a special code, like a blank code that normally gets hard coded into stuff like this, or they at least have access to an emergency access code that they can then use to get in the gate. I feel like we need that too. We need to know how they got into the gated community because I'm sure that it matters. Especially since I don't like, getting warrants for things. However, the defendant filed his motion. The Idaho Supreme Court reaffirmed its holding in Donato and rejected the very argument asserted by defendant here, i.e., that a local waste management ordinance can create a reasonable expectation of privacy. State versus Polizzi from 2024. An objective expectation of privacy is not created simply because an ordinance aimed at maintaining society's interest in sanitation dictates how trash is to be collected. As for the subsequent DNA testing of the discarded items, relevant here is the abandonment theory. This is so ridiculous. This is ridiculous. Okay. This court is bound by the decisions of the Idaho Supreme Court, and now we have another footnote. He is killing me. these footnotes. State versus Guzman from 1992, observing that the Idaho Supreme Court is the ultimate authority in fashioning, declaring, amending, and discarding rules, principles, and doctrines of precedential law by application of which the lower courts will fashion their decisions. This court has been and remains the final arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. I don't see nothing evolving but your bullshit. Y'all are not evolving to anything because none of this crap makes any logical common sense. Evolve more, because so far this is devolving, not evolving, devolving. There are no facts presented here that meaningfully distinguish this case from Donato or Polizzi. That the garbage cans may have been placed in the Kohberger's driveway for collection as opposed to on a public road, and that the Kohberger's neighborhood was gated are legally irrelevant factors given that the garbage was placed for the purpose of having it collected by another. So there wasn't no, okay, so somebody had said something about how there was like a special trip just to go pick up this trash. But that wouldn't even make any sense. Okay, I need them to make this make sense. If it is trash day, and you are a garbage man going through a neighborhood, you are not just picking up like one person's trash on your scheduled route. When you put your trash out on the road, you know damn well that you should be seeing all of the rest of your neighbors' trash cans also on the road. If you're the only one out there, then you're probably like that kid that gets up for school on Saturday because your parents play like a trick on you or some shit, telling you that your alarm's going off. Okay, it's one of them things. You put your trash can back, you can go in the house all embarrassed, whatnot. You put it out the next day. Okay, you would not be out here, like your trash can would not be accessible to the trash truck unless it was the scheduled day. Okay, scheduled, routine, trash pickup. So they just had the Kohberger's trash just like mixed up with all the other trash from the rest of the neighborhood. I mean, granted, they're trying to tell us that the DNA samples match. Cool, whatever. But you had the Kohberger trash mixed in with all the rest of the trash? They need to explain that more. They need to explain this whole thing more. Okay, they just do. State versus McCall from 2001, finding no reasonable expectation of privacy in garbage placed out for collection, regardless of whether it was in or outside the defendant's curtilage. Privacy interest in trash is lost when it is deposited in an area particularly suited for public inspection and public consumption for the express purpose of having strangers take it. Well, I mean, no one's inspecting my trash, okay? They come and they take the trash and they put it in the truck and they go. They're not sitting there going through it and inspecting it. So I'm not putting my trash out to be publicly inspected. They use really weird words here. Okay. Then we have this 19 footnote. See also Commonwealth versus Pratt from 1990. It's a Massachusetts case. I can never say that name either. Concluding that Greenwood applies to garbage left for collection in driveway. Then People versus Penix from 1989. Same thing. State versus Belts from 2007. Same thing. They're basically just going on about the same cases that have argued about the trash before. Curbside trash not protected under Fourth Amendment simply because the defendant lived in a gated community because it was still accessible to other residents, their guests, and service providers, including the garbage collector. State, United States versus Powell from 2013. And then again, 2017, residence in a gated community does not transform the entire community into an individual's private property for Fourth Amendment purposes. Okay, well, whatever. Therefore, the trash pool did not contravene defendant's Fourth Amendment rights. Yeah, we all do some shady shit, and how you'd think that you don't need a warrant, that don't make any sense whatsoever. Moreover, as already discussed, it is well settled that one abandons a privacy interest in one's DNA by discarding an item containing the DNA. See footnote number 11, which we don't went by pages ago. By throwing away an item of trash containing his DNA, defendant cannot object to the testing of that DNA, particularly given that it was standard DNA testing. What is 20? Defendant also lacks standing to object to testing of his father's DNA, as it is not his own. However, even if he had standing as to his father's DNA, the fact the item carrying the DNA was voluntarily placed in the trash for collection results in abandonment. I mean, the trash DNA thing doesn't bother me. I mean, it never really did bother me, but now it does because we're getting more information about how it was actually collected, and they've got to make it make more sense than what they're doing, because no. Consequently, no suppression is warranted with respect to the trash pool and subsequent testing. I mean, I really didn't think they were going to do anything about the trash. I mean, it is gated. What do you mean? It is gated. That's been like, that's been something that we knew about from like the beginning, that it was a really nice, private, gated community. But see, they can't do that because mailbox, that's a federal offense. That's a federal offense to go into somebody's mailbox and open their mail. I mean, maybe not to go into the mailbox. I don't think it's a federal offense to go into the mailbox, but to go in and open somebody's mail is a federal offense. See, I don't know if they did, Aqua Girl. I know that they tried to say at some point that they like saw him putting trash in a neighbor's trash can, but they haven't proven that. And even if he did, like there's so many people that live in neighborhoods like that say that that's normal. Like if the trash can is full, or if it's like recyclable stuff and somebody's like recyclable thing is full and they're going to go use the neighbors, like apparently that like it's common because of animals, especially out in Pennsylvania areas. They got big wild animals out there. Gresham thinks that he would have given a sample if they asked him. I mean, honestly, he might have. But then again, like getting a warrant to get a buccal swab from Bryan, that would even be like justifiable to me. Because regardless, his DNA was found at the scene. I'm not trying to argue that they didn't have a right to question, that there wasn't probable cause to bring him in, to swab him, to do all the things. But you cannot let that be the only thing. You cannot sit there and tell me that you've got nothing that even puts this man over there, not one freaking time. Not one freaking time, especially whenever this happened. And think that I give two shits about this DNA. If the trash was abandoned, then how can you prove it was ever mined? Well, yeah, that's true too. Because DNA can be planted. And you know, these officers are just all over the place doing all kinds of things willy-nilly with no search warrants. That's 2 states. 2 states now. I'm wondering what we're going to find out about Washington. What warrantless information are going to be coming out about Washington, because now we've got Pennsylvania and Idaho doing all kinds of stuff with no warrant. No paper trail, no permission, no, hey, judge, please sign off on this. Like, I thought that was just like protocol for everything. Everything that was not an emergency situation. Just wild. Absolutely wild. Okay. C. Defendant cannot establish the search of the genetic genealogy databases implicated his Fourth Amendment rights. Defendant's final argument is that law enforcement's warrantless search is the commercial genetic genealogy databases violated his right to privacy in his relatives' genetic information. Observing that this issue has not been addressed by the United States Supreme Court or Idaho's appellate courts, he asks this court to recognize as a matter of first impression that he has a reasonable expectation of privacy in the genetics he shares with his relatives, and further find that such privacy was not undermined when his relatives uploaded their genetic information to the commercial genetic genealogy databases. Alternatively, he claims that the FBI search of MyHeritage and GenMatch was unlawful because those databases were off limits to law enforcement, both under the interim policy and these databases' own terms. Hippler literally stated that in court. That part right there is what he verbalized in court. There was proof of. So the fact that he's doing all this shit now, like, does he just like forget that we all saw and heard what he said? I didn't, sir. I did not. The state responds that defendant has failed to demonstrate a reasonable expectation of privacy either in any of the commercial genetic genealogy databases or in his relative's DNA. Even if defendant could assert a privacy interest in the latter, the state contends that such interest was lost when such relative shared that DNA with the public by uploading it to the databases. Moreover, it argues that any violation by law enforcement of the terms of service of these databases or its own internal policies does not implicate the Fourth Amendment. This court has already determined that defendant failed to show a legitimate privacy interest to challenge the development of the S&P profile from Q1.1. I just lost my spot. Okay. If defendant does not have a reasonable expectation of privacy in the S&P profile, there is no basis to find an expectation of privacy in those portions of his S&P profile he shares with genetic relatives. However, to the extent the court's prior conclusion does not dispose of the issue, defendant's assertions lack merit because 1, defendant has not shown a reasonable expectation of privacy in any of the commercial genetic genealogy databases or in his relative's DNA, and 2, any alleged violation by law enforcement of its own policies and those of the databases is not of constitutional importance. I'm sorry? Any alleged violation by law enforcement of its own policies and violations of the database's policies is not of constitutional importance? Are they for real? What? What? Any alleged violation by law enforcement of their own policies. So the police breaking their own rules and the police breaking the terms of service, the procedures, the protocols of these databases is not of constitutional importance. I'm mind blown. I believe so. I might actually change the freaking whatchamadoodler, the big word on my thumbnail, to that damn sentence right there. I'm sorry. Let me read that again. Any alleged violation by law enforcement of its own policies and those of the databases is not of constitutional importance. He just said that. He just gave every... This makes me sick. Like, I'm going to have to sit back for a second. He just gave every fucking police department an out. He just gave them an out. Because this case is now going to be cited, and Hippler's decision on this is now going to be cited every single time there's a violation. Every single time that a freaking police officer or a police department violates their own rules or breaks the rules of a database that they are using or breaks procedure, this whole freaking decision is going to be their argument. He just gave them across the country so much disgusting ass leeway. I'm sick. This is disgusting. This is disgusting. Yeah, if you opted out of sharing, your expectation is for it to not be shared. And if the cousin that they contacted opted out of that situation and then he got a phone call, he has a lawsuit, doesn't he? Yeah, and again, courts punish lawbreakers. I'm sick. Where's Catherine or Kathleen Zellner whenever you need her? Good night, Batsheet. I cannot believe he just put this statement in an official order. Any alleged violation by law enforcement of its own policies and those of the databases is not of constitutional importance. You know how many cases are probably going to go back to court and be fought now because this asshole just put this in here? Just from that one statement. It's not even a joke. I know that a lot of you have been talking about the Colorado forensic expert that apparently lied and did a bunch of crazy shit on over like 1,000 cases. I have known about that forever. I've mentioned it in passing in a live before. I just never did a video about it. But I knew about that whenever that Georgia mayor or governor or whatever like started being in court a lot. I don't even remember her name, but she's stolen money and she's still constantly in court. She stood up and said something really ignorant about cell phone pings and stuff like that, basically stating that they're irrelevant, they're useless. And this is coming from somebody of importance. Like she's an official. After she stood up in court and said that, all kinds of people who had been convicted with only cell phone data started filing all kinds of motions across the country. Because of what she said and her power and her position at the time that she said it. This dude just did the exact same thing. Yes, that one. But that was going on at about the exact same time. That's why I even remember that situation right there. Because that lady getting in trouble for doing all this crap in Colorado was happening around the exact same time. So me and my buddy were like, so we're going to have all these cell phone motions get filed. All these DNA motions are going to get filed. Like there's all kinds of insanity that was going on at that time. That was a long time ago. I actually remember like the first time I heard about it, I was driving back home from taking the kids to go and help my grandparents for the weekend. Like I distinctly remember the drive and thinking about this case. It's just insane. Absolutely insane. Okay, let's continue. We're on page 23 of 29. And we are going to get into the, what you call it stuff. If I can. I don't talk hardly all day, guys. I mean, I do have to make a bunch of phone calls to the insurance company, but I'm like on hold more than I actually verbalize. So my throat is not taking this very well. Okay, let's go. Defendant cannot demonstrate a reasonable expectation of privacy in common segments of DNA a relative has uploaded to the public sphere. I mean, I guess I understand that part. Like it's somebody like, but you're still taking their DNA and matching it to that other person's information. And it does have a reasonable expectation of privacy if the person that has the common segments doesn't want you looking at. Yeah. That chick. This Tiffany chick. Yeah. Chicago. That's the one. Pretty sure that's the one. Well, thank you for being here to listen to all this, because I know it's been a rough 3 hours and we got some more to go. Okay, let's just keep on going. Okay. To invoke the exclusionary rule to suppress evidence under the Fourth Amendment, a defendant must establish that his own personal rights are violated by an unlawful search. Fourth Amendment rights are personal rights which, like some other constitutional rights, may not be vicariously asserted. And they are talking about State versus Rebo from 2021 and then Raucus versus Illinois from 1978. Defendant acknowledges that the search challenged is that of his relatives' uploaded DNA and not his own. To get around this hurdle, he claims a reasonable expectation of privacy in the segments of shared DNA his relatives uploaded to the databases. This argument requires accepting that 1, an individual has a privacy interest in the genetic makeup of another individual, and 2, that such privacy interest persisted despite the other individual sharing his or her genetic makeup with the public at large. The court will not make this leap. Lisa, 3 months. Thank you for being here. Thank you all for caring about this stuff. This is a lot. And we're going to be here for a while. Like I said, we're going to go through the facts of the other ones. And any of this case stuff that pops up, I'm going to read it myself later. And if anything in this sort of information in the other documents, if it's of importance, then I'll do just a short video later. But we're definitely going to go through all of the case facts tonight, if y'all can hang. Thank you for the $2. RB, keep it rolling. I'm trying. I don't know. I mean, I know that I know that having discussions with it helps a lot. Like doing it like this helps a lot, but it doesn't make it any easier to swallow how horrible our justice system is. It's horrible. Absolutely freaking horrible. Like just the more that I deep dive into all this, it just makes me hate the fact that I wasted so much time on a degree that makes me not proud. You know what I mean? Like I have no interest to continue because I don't want to get in the middle of this corruption and work in the middle of this corruption and then someone tries me because I'm not folding. So I just can't. We're just going to keep doing this like this. Okay. First, there is no authority for defendant's position. Granted, given the novelty of using commercial genomic platforms as an investigative tool, there are very few cases addressing it. However, not one has found that a defendant has a reasonable privacy interest in a relative's shared DNA. The primary case cited by both parties is Hartman, where the state of Washington Court of Appeals rejected the defendant's contention that he had a privacy interest in those segments of his DNA he shared with relatives. That was violated when law enforcement searched commercial genealogy databases to find a familial match to the crime scene DNA. Like here, the defendant likened DNA to the CSLI at issue in Carpenter and urged the court to follow Carpenter to find that his relatives' voluntary upload of their shared DNA did not forfeit his expectation of privacy in the information. The court's determination that the defendant lacked a reasonable privacy interest in segments of shared DNA rested on multiple grounds. The court first observed that the sole purpose of a genealogy database is to let others search for and share private information about the user's personal and family history for the purposes of finding relatives. To this end, the court found shared DNA is unlike the CSLI in Carpenter, which was not shared for the purpose of public perusal. The court further noted that the comparison of the DNA obtained from the crime scene to the genetic profiles of the defendant's relatives was limited to identification purposes and therefore did not support a privacy interest. In addition, the court found no historical protection for voluntarily shared genetic material or for information posted on websites intended for public access. Consequently, the court concluded that because law enforcement's investigation of the genealogy databases did not disturb a reasonable privacy interest, the defendant had no standing to challenge the search. And now we have footnote number 21. Notably, the genealogy databases search by law enforcement in Hartman allow law enforcement access, whereas here, the databases purportedly did not. However, as explained below, this does not alter the result. Now, where'd the little number go? So many numbers. Where's the little number? There's a little number. Okay. Other courts addressing the issue have held similarly. State versus Weston from 2021 in Minnesota, finding no reasonable expectation of privacy in genetic identifying information voluntarily uploaded to genealogy database by defendant's relatives. People versus Williams from 2022, finding the defendant lacked standing to suppress evidence obtained through investigative genealogy search because Williams cannot assert a personal privacy interest in his relatives' DNA profiles. So that's what they're just getting. This is the argument. Like they can't say that he has any right to say anything about what gets done with somebody else's DNA. So would it be up to the person, the family, the cousins, or whoever that ended up getting contacted? Would it be up to them to actually do something about it? That's what it sounds like. Other than claiming that the Hartman court failed to appreciate its holding, defendant has not offered any basis or even a reasonable analog from which the court could make the unprecedented finding that he has a personal privacy interest in someone else's DNA. While he may share segments of this DNA, it is not his own DNA that was searched in the genetic databases. I can feel it feels hollow. I guess that's what happens right before it starts to go out. Feels hollow. Further, there is no evidence he took efforts to shield his genetic relative's DNA from the public. I'm sorry. He wouldn't have the ability. Further, there is no evidence he took efforts to shield his genetic relative's DNA from the public view. That's not up to him. It's up to the people that put their information in there to do that. Bryan would not have had the ability to go in and change the settings of somebody else's profile information. Like, that's probably would be something that would have actually gotten him in trouble. Right. Okay. Now they're citing from Rebo, noting that a defendant must... He is chasing those dogs everywhere. 1 second. He does not like how rough the cat is playing with the dogs. So he's chasing them and trying to separate them. Oh, Zelda has become a little mini bully. Okay? She's a little mini bully. Okay, let's see where we were. Okay, Rebo. Okay. Noting that a defendant must show he sought to preserve the object of the search as private. Again, he can't do that to somebody else's stuff. Thus, since he cannot establish a personal expectation of privacy in the item searched, he cannot challenge the search. Again, it's not his stuff. So if there was evidence that he tried to break into their profiles and change settings, like, I'm pretty positive he could have actually gotten in trouble for that, right? Moreover, any subjective privacy interest he claims in his relative's DNA is not reasonable. One cannot have a reasonable expectation of privacy in what is knowingly exposed to public view. And again, I don't have it. I've never gone in and dug through it, but there are some channels that right after we found out IGG and all this other stuff was involved with Bryan that went out and actually did pull some information. But I mean, I don't know if it's still readily available on the places that these channels got it from, but there are a few that did have like a family tree that they showed up on their channels. Even information exposed to just a single person results in forfeiture of a reasonable privacy interest under the third-party doctrine. And we have footnote number 22. The third-party doctrine is derived from a pair of cases from the 1970s where the United States Supreme Court carved out from the reasonable expectation of privacy standard information that an individual shares with a third party from whom law enforcement subsequently obtains that information. United States versus Miller from 1976. No expectation of privacy in financial records held by a bank. Has nothing to freaking do with DNA. Smith versus Maryland from 1979. No expectation of privacy in records of dialed telephone numbers conveyed to a telephone company. Again, not a damn thing to do with what we're talking about. Idaho's appellate courts have applied the third-party doctrine to other situations, including lab reports turned over to the health department, Mubita from 2008, and power consumption records turned over to a utility company. Again, nothing to do with this whatsoever. Literally nothing. Here, defendants' relatives did not voluntarily share their genetic information with just a single entity. They voluntarily shared it with hundreds of thousands of other participants. This is true. Consumers frequently uploaded their DNA to consumer databases like GEDmatch for the very purpose of learning and sharing with strangers the exact private information, details about their ancestry, and familiar relations at issue here. Consequently, defendant cannot claim any subjective expectation of privacy he had was reasonable. Defendant warns that applying the third-party doctrine mechanically to DNA would have deleterious results. Deleterious. I don't think I've seen that word before. He points out that DNA can reveal a vast array of private details about a person. Further, he argues it is not truly shared. He notes that when one individual provides DNA to a consumer genomic platform, the identities of hundreds of genomic relatives can be revealed through shared DNA sequences. Finally, he observes that while Idaho law protects genetic privacy in some circumstances, there are no comparable limits over law enforcement's use of DNA taken from a crime scene. Noting that DNA can be left everywhere and last in the environment for a long time, he warns that the entire population could find themselves the targets of police investigation absent some controls. Damn straight! Especially if your dumbass Hippler is out here telling everybody now that the cops violating their own rules don't matter. So, thanks a lot for that. Despite defendants' dystopian warnings, the court does not find a departure from settled Fourth Amendment principles is warranted. In Carpenter, the United States Supreme Court observed that the application of the third-party doctrine does not turn solely on the act of sharing. Other factors to consider are the nature of the information sought and any limitations on the revealing nature of the information. Doing so, the court declined to apply the third-party doctrine to CSLI data obtained from the defendant's cellular carrier. First, the court noted that CSLI data is not truly shared. It logs a cell site record by virtue of its operation without any affirmation act on the user's part beyond powering up. Second, it observed there are no limits on what CSLI can reveal about a person. Well, that's freaking kind of scary, honestly. The shared portions of DNA defendants' relatives uploaded to genetic databases do not merit the same treatments. While the court agrees that DNA can be revealing, like CSLI, such DNA was affirmatively shared in this case, unlike CSLI. Defendants' relatives did not simply reveal the information as a byproduct of the participating in modern society. They engaged in an affirmative act of uploading their DNA to public databases for the very purpose of sharing it with others. Consequently, the reasoning in Carpenter does not apply. I really wish that we had some clarification on if Kohberger actually did do an ancestry test. Now, I know that we don't have any proof of that, but that was something that a neighbor said that lived next to Bryan Kohberger at the apartment complex, that they had had a conversation where he had claimed that he had done an ancestry test. Was it sent in? Was it actually did he do what he needed to do and send the DNA test in? Was he waiting for the results? Did he already have the results? Did it not happen at all? I just find it really crazy that we had that rumor and then they haven't said anything else at all about it. There's been no proof about it whatsoever, except for the fact that we do have this family tree that a couple of channels happen to have. But then again, I just don't know. I just don't know, because I feel like if they were going to try to use an argument that the terms of service or the policies or the procedures or something were broken in way of privacy for what your expectations are when you become a client, whenever you become a customer, if Bryan would have actually taken an ancestry test, used maybe one of these databases and could prove that he had taken a test and it was his privacy that was being violated, then maybe they would have had a different argument here. But they still at this point are not admitting if that rumor was true. So we still to this day have no idea if he actually took one or not. I just know that they talked about IgG, the Goncalveses talked about IgG before we even had Bryan's name. So I have no doubt at all that they were kept in the loop about hey, we sent this off for genetic testing. But I really wish we knew more truth about if he actually did that test or not. Okay. Moreover, any suggestion that defendants' relatives preserved their expectation of privacy against law enforcement by sharing genetic information on databases that excluded law enforcement use is also unavailing. First, consent or non-consent to a search goes to the reasonableness of the search, not whether a privacy interest is objectively reasonable. State versus Maxim from 2019. Second, as discussed, a privacy interest can be lost by sharing information even with a single entity under the third-party doctrine. Even though the relatives may not have consented to law enforcement searching their genetic information, it was nevertheless shared with other members of the public, which is all that is required to remove any Fourth Amendment protections. Information that is knowingly exposed to the public, even in his own home or office, is not a subject of Fourth Amendment protection. I want to know I want to know if whenever they called this person, one of those brothers, if they told him who it was they were trying to link him to. Because I listened to a story, I think I showed you guys maybe like some snips of this one time. It's probably been like a year or so ago, but she had gotten contacted because they were trying to solve a murder or whatever. And like the way that she made it sound was that every time like they got like a closer match to the Jane Doe, it was a Jane Doe case. Every time they got like a step closer to finding out who Jane Doe was, like the cops that were getting the DNA results and stuff were like telling her who they were trying to match the DNA to. So I'm really wondering if they were like, hey, we noticed that oh, well, I guess they wouldn't have known his name then. They wouldn't have even had Bryan's name then, so never mind, that's irrelevant. But I wonder how much he shit himself whenever he realized why he got that phone call. How freaking wild. Okay, anyway. Okay, in sum, even if defendant could vicariously assert constitutional rights of others, a dubious claim at best, he has not shown that any subjective privacy right he may have had in his relative's shared DNA was reasonable. Therefore, defendant lacks standing to challenge law enforcement search of the genetic genealogy databases. 2. Defendant has no basis to challenge law enforcement's alleged violation of its own policies and those of the genealogy databases in conducting the search. Defendant next argues that even if the court were to find shared DNA falls within the traditional Fourth Amendment rules, as it has, law enforcement's alleged search of databases in violation of both the database's terms and the interim policy cries out for judicial intervention. Yeah. Hello. Defendant has provided no authority that these alleged violations of policy or user agreements bear on the Fourth Amendment. So this shithead is not even denying the fact at this point that these actual violations happened. All he says is that it doesn't matter according to the Fourth Amendment, the Constitution. None of these violations, none of these broken rules mean a damn thing. What? How are you a judge with this sort of shit in your head? Violations aren't constitutional. It doesn't matter that they broke the rules. It doesn't matter. I have like no hope for like literally anything. This is the wackiest bullshit. Okay. Again, because defendant has not demonstrated a reasonable privacy interest in his relative's DNA, defendant has no basis to challenge the propriety of the search. Rebo, and they don't say what it is. They just mention it. Okay. Second, even if he could establish a reasonable privacy interest, these alleged violations are of no significance. They're not alleged anymore. They're not alleged. Like, you're literally laying it all out for us and admitting that it doesn't matter anyway. So just stop the allegedly. We already know that y'all are full of shit. Oh, this is making me mad. Okay. With regard to the violation of the database's user policies, while this may give rise to a civil action between the FBI and the particular database, or perhaps the individuals whose DNA profiles were used, defendant has not explained how this implicates the Fourth Amendment. So if all these other people have civil cases, how is there nothing that crosses over to what we're talking about now? I don't understand. How can there be enough proof for a civil situation, but it doesn't matter about anything else? It doesn't matter. It doesn't matter when it comes to the Constitution. No problem. But you've got money, you can go to civil court. You can sue the feds for bazillions of dollars. I don't understand. Okay, let's see. Where were we now? Okay. At least one state district court has found it does not. See State versus Westrom from Minnesota District Court from 2021. Law enforcement's possible violation of MyHeritage service agreement may subject them to action from MyHeritage, but the court does not see any reason why this violation of a private company's terms would implicate constitutional protections. So in this Minnesota situation, they basically validated and verified that there was all of these policy violations and then said, what? Okay. This is stupid. This is stupid. Like, this is wild. I'm surprised my eyes are holding up. I look at this little tiny nothing freaking print like all day for work. I'm surprised my eyes have not given out by now. This is the dumbest shit. I cannot believe this. I cannot believe this. This is going to be what radicalizes me. This is so stupid. So many things have already like turned me against so many things. This just like turned me even more against things. Because now you're telling me that it doesn't matter. And there's rulings that says it doesn't matter. They can break these rules. Exactly. MyHeritage could sue over the bullshit done in this case, but the person that they did it to can't do shit about it. Can somebody make some shit make sense? Can something make logical sense? Just one thing. One thing. Just one. This is wild. Okay. With regard to the FBI's alleged violation. Oh, 1 second. I got to turn my alarm off. Okay, let's start right here. With regard to the FBI's alleged violation of its own policies or guidelines, the state currently points out that non-compliance with the law enforcement policy does not provide a basis for a Fourth Amendment challenge. So I'm just going to start breaking all the rules then. I'm going to start breaking all of the rules and blame it on this order right here saying, well, if the cops can do this, that, and the third, then I should be able to do this. Like what? This is stupid. If rules are broken in order to get to an answer, then there should be consequences for those who break the rules. It's just that simple. This is criminals being told that it doesn't really matter because in the end, the cops can lie. Actually, let me rephrase that. This is telling innocent people that it doesn't matter because the cops can lie and break rules and do everything they can to manipulate something against you. And constitutionally, it doesn't matter. This is stupid. Thank you for the $2, RV. This is the reason cops are corrupt. What a judge. I mean, seriously. And that's what makes me so mad because I really do try to say, like, I don't hate LE, okay? And whenever it came down to my situation, it was the prosecuting office, the judges that were my problem. The cops were great. The cops even came back to check on us, to apologize for allowing that dumbass to call me 20 times while he was sitting in lockup surrounded by a whole bunch of freaking prisoner people, jailer people. He was pretending to write down phone numbers, but instead of writing phone numbers down that actually he was looking up on his phone, he was messaging me on Facebook with 4 cops literally surrounding him. He found a way to write down numbers on a piece of paper and fake scroll, and instead of scrolling, he was messaging me. The cop came out to my house to apologize. Not all cops are bad. They're the bottom of the totem pole. It's these assholes that get paid to make decisions that are the problem. And then whenever they do shit like this, it puts those guys that are out on the street putting their lives in danger and even more danger because you're literally saying, It doesn't matter. It doesn't matter. Literally saying it doesn't matter. This is so stupid. This is so stupid. Thank you, Connie. Thank you for your time tonight. Much appreciated. Thank you for being here and listening to all this, because it's been a while. We're over 3.5 hours now. We still got some to go, but I'm good. I'm going to keep on going. Keep on going. Where was I? I'm sorry to hear that, RB. But then again, that doesn't really surprise me either, because I know, like, there's a mix. There's a good bunch, there's a bad bunch, and the sad part is that the majority of them that are good are scared to go against the ones that are bad, because they're going to be the ones getting punished. I know that as a fact. My sister's ex was a police officer at the local police department, and he was a jailer for a while, and he saw something. He saw a situation, and it was messed up, because he basically saw like several of the jailers beating the shit out of this guy and just left him basically like with his injuries on the floor, bleeding, throwing up. It was a scene. Okay. It was a scene. And my sister's ex was sick with this, like mentally sick. He couldn't sleep. He was physically sick from what he saw. He went and reported it, and he ended up being the one getting in trouble whenever it came to him being promoted up to patrol. Those assholes that were the ones beating the crap out of that guy and leaving him in the jail cell to just die, basically, ended up getting no punishments, not getting in trouble, no nothing. And he didn't get to get promoted into patrol. They made him wait because he came and ratted these pieces of shit that were doing this to this guy. That's the problem. That's the problem. The good guys try to do the right thing, and then they get the one. They're the ones punished. And then look right here, because Judge Hippler says it doesn't matter. Because Judge Hippler says it doesn't matter. It's so stupid. Okay. Police enforcement practices, even if they could be practicably accessed by a judge, vary from place to place and from time to time. We cannot accept that the search and seizure protections of the Fourth Amendment are so variable. Number 23, no, to number 24. See also State versus Lancaster, noting that suppression of evidence is a court-created remedy to ensure compliance with constitutional standards, not statutes. I'm so tired of all these different words and stuff. Stop making everything so stupidly complicated. Make things simple. You do something stupid, you get in trouble for it, no matter who you are. But you got to prove it. You got to prove it. This is just so ignorant. Where's that little number? Okay. In addition, the interim policy at issue here expressly states it is intended to provide internal guidance only and does not create any substantive or procedural rights or benefits or impose any legal limitations on otherwise lawful investigative techniques. Therefore, violation of its terms cannot alone give rise to a Fourth Amendment challenge where, as the court has already found, the search of the databases was otherwise lawful. No, it wasn't. You literally admitted in this exact same order that the FBI searched databases that they were not allowed to search. That they tried to use the interim policy as the reason for it. But even honestly, with the wording that you yourself put in here, Hippler, not even that covers what happened here. This is dumb. Suppression, therefore, is not warranted with regard to the database search. Based on the foregoing, the court denies defendant's motion to suppress genetic genealogy. And there it be. How disgusting. How disgusting. Okay. I am going to go to the next one. That was the IGG, right? Okay, so here's the AT&T one. I'm not reading all of this. I'm not going to read, I'm probably going to read the introduction. And let's see. Not the standard. I'm going to read the finding of facts. and then go into the AT&T warrant information. I'm going to read up until we get to where they start talking about case fact again. Still a super lot. But that's fine. Right here. This stuff right here. Yeah. I'm not going to read any of this. So for this one, we're going to go to page 13. But we're taking a break. I'm going to put a thingy right here that we're taking a break because I need something else to drink. This water is almost gone. My coffee's gone. I need something cold. So I'm going to put a little thingy right here on the banner. Hide. I don't know why I have to hide it in order to edit it. It's kind of stupid. Okay, so I need to cut this and then, okay. Taking a break. Okay, I'm just going to put it like this. I'm going to go get something to drink. And I will be back in like 3 to 5 minutes. And then we're going to start reading this stuff. The facts. Because I want to get to the part about a vacuum. 9 minutes and homeboy brought a vacuum. I don't quite comprehend. So we're going to figure that out. We'll be back. Y'all go refreshments, hydrate, all the things. I'll be back. Okay. You guys ready? Let's get started. Now, again, we're only going to page 13 on this one. And if there's anything else in like the case law stuff that I find reading it separately myself off camera, then I'll do like a little video about it if it's important. Okay. This is order on defendant's motions to suppress regarding the AT&T information, Google, the USB, which is the forensic download of his phone, Apple, and Amazon. Okay. Introduction. Some of this is going to be the same, but then it's going to also go into like different wordings for the warrant itself before we get to the facts of the like the factual findings. Okay. Introduction. Defendant is charged with 1 count of burglary and 4 counts of murder in the first degree in connection with the stabbing deaths of 4 University of Idaho students in the early morning hours of November 13th of 2022. As part of law enforcement's investigation, the Federal Bureau of Investigation, FBI, issued federal grand jury subpoenas to Apple Inc. and Amazon to obtain information from accounts linked to defendant. The FBI provided responsive information to detectives from the Moscow Police Department who requested and received, I think I can make this a bit bigger. So here we go. Yeah, that's a lot better. Okay. Okay. Who requested and received search warrants for the Apple and Amazon accounts. In addition, detectives sought and obtained search warrants for defendants' Google accounts, a USB drive containing defendants' cell phone data, and for information held by defendants' cellular carrier, AT&T. Before the court are defendants' motions. Where did my chapstick go? 1 second. I'm going to make sure I have all my stuffs. Did I put it in my pocket? No. I'll just use glitter. You know, my daughter told me one time. I put my lip gloss on like this in the car one day. Like I close my lips around it. This is just a side note. I go like this. She looked at me and she looked at me with horror. And she said, I thought you were perfect. Why are you putting your lip gloss on like that? It was just the funniest shit that I remember in my head. Like her face, because of how I put my lip gloss on. Like it's easier. That just reminded me of that. Okay. Let's see where we were. Okay. Before the court are defendants' motions to suppress the information obtained through the subpoenas and the AT&T, Google, Apple, and USB search warrants. Defendant argues the FBI's issuance of the subpoenas constituted a warrantless search that violated his privacy interest under both the Fourth Amendment and Article 1, Section 17 of the Idaho Constitution. Let me change this banner real quick. Back to what it was. There it goes. Okay. Let's see. Okay. He further argues that the search warrants failed to command a search or lack particularity. And now we have our first footnote. Defendant also argued that the AT&T, Apple, Amazon, USB, and Google search warrants were invalid under Franks versus Delaware due to claims of recklessly or intentionally false or omitted material information and or because they are based in law enforcement's allegedly unconstitutional use of investigative genetic genealogy. On these arguments, defendant incorporated by reference his arguments in his motion for a Franks hearing and his motion to suppress regarding genetic information. The court incorporates herein its rulings denying both motions. Consequently, this order only addresses the arguments still at issue. Okay, well, let's continue. The state responds that defendants relinquished any privacy interest he had in Amazon and Apple materials and further contends the remaining warrants are proper and sufficiently particular. Oh, RV. Thank you for gifting those memberships. RV, keep it rolling. I want an RV and I want to keep it rolling. I'd love to get an RV and just travel everywhere. No way. Are you serious? Did he just do something on News Nation about this right here, Jake? Oh yeah, Sally. No, I know, but I don't. It's not brothers to Bryan. It's like the four people that they identified are brothers, and they called or tried to contact one of those brothers, but it's not Bryan's brothers. It's just people that are brothers. Like it's four actual brothers that are brothers to each other that have a low genetic match to the sheath DNA. But that did trip me up for a minute. But again, thank you, RV, for the gifted memberships. That's very sweet. You still have the RV? At least you still have it. That's pretty cool. You kept it with your name, though. It's a part of you. Okay, let's see where we are. Where are we? Okay. The state responds that defendants relinquished any privacy interest he had. I think I read that part. Okay. A suppression hearing on the portion of defendants' motions at issue in this order. Here's another footnote. They sure like to interrupt, don't they? Number 2, evidence and argument on the Franks motion and IGG motion were heard on January 23rd, 2025. The balance of motions to suppress was taken up the following day. Okay, like we know. We were there. We saw it happen. Okay. Okay, so the suppression hearing was held on January 24th, 2025, during which the court received testimony from Detective Corporal Brett Payne and Detective Lawrence Mowry, both from the Moscow Police Department. The court found both detectives to be credible and reliable. Following argument, the court took the matter under advisement. The court finds suppression is not warranted because 1, defendant relinquished any privacy interest he had in the records subpoenaed from Amazon and Apple pursuant to the third-party doctrine, and 2, the remaining search warrants are valid. Sure. Standard. The standard of review of a motion to suppress is bifurcated. Oh, hold on. Nope, I'm not reading that. That's the same stuff from last time. Finding of fact. This is where it's important. We are instantly on a footnote. Instantly. At a footnote. Oh, you're saying that the actual 4 brothers. Sally said, look up Kohberger's obituary. He has 4 surviving brothers. Oh, so you're talking about the actual 4 brothers that were actual brothers that were found on there. And look, okay, I never really dug into the Kohberger stuff because I know for a fact that man had mental illnesses. Okay, there's no ifs, ands, or buts about it. There was something wrong up here. Okay, there was body cam footage of instances, or at least one instance that happened before this, where he's like imagining all kind of crazy stuff happening, imagining people doing things to him that there's no proof of. He sounds like something is mentally not right. Okay, so I never got into all of the insanity when it came to Kohberger. But I'm not going to sit here and pretend like I don't remember that Judge accidentally said what he said one time. Because there's no reason for Judge to have ever had a slip up of Kohberger's name when speaking about Kohberger. Because the situation in the instance that happened with Kohberger didn't happen in Judge's jurisdiction. So I guess what I really want to know is if that slip up of him accidentally stating what he said and correcting himself, was that before or after he did the in-chamber or in-camera review of the DNA information? So I don't know. Are you talking about the dude that apparently got the call from the cops that day? Like the one that's been on interviews everywhere, or a different friend, Tara? I could have sworn that like the one guy with the beard or whatever, like came out and was just like pissed off. Everybody thought that he could have been involved. Noble said if Kohberger has 4 brothers and was military in both Paynes and both Paynes were on the squad, that ended him. The dots are connecting, especially with that knife thing. It was a different guy. I'm gonna have to look it up. Man, am I gonna have to like actually look into this Kohberger stuff? I'm telling you, like I've tried my damnedest not to go there. Because honestly, like up until I guess really like this, like I mean, I understood why people were looking into it, but I can't listen whenever people are trying to say that they have proof that he stopped at Brett Kopacka's house on the way to Moscow or on his drive or whatever the hell they're trying to say, that at some point when Bryan left his apartment before he went wherever he went, that he stopped at Kopacka's apartment. There's no proof of that. There's no proof that he like stopped there and did anything, especially since we know now that the PCA stuff is like wrong. It's wrong. There's no way that the 7-minute difference between what the feds claim the time is his phone went off network and what MPD put in there is the only thing wrong. Because we also have the other one that's 2 minutes different of a left turn or some shit like that. Patricia Presley gifted 5 memberships. Thank you so much. Y'all, you guys are awesome. And congrats to the people that end up getting the memberships. That's great. I know. Like, don't think I don't think about it. Like, I think about it. I just don't come out and talk to y'all about me thinking about it. I think about it to myself and tell myself that I'm thinking about it. Like, I know it's difficult, especially with like the timing that it happened and Bryan leaving town and the Indiana stops. Like, I have thought about it. Man, we're going to have to talk about this. Shit. Well, I'm going to end up doing it in a very different way than a lot of people have, because I don't appreciate it. I don't appreciate the insanity that comes into situations whenever people get into theories and they just go wackadoodle and dox everybody and everything, and they just go too far and go crazy. I have to come at this like completely differently than I've seen other people do it when it comes to Kopacka, especially since he's military. I'm going to be honest about it, but I'm going to have to come at this a little bit differently than I've seen people do it. I mean, I don't know if there's proof that Bryan picked off Brent, but there's definitely a hell of a lot of weird coincidences. Yeah, Darren Duncan. Well, okay, so yeah, Darren Duncan was the one that defended him, but Tara's saying there was another one. Okay, yeah, no proof. Right, there's no proof. But it's coincidental, crazy stuff. What would be the reason? It's the reason. See, that's the problem. Wackadoodle. Thank you, user M. I'm gonna have to. We're gonna have to talk about it, if not to just exclude it. Five more memberships. Holy crap. Thank you, RV. You guys are great. I love how y'all gift each other things. That's awesome. Yeah, I'm gonna have to. We're gonna have to. I know. I know. Everything with Kopacka is wild. We're gonna have to. We're not gonna have a choice. All right, let's get back to this, because I'm not gonna have any time to go do the Kopacka thing until we get through all the court things and figure out what's going on here. Okay. And it's crazy because I literally just had time to do videos on like a couple other cases and didn't even get the chance to post them because we had this come out. I wasn't thinking it was going to come out just yet. So we're gonna have to. We don't have a choice. If even, like I said, just to exclude it, but I'm gonna have to come at it a different way. I'm not gonna come at it with a whole bunch of rumor and stuff that's not proven and a bunch of crazy. Like, we've got to be as factual about this situation as possible. We're gonna have to. 7 a.m. in South Africa. It's 11 p.m. in Texas. Good morning. Oh, Meckles, you got it. You got it, baby. You're green. You accepted it. Your account accepted it. You are green. Man, thank you for reminding me. Patricia said, do you think there's any truth to the person showing up in North Carolina and talking to the cops there? You mean in dropping names? Oh, yeah. No, that's crazy. I don't know if there's any connection or truth to it. I know that I saw a person talking about it. I think it was Tell It to L's channel had it. And there was these 2 documents that were shown on there, but I'm trying to, I have it on my notebook. I mean, I've got a notebook of, this many things I want to talk about. Yeah, no, I'm going to be looking into that one because that's wild. I don't know how the hell we've gone this far. And I literally just like found out about that like a week ago. I think I actually mentioned it. I think I mentioned it in a live, maybe last Thursday's live. I maybe talked about it. I know. Like he walked into like a sheriff's department, or he walked up into a courthouse or some shit. And just like started giving names and connections and talking about like the guy uses a dirt bike and is like, he commits crimes all the time and gets away with it because he parks a dirt bike or an ATV somewhere, walks back and forth to the crime scene to where he has the freaking dirt bike and shit. And I'm like, what? Yeah. It's insane. I'm definitely interested in that. I'm just floored. I didn't know about it until like recently, but into the sheriff's office, there's a bunch of it redacted. I mean, I just saw the 2 little pieces that she had on there, but I was like, what? It's so difficult trying to just go through. Yeah. And then, he was claiming they were trying to frame him and he was dropping like women and men's names. Shit, man. We're going to go down all the rabbit holes ever. And I think down the rabbit hole to hell is in here. So it's perfect for how this night's going because we're going to end up having to go through all kinds of insanity. Okay, let's get back to the subject at hand because like I said, we're not going to be able to move on past anything until we get past all this insanity first. Okay, finding of facts, and it already has a footnote. The court's findings are based on suppression hearing testimony provided by Detectives Payne and Mowry, as well as the following documentary evidence. For first AT&T warrant, Defendant's Exhibit A attached to reply to state's objection to defendant's motion to suppress and memorandum in support regarding AT&T first warrant from December 19, 2024, admitted as Exhibit S2. S2.1 at suppression hearing, and states exhibits S1 and S2 attached to its objection to defendant's motion to suppress and memorandum in support regarding AT&T first warrant from December 6th of 2024. That's the first AT&T objection. I don't think I need to read all this. This is literally just names of documents, and we've literally read the guts of these documents. So I don't think we need to read that footnote. I'm just saying. Okay. I need a drink first. I honestly never thought that I would like these waters. But we don't buy soda, and I like bubbly things, and so we found them, and now that's like all we buy. See, look. You're where you're supposed to be. All this insanity. Man, where's my Post-its? If I had my Post-its up, then I'd remember all of that wild stuff. Yeah, that North Carolina thing is... Okay. On November 13th, 2022, an officer from the Moscow Police Department responded to a residence located at 1122 King Road in Moscow, Idaho, where he discovered the bodies of Maddie Mogen, Kaylee Goncalves, Ethan Chapin, Xana Kernodle. Each appeared to have been stabbed to death. The investigation that ensued was a multi-agency affair involving members of the Moscow Police Department, the Idaho State Police, and the FBI, among others. For purposes of the investigation, a command team consisting of several investigators from each of these agencies was set up at the Moscow Police headquarters. Exactly, a command team. So if you are part of the command team that is actively investigating the case, then how is anything that you come up with a tip? You cannot sit here and say that they are part of a command team and then think that all of this stuff can be considered a tip, and that's why no warrants and no information is needed. Full of crap. Full of shit. Full of shit. They're part of the team. Full of shit. The command team included, among others, Detective Brett Payne and Detective Lawrence Mowry of the Moscow Police Department, as well as Special Agent Nicholas Balance of the FBI, all of whom were co-located on the second floor of the Moscow Police Department. The command team met twice daily for several weeks to review, analyze, and organize the information gathered in the investigation. You're meeting together twice a freaking day? Okay, Tara. Thank you. I'll go check it whenever I get off of all of this. I'll check it. Again, they're a team. It ain't a tip. This is stupid. And again, the co-location on the second floor of the Moscow Police Department. So they're not only part of the exact same team, assigned to the exact same team, like a tip comes from an outside source, right? Like a tip comes from an outside source. A tip comes from somebody calling something in, sending in an email, giving you a clue to something, and then you have to take it and you have to go and investigate it. A tip does not come from somebody actively investigating the case. I've been saying this for so long, and I just don't understand why they don't think that way. I guess it's like my brain works. I feel like their brains don't. I don't understand how they can say that. It doesn't make any sense to me. The FBI was not just like sitting over in Virginia waiting for, them to get asked for assistance. They were physically at the location. They were meeting together twice a day and literally hitting elbows at the desk because they were literally sitting next to each other. Okay. Like Payne was across apparently like across the way from where the lab was. But according to what Mallory said, Mallory and Balance like shared the same office space as far as I can remember. Give me 1 second. Anyway, I don't see how they can keep saying that. Because this is just like validating even more that this was not a tip. This was not a tip. Pertinent information was transmitted into a working probable cause affidavit that could be and was incorporated by law enforcement into their various search warrant affidavits. All investigators had access to the search warrant affidavits issued during the investigation. Among the initial search warrants sought in the investigation were two to AT&T, the cellular carrier, for a phone number that law enforcement had linked to defendant. Detective Payne applied for and received both warrants on December 23rd, 2022. You notice he never says his name? He never says his name. He just calls him defendant, not the defendant, but defendant. Like defendant is his name, which is a bit strange. Detective Payne applied for and received both warrants on December 23rd, 2022. As Detective Payne was not an expert in cell phone data, he relied completely, upon Agent Balance, who is a member of the FBI's Cellular Analysis Survey Team, or CAST, and specializes in cell records and analysis. Agent Balance aided Detective Payne in both drafting the search warrant affidavits for AT&T warrants and analyzing the returned information. Honey, he didn't aid Payne in anything. He told him the answers. See, aiding means helping, meaning you're not doing everything yourself. There's multiple people, multiple things coming together and all congruently helping each other do something. That's what aiding is. Balance did not aid Payne in anything. He gave him the answers, and Payne had no educational background in order to be able to fact check what Balance was telling him was accurate, which is probably why we have a 7-minute difference on the network stuff. Whose is right? We don't know. Will we ever know? Probably not. Within a week of obtaining the AT&T warrants, law enforcement obtained a warrant for defendant's arrest. The arrest was effectuated on December 30th, 2022 at his parents' home in Pennsylvania. At that time, law enforcement seized defendant's cell phone pursuant to a search warrant for the home. To preserve the phone's data, the FBI copied the contents of the cell phone onto a USB drive, but did not review the contents. Liar. You really want me to sit here and think that they downloaded shit off of Bryan's phone and didn't look at it? You funny. Law enforcement also had a warrant to search defendant's vehicle, which was located in the garage of his parents' home. During the search of the vehicle, a receipt for an Apple iPad was found. Who cares? Who cares? A receipt from how many years ago? Was it 2016? 2016, right? Who cares? Following defendant's arrest, the FBI obtained and served 2 federal grand jury subpoenas, one to Apple Inc. and one to Amazon Inc. In addition, Detective Payne and or Mallory obtained search warrants for records from Google Inc., Apple Inc., Amazon, and for the contents of the USB drive. Are they going to mention that the feds drafted some sort of letter to preserve shit over to Apple before they went into the Kohberger house? Because according to Payne, they had no idea, Moscow had no clue that an iPhone or an Apple product or anything Apple related was connected to this case whatsoever until they went in and saw the iPad in the common area of the Kohberger home. So he better have something in here about how the feds drafted a letter prior to them ever entering that house, because Payne already said it on the stand. They had no clue that Apple was involved in this situation until they got into that house. So how are they going to explain that letter? Oh, well, he does mention it right here. Is he going to mention how it doesn't make sense for them to have been able to know to file it? That's the whole point. Is he going to make a big deal out about it? Or is it okay because they're the feds and they can break the rules and lie? Payne already blew their cover on that one. Following defendant's arrest, the FBI obtained and served 2 federal grand jury subpoenas, one to Apple Inc. and one to Amazon. Well, that's not the same thing, I guess. Okay. In addition, detectives Payne and or Mowry. No. You don't get to do that. You don't get to do that, because you know why he's doing this? To save his ass? Because we have physical proof in the search warrants that both of their names are on these things. Like, it has like one person being the one in the format that's requesting it, but then everything is like signed and done by the other guy. I can't remember which one it was, but we pulled it up and we went physically through it, and I showed you guys this already. And I was like, wow, I guess I didn't realize that, because I didn't realize it until it was talked about in court. I mean, we probably talked about it a long time ago, but we don't always go through those search warrants all the time to catch stuff that we might have missed. So he can't just sit here and say and or Mowry. That's the way that he's just like glancing over the fact that they copy and pasted a bunch of bullshit and were too stupid to learn how to get it in order. Stupid. Okay. Anyway, obtained warrants for records from Google, Apple, Amazon, and the contents from the USB drive. First AT&T warrant. The first AT&T warrant Detective Payne applied for sought 9 categories of records associated with defendant's cell phone. 1, customer subscriber information. 2, device purchase information. 3, associated email addresses. 4, call detail records. 5, cell site information. 6 is what now? Cell site locations. Okay. 7, location information for the cell phone. 8, text and MMS messages, picture messaging, media messaging. And 9, cloud data. First AT objection from Exhibit S-1 is where they're getting that information from. Each of these categories was narrowed by a detailed description of the specific information sought. The information requested was temporarily limited to a 48-hour period, November 12, 2022 at midnight through November 14th, 2022, midnight, 2 days. In his, okay, make sure it's PST on both, because, you know, they've been playing with some time zones. I'm just saying the time zone stuff is not good for my brain. For some reason, I'm not good at time zones. In his accompanying search warrant affidavit, Detective Payne set forth in detail the circumstances of the crime and the scope and results of the investigation as of that date, including evidence linking defendant to the suspect vehicle seen on surveillance videos around the times of the murders. Detective Payne indicated how each of the categories of information sought would aid the investigation, including in determining whether the phone's activity was consistent with the suspect vehicle's route of travel as seen in the surveillance videos, whether the phone was in the vicinity of the murders during or prior to its occurrence as part of the planning of the crime, and why defendant's phone was not reporting to the network during the estimated time the crime occurred. And now we have number 4. An earlier search warrant had revealed that defendant's cell phone did not appear to be reporting to the network for the hour before and hour after the homicides occurred. So what? If he went the direction they're claiming he went, it's because he literally had no service. No service whatsoever. Based on Detective Payne's search warrant affidavit. And again, why are we even using this Hippler? If, what's his face? Thompson? If Thompson said that this affidavit is like No longer relevant. Like, I'm pretty sure no longer relevant or irrelevant, something along those lines, is what he said about this thing. Why are we still going back to it when it comes to court decision? If it's already on record that Thompson doesn't even think that his own probable cause order is valid anymore, why is he going back to it? Why is he going back to it? He shouldn't be allowed to. I'm going to have to go back and find exactly where Thompson said that shit, because he said that shit. Based on Detective Payne's search warrant affidavit, the magistrate issued a search warrant for the records sought therein. The warrant stated in relevant part, Brett Payne having given me proof upon oath this day showing probable cause establishing grounds for issuing a search warrant and probable cause to believe property consists of certain evidence regarding the investigation into the crimes of homicide at 1122 King Road in Moscow, Idaho, is on the AT&T account associated with the phone number 509-592-8458 between November 12, 2022 at midnight and November 14, 2022 at midnight. And that's the exhibit. The warrant then set forth each of the categories of information defined by Detective Payne in his search warrant affidavit. It was served by Detective Mowry upon AT&T via email. Served upon AT&T. We must be in the medieval king castle days. As was Detective Mowry's practice, he did not include Detective Payne's search warrant affidavit with the warrant when serving it. AT&T emailed a return of the requested information back to Detective Mowry later that day. The returned information was immediately turned over to Agent Balance for review and analysis. In reviewing the information, Agent Balance had access to and knowledge of Detective Payne's search warrant affidavit supporting the first AT&T warrant. But why doesn't that have to be sent over to the company that you're sending the search warrant request to? Like, how come it doesn't have to be attached? Why is that okay? I don't understand. Like, everything should have to be included. Unless it's like too much investigative information going out into a public entity. Maybe that's why. I don't know. I have no idea. Okay. AT&T pin trap and trace warrant. Within hours of receiving the return on the first AT&T warrant, Detective Payne applied for a second warrant to AT&T, this time to obtain records associated with defendant's cell phone number for the prior 6 months, as well as for the installation of a pin register and trap and trace device for the number. Now there's number 5. PIN registers capture the outgoing phone numbers, email addresses, and other dialing or routing information transmitted by a cell phone. Trap and trace devices capture similar information that is received by the phone as in incoming. Okay. Where'd it go? Where'd the little number go? Okay. And Exhibit S-1 to pin trap objection is what they're getting that information from. The records sought were call detail records with cell sites for all voice, SMS, and data connections. These records were further defined to include subscriber account information, device identifying information, usage and location information to include cell site positions information, addresses of cell towers used by the device, and subscriber identity information for customers who contact or are contacted by the device. Again, Detective Payne's search warrant affidavit set forth in great detail the circumstances of the crime and the scope and results of the investigation as of that date, including an analysis of the data received from the first AT&T warrant. This information, according to Detective Payne, showed that the estimated locations for defendant's cell phone during the 48 hours before and after the homicides were consistent with the movement of the suspect vehicle seen on the various surveillance videos. No, not if it's cut, copy, pasted, manipulated, stitched together. No, especially if you've got a turn where this car is going left happening 2 minutes after his phone actually makes that similar movement. No, it does not add up. You manufactured it. You took pieces that fit what his phone apparently was doing tower-wise, because if you go that way and you have no service, it is reaching to the farthest depths possible to get a cell phone signal. One of the things that we learned here that really bothered me about how this shit works is that depending on cell traffic, you could be traveling one way, but because there's no way for your phone to truly connect, at least not in like a good enough way for your phone to connect to the towers in the direction that you're going. The towers could go left, they could go right, they could go behind you. Those are the ones that your phone will connect to, even if you're going forward. Because if there's nothing for it to connect to forward, it's going to grab onto whatever it can, no matter the direction it is from where you're going. So none of this means anything to me now that we found that out. That whole thing right there makes all of this phone shit completely irrelevant. To know that the phone is basically struggling for air, okay? This is basically a signal searching as far as it possibly can to grab something, literally grasping for air. It's grabbing onto anything. It can grab onto a tower 5 miles past where you just were and have no intentions to ever go through again. But that's where your phone is going to stay connecting, even if you're going the opposite direction, if it has to. And if he really was a direction where even reporters from Court TV have stated on their news broadcast that there's no service out that way, that they had to come back into Pullman in order to even get on TV because there's no service. So if he really was somewhere where there was no service, don't you think his phone would be trying to grab at all these towers and all these different places? That's what it's designed to do. That's literally what it's designed to do. Now let's read his copy and pasted training and experience. So stupid. Based on my training and experience and the facts of the investigation thus far, I believe that Kohberger, the user of the 8458 phone, was likely the driver of the white Elantra that is observed departing Pullman. Likely. It's all guesstimates, estimates, likelies, and because I said so's. Seriously. Y'all know this. Y'all know this. Let's see. Was likely the driver of the white Elantra that is observed departing Pullman, Washington, and that this vehicle is likely suspect vehicle 1. Additionally, the route of travel of the 8458 phone during the early morning hours of November 13th, 2022, and the lack of the 8458 phone reporting to AT&T between 2:47 a.m. and 4:48 a.m. is consistent with Kohberger attempting to conceal his location during the quadruple homicide that occurred at the King Road residence. No, not really. As a result, I am seeking historical CSLI from June 23rd, 2022 to current prospective location information and a PIN register, trap, and trace on the 8458 phone to aid in efforts to determine if Kohberger stalked any of the victims in this case prior to the offense, conducted surveillance on the King Road residence, is in contact with any of the victims' associates before or after the alleged offense, any locations that may contain evidence of the murders that occurred at November 13th, 2022, the location of the white Elantra registered to Kohberger, as well as the location of Kohberger. Well, guess what? Guess what? It didn't prove this. It also did not prove this. It proved nothing. It proved nothing. Nothing at all. Well, thank you for the membership. Gifting RV. Thank you. Congratulations to whoever gets that one. That's awesome. Thank you. But yeah, this didn't prove anything. This did not prove surveillance. This did not prove stalking. And just like the traffic stop isn't there to prove those things either. The traffic stop is there to prove identity, phone number, address, and car. Nothing is proving anything. Nothing is proving anything. A search warrant for the information requested by Detective Payne was issued by the magistrate later the same day. The warrant stated in relevant part, Brett Payne having given me proof upon oath this day showing probable cause establishing grounds for issuing a search warrant and probable cause to believe there are records related to the crimes of homicide at 1122 King Road in Moscow, Idaho, and are currently under the control of AT&T for historic call detail records for the telephone number of 509-592-8458 with cell sites for all voice, SMS, and data connections between June 23rd, 2022 to present. And that's in the States Exhibit. States Exhibit? Yes, States Exhibit. The warrant then set forth each of the categories of data outlined by Detective Payne in his search warrant affidavit. In addition, the warrant authorized investigators to install and use a PIN register, trap and trace device, and cell site simulator in accordance with IC 18-6719. Once issued, Detective Payne sent the pin trap warrant to the FBI for service since the FBI hosted the pin register portion of the warrant. So they had to ask AT&T permission for the feds to do something? That's wild to me. Why don't you just ask the feds to do it? Why do you have to get... See, so you don't have to get a warrant. This is going to make me so mad. You don't have to get a warrant for Othram. You don't have to get a warrant for the feds to do their boo-boo. You don't get a warrant for the trash can. But you got a warrant that served to AT&T just to turn around and have it actually be the feds being the one that actually does it? This is dumb as shit. Dumb as shit. Dumb as shit. Agent Balance then served the warrant on AT&T on behalf of the Moscow Police Department. Detective Payne's search warrant affidavit supporting the pin trap warrant was not served with the warrant. However, the return was provided to Agent Balance, who had access to the search warrant affidavit in reviewing the return. Blah, blah, blah. We already know. You know why? You know why he had access, Hippler? Because he was a part of the active investigating team. Nothing was a damn tip. Google warrants. Detective Mallory applied for and was issued 3 different warrants for Google Inc. between January 3rd, 2023 and February 24th, 2023. Each of the 3 warrants began with the following language. So they didn't even bother looking up anything with Google until after they had him. Like they had from the 19th to like the 29th, where they could have filed all of these warrants and gotten all these things done ahead of time. Why did they wait? Why did they wait? I guess they really thought that they were going to probably like bust into his parents' house and find like the weapon and like clothes hidden away or some crazy shit. Dumbasses. Okay. Detective Mallory applied for it, was issued 3 different warrants, blah, 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 blah. Here's the language. Lawrence Mallory, given me proof upon oath this day showing probable cause, establishing grounds for issuing a search warrant, and there is probable cause to believe that the property referred to and sought in or upon said premises consists of information related to the investigations into the crimes of homicide at 1122 King Road, Moscow, Idaho, on the Google account of Bryan C. Kohberger. And then exhibits A through C to Google Motion. Each warrant requested information in connection with email accounts, phone numbers, and International Mobile Equipment Identifiers, IMEI, numbers that the investigation had revealed were associated with defendant. The Google warrant issued January 3rd, 2023, which is Google Warrant 1, requested business records and subscriber information in connection with Brian Christopher 1994@gmail.com, plus 2 phone numbers and an IMEI number. The Google warrant issued January 24th, 2024, Google Warrant 2, requested business records and subscriber information in connection with username spelled funny @gmail.com. The Google warrant issued February 24th, 2023, Google warrant number 3, requested data in connection with all Gmail accounts linked by recovery email, cookie, Android ID, creation IP, or phone number associated with all of the accounts listed in Google Warrants 1 and 2, as well as for BK5781@desales.edu. I don't understand what made them think that they could ever file a warrant to Google for a .edu address. Like, they should have already known not to do that. Each of the 3 warrants were temporarily limited to January 1st, 2021 through December 30th, 2022. In addition, all 3 warrants listed the following 16 specific items to seize: Google account subscriber information, Google account recent activity logs and connected devices, Google email messages, Gmail, including drafts and those in the trash, Google Pay, account information and transactions, calendar events, contacts, people and contact files, photos, photo albums, photos, videos, albums, associated metadata, Drive, documents, spreadsheets, presentations, files, and associated metadata, Keep, titles, and the notes, Hangouts and chats, messages, including attachments such as photos, location history, location data and deletion records, my activity, searches and browsing history, including activity from web and app activity, Google Assistant and Google Home, Google Voice information, including Google Voice basic subscriber information, call logs, forwarding number, text messages, voicemails, YouTube, registration email, channel ID, display name, IP logs, and account registration information. Android, records for Android devices, to include subscriber information, other associated accounts, cellular, carrier information, and device hardware information. Google Play purchases made, and Google Play applications downloaded. These warrants were each supported by search warrant affidavits executed by Detective Mowry. In these affidavits, Detective Mowry set forth a statement describing in detail the scope and results of the investigation to date, how the accounts and phone numbers identified in each warrant were discovered, and how they were connected to defendant. He also included a detailed explanation as to how Google works and why each of the 16 items listed in the warrants could be relevant to the investigation. Upon receiving each Google warrant, Detective Mowry served it on Google electronically, through its law enforcement portal. As was his practice, Detective Mowry did not serve his search warrant affidavit in addition to each warrant. The returns for each Google warrant were submitted to law enforcement as a digital file available through Google's law enforcement portal. Detective Payne downloaded each return upon receipt, after which he prepared a receipt and inventory of warrant. Detective Mowry then reviewed the downloaded material to ensure it contained information for the correct accounts identified in the warrants before disseminating the returns to other investigators in the command team to process. Each member of the team had access to the search warrant affidavits supporting the respective warrant. Thus, in processing the returns on the 3 Google warrants, the reviewing investigator was able to refer to the particular search warrant affidavit. So, I mean, Google, I don't really see anything in any of that. I mean, they're going to file warrants. They're going to get information. The problem is that none of this stuff brought any results of anything. So they did all of this, and they can still sit there and say in court that there's no connection to him, that they don't have any proof that he was stalking anybody, watching anybody, going on social media, doing nothing crazy. Nothing. Thank you, Kayla. Thank you for the $19.99 super sticker. Thank you. Did you check out the link I posted in the chat earlier? No, you can't post links in the chat. It doesn't let anybody post links but me. YouTube doesn't let you. Oh, good night, Canada. Canada A. Good night. I mean, we heard all of this. And again, like I said, they have nothing. All of this was for what? The state themselves has even said nothing. Nothing there. Okay, let's go to D. USB search warrant. This is the forensic download of his phone. I am laughing so hard at the fact that he's like, oh, they downloaded it, but they didn't look at it. Yeah, they did. Last somewhere else. After the content of defendant's cell phone was copied into the USB drive, but not reviewed, I love how he thinks that he actually has the proof of that. I love how he thinks he actually has the proof of that. Well, it doesn't let me copy you. Can I copy this? Hold on. I can't even copy that. Okay, so in StreamYard, whenever I click on y'all's stuff to pop it up on the screen, like it's blue for me. And if I click back over it, it just tells me hide. And then it goes gray. I click back on it, it just says show. Like it doesn't let me copy and paste anything. So that sucks. But I'll If you're still in here, whenever I get to it, type it in there and then I'll type it in and we'll look and see. Because, yeah, that's going to be kind of crazy. Because, again, I don't know how they're going to sit here and say that she saw anything that looks like a vacuum, trying to say that the assailant is the one that cleaned up the scene whenever this person was only apparently doing all these things for like 7 to 9 minutes. No. Oh my God, he really was on the news. Oh my God. I can't deal with him tonight. I'm not dealing with you tonight, Steve. Just not going to do it. Not going to do it. Okay. Again, I don't know how Hippler can sit here and try to say not reviewed because he wasn't there. He doesn't know shit about shit. He does not know. Especially if they were in the house with the family being held at Pew Pew Point. Okay. And we don't know what the hell happened for all that time. We have no idea. We don't know what they know. We don't know what they looked at. We don't know that. And he doesn't know that. So he cannot sit here and say that to just try to save somebody's ass. They don't know that. He doesn't know that. Literally at all. The USB was sent to Detective Mowry, who stored it in the forensics lab at the Moscow Police Department. Detective Mowry then applied for a warrant to search the contents of the USB. In his search warrant affidavit, Detective Mowry set forth in detail the circumstances of the crime, the investigation to date, and his probable cause to suspect defendant's cell phone contained evidence of the homicides. Okay, so I've decided right now, I'm not reading all this stuff. You know why? Because we already did. We read through every single one of these already. We know exactly what Payne and Mowry said and what they asked for. So I'm not reading none of this stuff. Location, all this stuff. Like we know, okay? The USB warrant was served by Detective Mowry in person at the forensics lab. Remember they had to file a search warrant to get something that they already had in their own possession. But, no warrant for any of the DNA work. Make damn no sense. The USB warrant was served by Detective Mowry in person at the forensic lab. He then obtained the USB and prepared an inventory documenting his seizure of the USB and Bryan Kohberger's phone data. He submitted the return to the magistrate who, in a subsequent order, authorized the property to be delivered to any person or laboratory or laboratories for the purpose of conducting or obtaining any test, analysis, identification of said property, etc. The data on the USB was subsequently processed by other investigators on the team, all of whom had access to Detective Mowry's supporting search warrant affidavit. But did they open it? Like, do they have to actually, open it, acknowledge it, go over it, check it out? Do they have to prove that? Apple subpoena and search warrant. The FBI served a federal grand jury subpoena upon... Ooh, there it is. Nope, that's not it. That's not it! Ooh. Oh, it might be right here. I'm going to say he better have something. He probably doesn't. I'm going to say it again. We found out that the feds asked for Apple to preserve information at some point on some sort of letter. And according to Payne, they had no clue that an Apple product was involved in this investigation until after they went into the house in Pennsylvania and saw the iPad in the common area and had the receipt in the car. Until then, they had no clue, but then we have a letter from the feds dated way before they ever even went into that house. That needs to be answered for. Okay. Now we have a 6 footnote. The FBI subpoena is not in the record. Holy crap. So they don't even have a copy of it? So they served the subpoena to the federal grand jury, but they don't have a copy of it in the record. Good night, Divine Pathways. Good night. Yeah. Like what? So you have proof that that it was given to the grand jury. There's not a packet of shit that comes discovery wise. Hey, this is all of the evidence that was submitted to the federal grand jury. But why not? How can they even talk about it if it's not in the record? That's stupid. And how come they haven't been able to get one? Oh, yes. I've done a lot of cleaning up blood. Whole lot. And I've had to do it in ways that most people don't. So there's that. Yeah, I don't know. I mean, it's insane. I don't even know if they'd even have, I don't even know anymore. Like, this is the stupidest, insane, insane. Just the simple fact that we're being told that, like, yeah, the scenes themselves were a horror show, but there was like nothing in between. They cannot sit here and say that the two roommates didn't know what the hell was going on and they thought that somebody just was like passed out behind the door. That means there was no blood nowhere, guys. If we want to believe that situation, that would mean that there was no blood outside of the door. You don't think that somebody is just passed out from being overly intoxicated or taken something or whatever if there's blood everywhere. That's not your first thought. Nah. So they're going to have to explain that shit too. And this whole thing about Dylan seeing somebody with a vacuum, that's going to be wild. That's going to be wild. Apple responded on January 27th, 2023 by providing subscriber information for two Apple accounts associated with defendant. B. Kohberger at spartan.northampton.edu, which Apple indicated was active, and Wi-Fi Army owns at Yahoo, which Apple indicated was locked. What does that mean? Does that mean that somebody tried to get into it but didn't know the password and so the account got locked? Like somebody was trying to steal it from him? Because if he had all of this stuff and he's like this like forensic cloud person, he would know how to reset his freaking password. So I wonder if somebody tried to get into his account and that's why it's locked now. Both accounts were created on October 7th, 2016. The subscriber information provided by Apple also revealed the account had last been accessed on December 20th of 2022, just days before the defendant's arrest. And then it goes to footnote number 7. The information produced by Apple in response to the FBI subpoena is contained on a thumb drive submitted by the state as Exhibit S-4 to the Apple objection. Well, if he was already in Pennsylvania, I wonder if that Northampton IDU connected to the Apple account is on that tablet that was in like the common area. Like if that's just a tablet at his house, his parents' house. I wonder if that's why it showed that it was accessed on the 20th. Because at that point, he'd already been back home for like 4 days. Because we have the notation, they're telling us that the cops at some point, I don't know which freaking cop agency it was, because they're not clear. They just say LE. Do I have to sneeze or not? Like, I'm trying to, like, brace myself. Maybe not. Probably now that I've talked about it, I'm not going to have to sneeze. Anyway, that was on the 16th of December. That LE apparently either witnessed or knew or saw or whatever him walk into a CVS in Pennsylvania. So I don't know. Thank you, Rose. Thank you for the $9.99. I very much appreciate it. Thank you so much. Thank you so much. Let's see. Okay, that was that one. Okay. On or about April 6, 2023, the FBI issued a preservation request to Apple for those two accounts. Okay, but they did one before that. So we're not going to talk about that one. The FBI's preservation request also listed other email accounts it determined might be associated with defendant, but Apple's response to the request indicated that it had no records associated with those accounts. So we already know that they sent one in incorrectly spelled or some shit like that, and that one got declined back. And I think there was like was there another one? I don't want to missay. I don't know if there was another one that got sent back for nothing that we knew about already, but this means that there was more that they thought could be associated but didn't even exist, apparently, like at all. So that's interesting too. So there's just like a bunch of like ghost accounts, because how would they have information that they might be connected to him, but then it turns out that they don't even exist at all? I'm not really quite sure. Ooh, hold on. Ooh, it's 30 degrees outside. I have to make sure I drip my faucets before we go to bed. The FBI shared the information it received from the Apple subpoena with Detectives Payne and Mowry. On August 1st, 2023, Detective Payne applied for a search warrant for all Apple accounts and associated or linked accounts associated with the two above identified Apple accounts from October 7th, 2016 to the date of defendant's arrest. His search warrant affidavit discussed in detail the circumstances of the crime, the results of the investigation to date, and why defendant was arrested and charged. Detective Payne also conveyed that defendant was seeking an advanced degree in criminology and had studied cloud-based forensics prior to the crimes. The affidavit discussed how defendant had attempted to conceal his location during the period immediately before and after the crime was committed. That's not true. See, what should have been here was the likely, the might have, the allegedly. Hippler's saying this shit like he knows this for a fact, and that's a damn lie. They actually haven't said a damn thing other than the fact that it went off network. It's assumed based off of copy and pasted stolen experience that it was turned off. The fact that he just... Okay, Hippler. You're shining bright, baby. We see you. Detective Payne also included a detailed explanation about what types of information Apple captures and maintains from users of Apple accounts, and that he believed the information sought from Apple would provide information concerning Kohberger's plans, thought process, research locations, blah, 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 shit that isn't true. Shit that's not true. And now we have the verbiage from the record itself, but we've actually gone over that before already. And it's just talking about the same two addresses, the spartan.northampton.edu and then the Wi-Fi Army owns. It's interesting that that one's locked. Did we know that before? Did we know that it was locked before? I don't think we knew it was locked before. That sounds new to me. The Apple warrant set out 9 categories of information sought by Detective Payne in his affidavit as summarized. Account identification, records regarding devices and associated with the accounts, contents of emails associated with the accounts, contents of IMs, contents of stored iCloud files, activity connections, and transactional logs for the accounts. Locations, kick the camera. Locations where the accounts were assessed, records pertaining to, I don't like the way the camera is now. Okay. Records pertaining to the types of services used, information necessary to decrypt any data. Other than its reference to the date of the crime being investigated, the Apple warrant was not temporally limited. The Apple warrant was served electronically by Detective Payne through Apple's law enforcement's email portal. As is his practice, he did not include a search warrant affidavit when serving the Apple warrant. Approximately 1 week later, Detective Payne and Mowry's downloaded the return provided by Apple and prepared and filed an inventory of the return with the magistrate. Subsequently, the magistrate issued an order allowing for the returned information to be delivered to any person or laboratory or laboratories for the purpose of conducting or obtaining any test, analysis, or identification of said property, which is deemed necessary by the custodial law enforcement agency or jurisdictional prosecuting attorney without further order of this court. Detective Payne disseminated the returned information to other members of the investigative team for processing, namely Detective Mowry and Special Agent Nicholas Balance. Both of these individuals had access to Detective Payne's search warrant affidavit in support of the Apple warrant. Okay. Amazon subpoena and search warrant. At some point in the investigation, the FBI located an Amazon account associated with defendant. It served a federal grand jury subpoena upon Amazon Inc. seeking order history records. And y'all see that? Wow. The feds literally showed nothing. Nothing. I mean, honestly, considering the fact that what did they get? Some little chicken scratch on some notepads when it came to the IgG stuff? How can you sit there and file stuff into a federal grand jury and not allow that information to be... If it's being discussed here, why is it not on record? I mean, we don't have a freaking point at this. I mean, we don't have an option at this point. We have to. Like, TUI has to. TUI has to. I mean, this is stupid. Yeah, especially when he sat there in that freaking courtroom and literally stated, well, that's what the evidence shows. That's what the evidence is showing when it comes to all these violations. And then homeboy backpedaled. He is just like Judge Gull, except worse because she's not two-faced. You see her boo-boo on her face all the time. She don't give a shit. This dude's two-faced hypocrite. How much did it cost? How much were you bought for, Hippler? Because at this point, what else am I supposed to think? What else? What else? It's like the biggest catch-22 because I know Judge wouldn't be this much of a dumbass, but I also don't trust the jury in Moscow. So I'm not mad about the change of venue because regardless of all the bullshit hippo face over here is pulling, a jury is still going to be the one to decide the situation. That judge doesn't decide shit in the long run. But all the crap he's doing now is going to make a huge, huge impression on the way that the jury sees the entire case. This is so gross. I hate this. Because it's blatantly in our faces. And all we can do is complain about it. And not enough complaining is going to change anything. It makes me absolutely disgusted. Makes me sick. Makes me sick. Amazon responded by providing the FBI with defendant's Amazon subscription information and purchase history from January 1st, 2022 to December 13th of 2022. After reviewing this information, Detective Mowry applied for and received a search warrant for records retained by Amazon for defendant's account regarding customer click activity, details of items added or deleted from his cart, all suggestions made to the account, advertising data, device identification information, and linked accounts with a date range of March 20th through the 30th of 2022 and November 1st, 2022 through December 6th of 2022. See, this part, is this where we're done? Okay, conclusions of law. This is pretty much where we're done with this document. But what bothers me is this. Who gives a shit what you click on? Okay. Who gives a shit what was added to or deleted from the cart? Who gives a shit about the suggestions being made? Who cares about the advertisement? Who cares about the device being used or what accounts are linked? If there's no proof he bought what you think he bought, what you're trying to tell us that he bought. Exactly. They wanted clicks because they had nothing. So what are they going to try to say? That after November 13th, he clicked on a K-bar after seeing the freaking shit on the news and are going to use that against him? Is that what they're going to do? This is so stupid. Exactly. They don't have him actually purchasing the freaking knife. That's what I've been saying this whole time. They literally have nothing. They have nothing. That's why I don't understand who the hell Nancy Disgrace thinks she is and who the hell McDonut thinks he is coming out here and lying to everyone. There's no proof of anything. And if the feds actually had information, don't you think it would be in the record? Don't you freaking think that if it actually proved their point, they would have no problem? The freaking court, the federal grand jury court system already had the paperwork. This is dumb. I couldn't be a lawyer. I would have punched somebody in the face by now. I could not be a lawyer. This is so ignorant. This makes me mad. Clicks. Clicks. Fucking clicks. This is so stupid. Clicks. Thank you. Hope this is worth his career. He said in open court and said BK's rights were violated. He is part of the Idaho Brotherhood. Wonder what they have him doing on video. Well, if he ends up like Judge Mullins, we'll probably know. Okay, we'll probably know. But I'm glad that you remembered that, because that's what I've been saying since we started this shit. This homeboy literally just went into court. We all heard it on live, him saying, this is true. All the evidence shows this is true, and this is what happened, and these policies and these things were all fucking violated. He said that in court. And now he's going to put on paper. Nope. This makes me so mad. We're done with this one. We're not stopping. I know it's 5 to midnight, but there's still over 600 of y'all in here paying attention. So we're going to keep on reading, because I'd be freaking damned, bro. I'd be damned. All right, arrest warrants. And then after this, we got Frank's. I believe the Frank's one talks about a vacuum. Now, this one's only 11 pages. How much of it is stuff we're actually going to read, though? Go back up. Okay, so introduction, standard. That's going to be the same. Findings of facts, conclusions of law. Not much. Not much. Okay, so let's just get this going. Let's get this freaking going. And what I'll probably end up doing, I mean, I'm going to have to at this point. This video is already freaking 5 hours long. No one's going to watch this shit. Besides y'all that are on here, ain't nobody going to click on this thing after 8 o'clock tomorrow morning. That's just how YouTube works. It's way too freaking long. So just like I have done with other things, I'm going to have to come in, and I'm going to have to come in and do some smaller stuff, because these points are too important for people to pass up just because they don't want to sit here for 5 hours. I don't blame them. I don't want to sit here for this long either. Like when I'm listening to something, I had to listen to stuff at like 2 times speed, and it can't be this long or else you've lost me. I know somebody's summarized something somewhere. So I'm just going to have to do both, like I tried to do most of the time. Okay. You ready? Let's see where we at. Is this even? Is it even? Okay. Order on defendant's motions to suppress the arrest warrants, Pennsylvania warrants, apartment warrant, and Idaho warrant to search person. I don't know how Dawn Daniels is getting away with all of her crap. I just don't get it. Thank you for the $9.99, Rose. I'm going to buy so much coffee with that. We got to keep going. Yep, let's do it. Let's do it. Thank you again, Rose. You ready? Ready? Okay. Introduction. This part's going to be the same. Defendant is charged with 1 count of burglary, 4 counts of murder in the first degree in connection with the stabbing deaths of 4 University of Idaho students in the early morning hours of November 13th, 2022. On December 30th of 2022, he was arrested pursuant to a warrant at his parents' home in Pennsylvania. At the time of his arrest, Pennsylvania authorities executed search warrants for defendant's person, his vehicle, and his parents' home. Around the same time, a 5th warrant for a search of defendant's Pullman, Washington apartment was issued by a Washington magistrate. After defendant was transported back to Idaho, law enforcement obtained a 6th warrant for the search of defendant's person. He better say something about Dawn Daniels. Thank you, Hurricane Train. I never want to say your name wrong, but I always just want to say Hurricane. Hurricane Train. Thank you so much for the $10 super sticker. It's very, very sweet. Okay. Through 6 different motions, and we instantly are interrupted by a freaking footnote. Okay, motion to suppress. Pennsylvania search warrant for 119 Lambsden Drive, Albrightsville, Pennsylvania, and statements made. Motion to suppress. Okay, so this is just the labels of the documents and the VIN number for the car. Okay, yeah, it's literally just the labels. And where were we? Where's that little number? Okay. Defendant seeks suppression of evidence gathered by law enforcement through these warrants on several grounds. His arguments for each motion have largely been disposed of through the court's contemporaneously filed orders. And we're going to just go ahead and go to number 2. Insofar as defendant argues the 6 warrants at issue are invalid under Frank's due to claims of recklessly or intentionally false or omitted material information, and or because they are based in law enforcement's allegedly unconstitutional use of investigative IGG. These arguments were addressed in the court's order on defendant's motion to suppress. Okay, so it's the exact same. Okay, I think we actually read that in the last one. Still remaining, however, is 1, whether suppression is warranted due to law enforcement's failure to knock and announce in executing warrants at the Kohberger residence, and 2, whether defendants' post-arrest statements are suppressible as fruit of the poisonous tree and are due to a Miranda violation. And now we go to number 3. It just says Miranda versus Arizona 1966. What was the point of that footnote? We know what Miranda is. The hell? A suppression hearing on the portion of defendant's motion at issue on this order. And here we have another 4. Okay. Evidence and argument on the Franks motion and IGG motion were heard on January 23rd, 2025. The balance of motion to suppress was taken up the following date. Why are they giving us stuff that we don't need? I think he just likes to be annoying. I think that's what he's doing. Okay. During which the court received testimony from Detective Corporal Brett Payne and Detective Lawrence Mowry, both from the Moscow Police Department. The court found both detectives to be credible and reliable. That's what you were talking about, Mowry? You were so proud of that. So proud of that. The court found both detectives to be credible and reliable. Following argument, the court took the matter under advisement. The court finds suppression is not warranted because 1, exigent circumstances excused the abbreviated knock and announce. You better list it. You better list it. Defendant has not established a Miranda violation. I mean, I don't remember them saying anything about that. Did they say something about that? I don't remember them saying anything. I don't remember them saying something about Miranda. Other than the fact that they didn't actually read him his rights until after they moved him to the police department, right? Like they held him at gunpoint. YouTube's probably going to trip out now. Anyway, they held him and his family at pew-pew point for hours and hours and hours and didn't read his Miranda until later, right? I'm pretty positive that it was like 3.5 hours later that they finally actually read him his Miranda rights. And they haven't said anything about that, I don't think. So it was. Yeah, because Payne was watching on a screen through drone footage from a command center. Eventually Mirandized. That's crazy to be held for over 3 hours and you not being read your rights. Frick, you got me in here for, Ben, bro. That's crazy. Okay, standard. The standard of review of a motion to suppress is bifurcated. We did all this already? Yeah, we're not doing that part. Okay. Findings of facts. And already with the number 5. The court's findings are based on suppression hearing testimony provided by detectives Payne and Mowry, as well as the following documentary evidence. And then it just goes on to list the document names that we've, again, read the guts of, so there's just no point. On November 13th of 2022, an officer from the Moscow Police Department responded to a residence located at 1122 King Road in Moscow, Idaho, where he discovered the bodies of Maddie Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. Each appeared to have been to death. The investigation that ensued was a multi-agency affair. We know that part already. Okay. On or around December 16th of 2022, defendant left his Pullman apartment and drove to his parents' home located on or around. Excuse me? He did not leave on the freaking 16th. They have him in Indiana on the 15th. What you mean? This dude knows nothing. I'm about to just like lose my mind. Oh no, Mowry. Hippler is worse than Jennings. What? He left before the 16th. You can't say on or around December 16th, knowing damn well we have body cams of him being somewhere else on the 15th. He can't even put actual information in here. This is annoying. On or about December 28th, 2022, the FBI and Moscow Police Departments requested assistance from the Pennsylvania State Police in their investigation. Oh! What would FBI be requesting assistance for if they're just sending in tips? What would the FBI be needing assistance for? If all they do is send in tips? Y'all prove yourselves wrong. Every time y'all talk, I swear on everything. Specifically in obtaining and executing warrants. And we have number 6. Prior to this point, investigators had been surveilling 119 Lambsden and had observed defendant walking near the residence in the early morning hours of December 27th of 2024. As part of this assistance, PSP reviewed reports and affidavits prepared by the Moscow Police Department, including a probable cause statement prepared by Detective Brett Payne, outlining the circumstances of the crime and the investigation to date. On December 29th of 2022, a criminal complaint and probable cause order were filed in this action, and the Latah County Magistrate issued a warrant for defendant's arrest. The same day, PSP applied for and obtained... My nose itches, guys. Hold on. I've been sitting here forever, and my nose has been itching forever, and I've been holding to sneeze, so I'm just going to have to itch my nose. Scratch my nose. Okay, I think I'm good now. Okay. The same day, PSP, Pennsylvania State Police, applied for and obtained 3 search warrants from a Pennsylvania magistrate. 1 for 119 Lambsden Drive, 2 for defendant's person, and 3 for defendant's vehicle, which was believed to be parked in the garage of 119 Lambsden Drive. These search warrants were supported by the affidavit of probable cause of Trooper Justin Leary, to which was attached Detective Payne's probable cause statement. And later that day, PSP received the signed arrest warrant issued by the Latah County Magistrate. Late in the evening of December 29th of 2022, PSP and its Special Emergency Response Team, or CERT, prepared for the execution of the warrants. Detective Payne was present briefly to observe the final preparations. I don't understand what you mean. What do you mean by he was present briefly? He said he never went into that neighborhood. He never drove through or did anything. He never was over there. Never was over there. He said so himself. It was Detective Payne's understanding that PSP and CERT were preparing for a knock and announce entry. During their final preparations, CERT snipers set an umbrella around the residence to monitor any activity therein, while a helicopter monitored from overhead in the event defendant exited the residence. So you're trying to make me believe that they didn't notice there was some loud-ass freaking helichopper just doing its thing up above their house? Come on now. I'm sure that they would have heard that shit. I feel it whenever a helicopter comes over my house. I mean, come on now. There ain't no way. At 12:33 a.m., snipers observed a kitchen light turn on and saw a taller, young white male wearing a black hoodie standing near the glass sliding door leading out to the deck. At 12:40 a.m., the same person was seen again. This time, officers were able to positively identify the person as defendant. Okay. At 12:55 a.m., the light turned on in the garage where defendant's vehicle was believed to be parked. At 1:03 a.m., lights flashed in the garage as if the vehicle was being locked or unlocked by a key fob. Okay, that's how many minutes later? 8 minutes later? Who gives a shit? At 1:09 a.m., defendant was seen in the kitchen of the home, this time wearing rubber gloves and handling a plastic baggie. Okay, so 6 minutes. So he goes to his car. He's probably smoking, bro. He's probably getting high. Okay, can we be for real? He's probably smoking the ganja while his parents are asleep. He's doing it outside. Maybe he ran out. He went to his freaking car, did something, and then had that stuff in the kitchen. I mean, most people think that that's what's happening here. That's like a big, huge conversation on Twitter and on Reddit, is that that's what homeboy was actually doing. Because unless he smokes cigarettes, what are you doing going out on the porch for 10 minutes? You know what I mean? Like, what time did he go outside? 7 minutes he was outside on the deck. Is he smoking something? A cigarette or otherwise? I mean, I don't know. Do we know if he smokes? I mean, just because he's OCD and smart and all these things doesn't mean he doesn't smoke cigarettes. I mean, I'm awesome and I smoked for 20 years, so I don't even know. I just don't. This doesn't mean shit to me. We already know he stays up late. Him going to his car. This doesn't mean nothing to me. This story means nothing to me. Based on these observations, law enforcement believed defendant was potentially destroying evidence from the vehicle that was related to the homicides. Sure, because he'd been there forever, and now's the day he decides to do it. Number 7. As set forth in Detective Payne's probable cause statement accompanying the search warrant affidavit for the 3 Pennsylvania warrants, it was believed defendant drove his vehicle to the 1112... I'm sorry? Shit's this. Drove his vehicle to 1112 King Road, committed the homicides, and then fled in his vehicle. Thus, when law enforcement was preparing to execute the Pennsylvania warrants, they were aware there was potentially evidence of the crime. So he just typoed this. Because we already know for a fact that whatever car is on the King Road camera doesn't stop. Doesn't stop. So for him to be like, oh, 1112, there's going to be a freaking plethora of channels now that are going to take that little bitty dumb shit of a typo and a mistake and run with it and do all kind of crazy shit now. Be prepared. Be prepared. Let's see. Okay. Law enforcement was also aware the defendant possessed a Glock pew pew, prompting a concern over officer safety due to defendant's heightened mental state of awareness or threat level of police possibly tracking him. Oh yeah, faux pair, I'm here. We get into the end of all of this. So you can't freaking say that there was a heightened mental state of awareness unless you have proof that he was aware that y'all were watching him. So is there like phone calls? Do you see him like being super paranoid looking around, or what's going on with that? Because just because he had a hoodie on and he went outside and came back in and went to his car, then what was in the kitchen, that's not a heightened state of awareness. Or any sort of like, oh, the cops are watching me. Oh no, we knew that. I've got something to say. We've known that. I believe that there's multiple weapons in the inventory report, like the inventory thing. Him having I don't mean shit. I don't mean nothing. Yeah, like they all said exactly. Like they all said that he was up late at night. I mean, what college kid is not up all freaking night? It doesn't matter that you're a TA, that you're almost 30 and you're a TA. You're still a college student. You're still on that schedule of having to freaking cram your brain. I know that it takes me a long ass time. It takes me so freaking long at the end of the day to wind down. I've been really trying my best here lately to come up with some sort of like small little nighttime routines. I know that routines actually do help all of that. But I work in the medical crap all day long. I'm doing stuff with kids all day long, doing stuff with the animals all day long, and then I'm doing this the rest of my day. It takes a long time to like get my brain to chill out enough to where I know that I can turn it off and actually go to sleep, because I'll stay up all night if I don't shut my damn voice up in my head. That's just how it is. So for him to be up at all times of the night, that doesn't mean anything to me. Doesn't mean anything to me. None at all. But yeah, no, we knew he had a pew pew. We knew that. But they can't even try to say, I want proof. What do you mean? So because he was walking around, y'all think that that means this, and so that meant that you needed to do all the things that you did? You have to have proof that he had a heightened state of awareness. You have to have proof that he knew that y'all were watching him. You can't just say that and use it as an excuse for popping up in his driveway in a military-grade vehicle. You can't do that. You can't do that. At approximately 1:14 a.m., CERT made announcements from a Bearcat, which is an armored vehicle used by SWAT, parked in the driveway of the residence. Immediately following announcements, CERT effectuated a forced entry into the residence. Defendant was arrested without incident in a bedroom. I thought they said he was in the kitchen. Didn't they say he was in the kitchen? I could have sworn he was in the kitchen. That's a new one. That's a super new one. I could have sworn in the kitchen. So this changed. Suddenly he's in a bedroom. Interesting. They did. So why are they changing it? How come they didn't just tell us that? Stuff like that should be factual. Stuff like that shouldn't change depending on who's telling the story. Really? Mish Girl said, I really noticed the rage in SG's face and demeanor tonight in that interview, which was odd for something that was supposed to be good news for him. That is weird. His behavior is always ass backwards. Back asswards, however you want to say it. Always. Always backwards. Okay. His vehicle was located and secured in the garage, which we knew that. We knew that. Once apprehended, defendant was handcuffed and placed in a police vehicle. He was notified. That's not true. Why are you lying? He was held in his house for 3 hours. For over 3 hours. So what do you mean? This is a lie. Once apprehended, defendant was handcuffed and placed in a police vehicle. He was notified that he was in a police vehicle and being audio and video recorded. Again, that was like 3 hours later. Like we literally were told they were all held in the living room. Why is this changing? While awaiting transport, defendant informed law enforcement that he had an unloaded Glock in the residence by his bed. During transport, defendant engaged in small talk with the accompanying officers. When defendant expressed at one point that he wanted to know what was going on with his arrest, law enforcement told him investigators were going to speak to him at the station about the situation. The details of the investigation were not discussed with defendant. Once they arrived at the station, defendant was escorted into the processing room to await interview with Detective Payne, which occurred 10 minutes later. Defendant was then informed of his Miranda rights, and an interview subsequently began. And that's where we start getting into the law stuff. I just want to make sure I'm not missing anything. Like I said, I'm going to go through all this stuff off camera. The law stuff. I just can't believe he's like, oh, he left around the 16th. No, he didn't. Okay, yeah. It just goes into all of the cases that they were talking about. This one's interesting. Defendant has not established he was interrogated when he made unidentified statements. Defendant next argues any statements he made to law enforcement prior to being Mirandized must be suppressed, either as fruits of the poisonous tree or as a Miranda violation. I mean, the question is, where was the Miranda violation? I don't know, probably the fact that y'all had him for over 3 hours. Y'all had him for over 3 hours. That's a long freaking time. To have somebody technically in custody, but not in custody at the same time? Like, how freaking confusing is that? Ugh, okay. We are now, I don't know where we are. So we've gone, okay, yeah, here we go. Now again, we're not reading all this. I'm going to do it the exact same way that I'm doing the other ones. So what we're looking at here is, and this is the Franks one. So let's see how far we're reading, just so that we know. I mean, I don't know if I'm going to be able to tell how far down I can read it without stopping. Okay, here's the stuff. Ooh! Okay. I don't want to just jump right down into that, but I don't want to miss anything. Like, I know that that's what's going to end up showing is way down here. Like, I noticed it was off. But if we go all the way down to this page, freaking page 10, it talks about all the extra stuff, hopefully, because that's where they start talking about Dylan. Okay, yeah, there's more stuff in here. Okay. But we've got to read from the beginning so that we don't miss it. I don't want to miss nothing. Okay. I need to change the way I'm sitting because my back is going to break up here in a minute. Okay. Yeah, probably going to have to read all of the pages. You ready? You ready? Okay, here's the Franks one. There's a lot here. 38 pages, and we probably do need to read the whole damn thing. So, we'll see. Let's go. Introduction. The same page is always the same. Defendant is charged with 1 count of burglary and 4 counts of murder in the first degree. It is alleged that defendant entered a residence at 1122 King Road in Moscow, Idaho in the early morning hours of November 13th, 2022 and killed Maddie Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. Defendant is requesting a Franks hearing, and all they're doing is Franks versus Delaware for that first footnote because, you know, we need to be told about it 20 times. Claiming law enforcement intentionally or recklessly misrepresented and or omitted several material facts in their probable cause affidavits supporting various search warrant applications. These misrepresentations or omissions, according to defendant, affect the validity of 17 different search warrants. And the second footnote says there was a total of 25 search warrants issued in this investigation between December 23rd of 22 and August 1st of 2023. For each issue analyzed in this order, the court has identified the date range for the specific warrants defendant's claims are implicated. Okay. The state responds that defendant has failed to make the requisite substantial preliminary showing under Franks that 1, law enforcement either made false statements or omitted material information knowingly or intentionally, or with reckless disregard for the truth, and or that false statements or omissions were necessary to findings of probable cause. So are they going to talk about Bethany? Are they going to talk about Bethany? And now we have a third footnote, and it looks like it is just the exhibit names. It's just the exhibit names. Yeah, okay. A hearing on defendant's motion was held on January 23rd, 2025. In the interest of evidentiary efficiency, the court permitted a full Franks hearing on the motion only insofar as it pertained to the alleged omission of information regarding defendant's identification through investigative genetic genealogy. And now we have a fourth footnote. This was identified as issues 5 in defendant's amended memorandum. Okay. Now, where's the number? Okay. On the remaining challenges, the court permitted argument on defendant's proffer as to whether defendant had satisfied his burden to warrant a subsequent Franks hearing. And now we have a freaking another one, number 5. The court notes that in response to some of the Franks challenges, the state submitted and argued evidence that was not included in defendant's proffer. While this evidence can be considered at a Franks hearing, this stage only permits the court to consider whether defendant has made the substantial preliminary showing. Which is true, because the state came out and said some things that Bryan's team didn't talk about, like how Dylan didn't recognize his photo and how she was, you know, here nor there. Well, actually, Ann Taylor said the whole like here nor there, but we didn't even hear a word about the grand jury transcripts from Ann or about Dylan not recognizing a photo of Bryan Kohberger. And Jennings had no issue like just blurting that stuff out. So that's not wrong. I mean, the state did say a bunch of stuff that had nothing to do with anything that the defendant was talking about. And plus, remember the cell phone tower situation? cell phone tower situation. Jennings was like, oh, 3. And he was like, if you say 3, I got to let this happen. I don't understand why he's allowed to help the state. What a loser. What a paid shill. The court should not give the government an opportunity to present its evidence on the validity of the warrant without converting the hearing into a full evidentiary Franks hearing, including full cross-examination of government witnesses. Consequently, on these challenges, the court is only relying on defendants' exhibits and the parties' arguments regarding why or why not, based on that proffer, a Franks hearing is warranted. Well, we think it is very warranted, and you just seem to be a douche face. That's all I've got to say about him. Were we on number 5? Yeah. Okay. Where's the little number? There's 5. Okay. The court then took matters under advisement. Yeah, sure you did. The court concludes that the search warrants are not invalid based on the omission of defendant's identification through IgG because that information would have only bolstered probable cause of the searches. As to the remaining challenges, the court finds defendant has failed to carry his preliminary burden under Franks and therefore denies his motion for a Franks hearing. Standard. In a Franks motion, the trial court's determination as to whether a representation is false and whether a misrepresentation or omission was made knowingly and intentionally or with reckless disregard for the truth are factual determinations reviewed under a clearly erroneous standard. State versus K from 1996. Citations were omitted. Whether a representation or omission is material is a question of law freely reviewed. Freely reviewed? I mean, if something is represented incorrectly or purposely omitted, like it's called a Brady violation. So why is this in quotations? Like there's laws for this. Oh, wait, it's okay for them to break them. Totally fine, according to Judge Hippler. Analysis. For a search warrant to be valid, it must be based on probable cause. In Franks versus Delaware, the United States Supreme Court held that a defendant can void a search warrant and suppress the fruits of the search when the affidavit used to procure the warrants contains a knowingly and intentional or recklessly false statement that is material to the probable cause determination. Where the defendant makes a substantial preliminary showing that a false statement knowingly or intentionally or with reckless disregard for the truth was included by the affiant on the warrant affidavit, and if the allegedly false statement is necessary to the finding of probable cause, the Fourth Amendment requires that a hearing be held at the defendant's request. Idaho has adopted the rule established in Franks and extended it to the deliberate or reckless omissions of material, exculpatory facts in affidavits. So are we going to hear about Bethany? Are we going to hear about Bethany? Are we? An omission of exculpatory facts is material only if there is a substantial probability that, had the omitted information been presented, it would have altered the magistrate's determination of probable cause. The analysis under Franks is a two-step process. The first step considers whether the defendant has made a substantial preliminary showing that the affiant knowingly and intentionally or recklessly falsified or omitted information from his or her affidavit. And now we have number 6. Reckless means a high degree of awareness of probable falsity. Okay. Was that number 6? Okay. Guzman is also being referenced right here. While the Franks court did not define this burden precisely, it is generally held to be something more than conclusory allegations, but less than proof by a preponderance. Courts have said this requires direct evidence of the affiant's state of mind or else circumstantial evidence of a subjective intent to deceive. Negligent, United States versus Woodfork from 2021, and there's a 7. Whether an omission was intentional or reckless may be inferred, in part, from the relative importance of the information and its exculpatory power. However, a court need not draw inferences from the evidence in a defendant's favor. Okay. Where were we? There's the little 6. Now, where is the little 7? Am I tripping? There's the little 6. am tripping. Where is it? Guys, I really do not see the little 7 until I get back where I was. Okay, well, that was the sentence that I read. Okay. Courts have said this requires direct evidence of the affiant's state of mind or else circumstantial evidence of a subjective intent to deceive. Okay, there it is. There it is. That's why I couldn't freaking see it. Okay. Negligent or innocent misrepresentations or omissions, even if necessary to establish probable cause, will not invalidate a warrant, which is crap. That's just crap. Like if it's, it should have to be dotted I's, crossed T's. It shouldn't have any issues. It shouldn't be allowed to just be whatever. It shouldn't be allowed to be misinterpreted. Everything should have to be in there that matters. And even if there is something that maybe will cause it not to be signed, you're like under oath to be honest. You're under oath to be honest. Okay, so this is talking about Peterson, and it says the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. There must be allegations of deliberate falsehood or of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. Ooh, did y'all hear that? Like, I wouldn't hear it, but y'all probably just heard that. I hit the metal on my microphone. Sorry for anybody whose eardrums that might have just busted, because I felt it hit the metal. Where'd it go? They should point out specifically the portion of the warrant affidavit that is claimed to be false, and they should be accompanied by a statement of supporting reasons. Affidavits or sworn or otherwise reliable statements of witnesses should be furnished or their absence satisfactorily explained. You heard the doink? Did you hear it? Okay. The defendant successfully shows an intentional and knowing or reckless inclusion of a false statement or omission of exculpatory information. The trial court must then examine whether the remaining information in the affidavit is sufficient to establish probable cause, absent the false statement or with the addition of the exculpatory information. A Franks hearing will be required only if the false or omitted information was necessary to a finding of probable cause. If a defendant makes a substantial preliminary showing under Franks, the matter moves to an evidentiary hearing where the defendant must establish by a preponderance of the evidence that intentional or reckless falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause, or that material exculpatory information was deliberately or recklessly omitted. It is at this stage where the state can provide additional evidence for the court to consider. Here, defendant claims that 17 search warrants issued in the investigation of the crime were based on false, misleading statements and or omitted exculpatory information in the various search warrant affidavits. His proffer is arranged by issue, of which there are 13. As mentioned, for convenience sake, the court granted an evidentiary hearing on the IgG issue. Yeah, we know. The court was informed that the evidence of this issue substantially overlapped with evidence that was to be presented in defendant's motion to suppress regarding IgG. Given that, the court concluded, one second. My Boomy wanted in here. My big dog. I guess he's going to lay down. Okay. He's laying down. Zelda doesn't really love me no more. I mean, she loves me. She's up here all the time whenever I'm working. But she has like this spot on the couch now. And it's like in this little corner. And she just like, that's her throne now. It's her throne. You can't even, the dogs can't get on her spot, near her spot. She's batting them away. It's a whole thing. But Boomy Doomy's over there. Okay, so let's get back to right here. This evidence will be considered under the preponderance of evidence standard, while the proffer on the remaining issues will be considered under the substantial preliminary showing standard. A, defendant has not met his Franks burden on issues 1 and 2, challenges to Exhibit A, and then it goes down to 9. Issue 1 applies to all search warrants. Issue 2 applies to search warrants issued on December 29th of 2022 and later. Okay. In issues 1 and 2, defendant challenges Exhibit A, which is a probable cause statement that individual investigative officers appended to their affidavits in seeking search warrants. As defendant notes, Exhibit A was a working document drafted as a group effort among the multiple investigative officers working on the homicide investigation. And then it goes down to 10. Defendant submits Exhibit D1A-C as evidence of the group effort. These exhibits are emails between Special Agent Nick Balance of the FBI and Detective Brett Payne of the Moscow Police Department, in which they are exchanging drafts of a probable cause statement. Did y'all just hear what I said? Whose boobs on the ground? That whatever, that Viviana lady. I don't care. She can. That's what she can do. She's annoying as shit. Anyway, let's get back to the point. Did y'all hear what I just said about this? Did y'all hear what I said? Nick Balance and Detective Payne were exchanging drafts of a probable cause statement. Meaning that really the feds wrote the probable cause statement. So it's really not Blaker and Payne copying and pasting each other. Balance wrote the damn thing, and they copy and pasted what Balance read, what Balance wrote. And never mind the fact that whenever it comes to the information about the guy who does the cast work, all it says is FBI agent. So Balance helped write this damn thing and didn't even put his own name in it, talking about the actual cast guy. They can say group effort all they want to, but it's not. It's not a group effort. The feds did every damn thing and then showed no proof for it. And then just basically, let's be for real, threw Moscow PD to the wolves. That's what happened here. Threw Moscow PD to the wolves. With no proof, nothing. Throw Moscow to the wolves, under the bus, all the things, blew them up, threw a nuke at them. So they don't even know how to write a PCA. Wild. Like I knew that they were helping, like with the cast and with the, with all of the other things, the warrants, the Google stuff, the email addresses, the phone shit, blah blah blah, whatever. Dude can't even write a probable cause at order. That's wild. That's wild. Did they do anything? Did they do anything? I don't think they did anything. In their respective search warrant applications, the officers submitted and swore to Exhibit A as their own, even though it was a product of collective effort and not necessarily limited to the swearing officer's own investigation. And now we have another footnote. In addition to the draft Exhibit A, defendant was provided with his proffer the following 3 actual Exhibit A's, which were submitted by officers with their search warrant applications. The statement of Dustin Blaker supporting the search warrant application for defendant's Pullman, Washington apartment and his office at Washington State University. The statement of Lawrence Mowry supporting the search warrant application for defendant's Google account. The statement of Brett Payne supporting the warrant application for defendant's arrest. These actual Exhibit A's are not identical to the draft Exhibit A or to each other. You freaking liar. I should have done it. I should have done it already. I should have freaking been able to have sat down and done the freaking comparison of Blaker's and Payne's. Now we're going to have to just suck it up, guys, because if y'all can sit here for this freaking long for this shit, we're going to have to just go live to do the comparison of Blaker and Payne's PCAs, because that thing is taking me way too long to record and edit. There's new shit happening all the time. It gets forgotten and it needs to be discussed. This dude just straight up freaking lied. We've been talking about this forever now, that it's nothing but copy and pasted bullshit, even down to their own experiences. What do you mean that they're not identical to each other? I'm tired of this dude. Did he even look at anything? Did he even read anything? Is he just getting his information the same way that Sheriff Steins did, where he just read the cover page and went along with the answer and didn't actually read the inside information? Yes, we have. We have both of them. What he is talking about are things that we physically have. We have Payne Exhibit A, and we have Blaker Exhibit A. Yes, sir. If there's something else we haven't seen, it's not labeled these labels, because these labels we have. I pulled up Blaker's earlier. I don't understand. Yes, get the popcorn and eat all the popcorn. Eat all the popcorn. I don't understand this. And that's another thing too. Why? Why do we need Blaker's for the stuff in Washington, but Payne's was used for the stuff in Pennsylvania? Why couldn't they just use the exact same one? Why is there two from two different people that are just copy and pasted? What's the point? I never understood that part either. Like, I never understood why that was even the case. And like, in the first place, they copy and pasted pretty much every damn thing. One's a little bit longer than the other, but not for like really anything special. It's like a bunch of technical stuff. This is wild. 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 Okay, let's see. Okay. In issue 1, defendant challenges this approach, arguing that Exhibit A was treated as a wild card to easily get a warrant. Yeah. I mean, none of it's true. It's all guesstimates and maybes. Guesstimates and maybes. On issue 2, he challenges alleged misinterpretations in Blaker Exhibit A, Mowry Exhibit A, and Payne Exhibit A. What is this? This is the one we haven't seen. Mowry. Mr. Mowry. It's yours, apparently. Because we don't have a Mowry Exhibit A. Not when it comes to a probable cause order affidavit. We have Blaker, we have Payne. I haven't seen anything with Mowry's name on it besides some search warrants, but not a PCA. Interesting. Interesting. That's the one. Is it? I mean, it probably is. But it's still, we haven't seen it. That's the one we haven't seen. Defendant has not met his burden under Franks on issues 1 or 2. First, is not improper for law enforcement seeking a warrant to swear to matters within the collective knowledge of other officers involved in the same investigation. When you're putting your information about why you think somebody's phone is off network based on your own personal experiences, and you're copying and pasting it from somebody else's shit, yeah, it matters. Because that means that you have no idea what it actually means for the phone to actually not be on network. You're going to instantly be like, oh, turned it off. Because you're too uneducated in the matter to know better. This is stupid. The later it gets in the night, the more ridiculous I'm probably going to act. Just so y'all know. So y'all lucky this is the last one, because this is dumb. This is stupid. This is dumb. Second, defendant has not demonstrated in his proffers any misrepresentations or omissions, much less that they were made intentionally or recklessly. What do you mean? So he hasn't put anything in his information about the exculpatory information from Bethany? Because I feel like that's probably in there somewhere. I mean, if it's not, then what was the whole point of that? It's so annoying. Defendant has not demonstrated any impropriety in law enforcement's execution of Exhibit A based on collective knowledge. It is well settled that statements of law enforcement officers that are based upon the observations of fellow officers participating in the same investigation carry a presumption of reliability. I will stop right here also for a second. Hold on a minute. Okay. Some of you might remember me mentioning this a while back. Like it was right before Christmas. My friend's grandfather was murdered by his grandson, by her cousin. I mentioned this in passing. Now she sent me all the documents because she wanted me to help her make sure that she didn't miss anything. They were trying to figure out the event that led up to this insanity. Okay, this was like an almost 70-year-old man. This guy was 6 foot something, ginormous, could have taken it out with his freaking hands like that if he really wanted to. Instead, he took a knife out the kitchen and he stabbed him several times in the body and just left him in the laundry room, hidden in some sheets. Took the car, crazy shit, okay? I read all of the documentation in this case. Not a single thing looked copy and pasted. There was like 12 different police officers' reports in this entire thing. Like 12. None of them had copy and pasted information. Even the ones that all showed up at the scene at the same time, or the ones that showed up in the parking lot where he ended up turning himself in, all the things, like none of their stuff was copy and pasted. It was very, 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 very much their own thoughts, their own view without any of the copy and paste stuff. Okay? This was small town Texas. Little bitty one horse, blink your eye and miss it, small town Texas. And they could do it right. They could do it right. They copy and paste all this bullshit. Big old bag of Lay's potato chips. I just don't understand. I mean, you can say that, but we don't really know that. Just because somebody filed something and it got denied from being under a gag order doesn't mean it even exists, honestly. I don't know if that's true or not. Like, some people have said that, but we don't really know if that's true. I don't feel like they would be using something that's irrelevant like this, that doesn't have substantial A, B, C, and D, and this is the truth and how this all happened for all of these warrants and stuff. If there was something else, they wouldn't be attaching all of this crap that literally has no evidence and nothing to stand on. Again, the case is Lieutenant Dan. There's no legs, bro. So I know that some people say that, but until they prove that, I don't believe that, because they attached all this crap to get all these warrants. They would be attaching this other thing that we haven't seen before, and it would have been sealed, and we wouldn't have it. We wouldn't have anything to view whenever it came to the search warrant for the apartment. Like, we would have that information attached somewhere, but it would show that it was sealed and redacted. We don't have no filings like that. There are no filings. Go to the case summary page. There are no filings that are sealed like that. Like, if there was some proof of a sealed document, then I could get along with that. We have proof of all of our sealed documents, and there's nothing to prove that that's being hidden anywhere. So I'm gonna need to see something that makes more sense. I mean, so is the Moscow traffic stop, and all they're doing is showing that it's Bryan and he had a car. Doesn't really mean much. Doesn't really mean much. Where were we? Okay. Now I see where we are. Now, this is United States versus Ventresca from 1965. Observations of fellow officers of the government engaged in a common investigation are plainly a reliable basis for a warrant applied for by one of their number. One of their number? Okay, whatever. The presumption extends to hearsay information from government officials who, while engaged in investigatory ... responsibilities, discover evidence of possible criminal activity. Talks about State versus Wilson from 1997. The presumption arises from the belief that facts gathered in the course of an investigation are unlikely to be based upon mere speculation or tainted by personal involvement with the suspect. And then that's talking about United States versus Reed from 1983. Defendant acknowledges that a warrant can be based on law enforcement's common knowledge, but argues that officers cannot sign a collectively drafted affidavit as their own without identifying who did the work described therein. Otherwise, it misleads the magistrate into believing that the swearing officer drafted the affidavit and performed the work herein when it was a collective effort. This hyper-technical argument has no traction under Franks. Even if a search warrant affidavit does not specifically identify the precise source of the information from within law enforcement, it is still sufficient to support probable cause if a reader would reasonably infer that the information came from other law enforcement personnel. United States versus May from 1987. In Wilson, for example, the defendant challenged an officer's search warrant affidavit on grounds that the swearing officer did not identify, 1, which facts were based on his own personal knowledge as opposed to hearsay information from other sources, 2, whether he had personally viewed the evidence, 3, the source of information for the drug dog's training and experience, and 4, the identity of sources he contacted for the information. Noting that search warrant affidavits are not to be reviewed and tested in a hyper-technical manner, really? Not to be reviewed in a hyper-technical manner? I guess because they're not supposed to be beyond a reasonable doubt, but just probable cause. But you'd still think that they could be... My email is on the channel somewhere. Go to the channel page, and then you go to like the more info thing where it pops up like my links and stuff, and then click and prove you're not a freaking robot, and then it'll give you my address. That's how that works. Anyway, I don't know. I don't understand this situation right here. I mean, again, like, I get it. Probable cause, not beyond a reasonable doubt, but to just be like, they can basically say whatever they want to, and as long as it sounds good is how it kind of like feels to me at this point. I'm not impressed at all by the way that they do things here. I'm not impressed at all. I'm just not. The Idaho Court of Appeals rejected the defendant's argument, finding that a common sense reading of the affidavit would allow the magistrate to reasonably infer that the information came from the officer's own observations or those of other officers engaged in the investigation. Here, defendant's evidence demonstrates there were several law enforcement agencies working together on the case, including the Idaho State Police, Moscow Police Department, and the Federal Bureau of Investigation. How are you going to include them? Y'all already know where I'm going. How are you going to include the FBI working together for the probable cause affidavit, but they're sending in a tip for the IGG? The same entity that helped write the probable cause order doesn't have to do anything whenever it comes to warrants for anything else. Make it make sense. During his testimony from a prior hearing in this matter, Detective Brett Payne from the Moscow Police Department explained that agents from these three agencies were co-located at a command center set up at the Moscow Police Department for purposes of the investigation. Yes, that's exactly what he said. These agents were assigned different investigative tasks. Pertinent information they learned in performing those tasks was then exchanged and transmitted into a working probable cause affidavit, i.e. Draft Exhibit A. That's the one we don't have, Mowry. That one too. That's the one we don't have. So whatever was drafted together with balance, they've got it somewhere. That's the one that we don't have. And that there's no records for it, because you know there's no records for any damn thing. Literally no records for anything. Nothing. This is the one I want. This is the one I want. That's the one I want. The information from the Draft Exhibit A was then incorporated by law enforcement in varying degrees into the Exhibit A's supporting the search warrant applications. Importantly, the Exhibit A's challenged by defendant included statements alerting the magistrate to the affiant nope, not to, that the affiant was assisted by other law enforcement agents and that the information contained within the Exhibit A was based on information provided by these other agents. And it says to see Blaker's exhibit. I am being assisted by other officers. Yeah, we already know what it says, actually. Well, most of us know what it says. I definitely know what it says. As found in Wilson, this is sufficient to allow the reviewing magistrate to reasonably infer that the information within Exhibit A came from not only the affiant's personal knowledge, but the knowledge of other law enforcement investigating the crime. Moreover, given the breadth of information in the affidavit, it is readily apparent that the affiant did not perform all the work identified therein on his own. I mean, we know that. Further, defendant was not cited to a single case supporting the proposition that law enforcement's use of a working probable cause affidavit is improper. In sum, defendant has failed to make the requisite showing under Franks on issue 1. Further, under no circumstances could it be reasonably concluded that had the swearing officer disclosed which members of law enforcement provided which piece of evidence, the magistrate would not have found probable cause. I mean, that's probably true. That's probably true. Defendant has not established that alleged misrepresentations in any of the 3 challenged search warrant affidavits compels a Franks hearing. The first misrepresentation identified by defendant on issue 2 is contained in Blaker Exhibit A, supporting the warrant application for defendant's Pullman, Washington apartment and his office at Washington State University. Defendant claims that Sergeant Blaker attributes discovering the knife sheath. This is the part that matters to me. Oh, I'm so glad he put it in there. This is the part that we've been talking about for a while. The difference in how they both claim that they came into knowledge of the knife sheath. Okay, now we're getting to something good. Defendant claims that Sergeant Blaker attributes discovering the knife sheath to Idaho State Police officers rather than Detective Payne. That's true. However, as the state correctly notes, defendant's challenge is nothing more than a quibble over semantics. No, sir, it's not. No, it's not. What Sergeant Blaker stated was that I was later advised by ISP investigators they located a tan leather knife sheath laying on the bed next to Mogen's right side when viewed from the door, and Payne takes responsibility or ownership over seeing it himself. In fact, it was Detective Payne who was the first investigator to discover the knife sheath. That's in the grand jury information. So Payne actually is the first person to put his eyes on it. Wow. Interesting. That's probably why Ann Taylor has been pounding down so hard on wanting these transcripts. That's crazy. There was even like a timestamp. Whew, I want those transcripts. Once discovered, Detective Payne notified ISP investigators. So what did he do? Touch her? Did he touch her? Because we're being told that it was like under her body, like under her leg, right? There was some comforter situation, but we don't really know the like order. We don't know if she was covered up with the comforter, if the comforter was under her leg and then the sheath was like mixed into the blanket somehow. We really have like no idea. We have no idea. We have no idea. That's wild to me. So ISP is in there collecting stuff and they didn't see it. And if they were walking together the way that it makes it sound, like they were literally walking together, being shown the exact same things at the exact same time. There's so much. There's so much here. Okay. Once discovered, Detective Payne notified ISP investigators who then collected and booked the sheath into evidence. At best, Sergeant Blaker's use of the word locate is ambiguous as to whether it means discovering or collecting. Under no reasonable reading could it be characterized as a misrepresentation, let alone an intentionally or recklessly false one. Well, I don't know if it was being categorized as a misrepresentation. It's technically just two different points of view. It's technically just two different points of view. But it's still questionable because, again, the whole time they're making it sound as if they're all walking together. How could he have seen it? I guess if he really did just like see it from the doorway. I guess maybe Blaker went like another direction while Payne was over there. Yeah, and see, that's actually a good question. How is it Payne? Like, he didn't get there till 4. Blaker and him got there together at 4. Okay. Nunez and Smith were the first responders, and I think there was a third one. Was there a third one? And we also know damn well there was freaking cops all over the place. Okay. There were cops all over the place. The video that just came out showing the people sitting next to the dumpster, there was several vehicles already there. So there was already several different police officers there. Gunderson, that's the other one right there. Gunderson, Nunez, and Smith. So how the hell is he the one who found it first? This is ridiculous. Okay. The second alleged misrepresentations are in Payne Exhibit A supporting defendant's arrest warrant application and Mowry Exhibit A supporting the Google warrant application. Defendant claims that both detectives simultaneously claim to have done cell site location information work as well as work to determine whether the defendant's cell phone was in the area of the King Road residence. And now we go to number 12. These exhibits Exhibit A's both state, after consulting with FBI CAST, I was unable to determine estimated locations. I was able to determine estimated locations for the 8458 phone from June 2022 to present. Yeah, we know what this says. Records for the 8458 phone showed that it utilized cellular resources that provided coverage to the area of 1122 King Road on at least 12 occasions. Yeah, we all know that doesn't even matter. Okay. See, but that's another thing. That's what I'm talking about. Like, if Balance helped them draft this thing, why isn't he putting his name in here as the guy that's the FBI CAST guy? Like, he's putting his information, his credentials, and like some classes or whatever that he went to, if I can remember right. But he doesn't put his name. There's no name for who it's about. Defendant notes, however, that both detectives admitted at a subsequent hearing in this matter that it was actually the FBI CAST agent, Nicholas Balance, who performed the location work that the detectives then used to complete their respective affidavits. So to me, he's technically, like, Brian's team is right. Like, if they're sitting there claiming that they're the ones who did it, but instead they just got told what it said by the guy who actually did the work, then that's technically not true. And they shouldn't be able to just lie. They shouldn't be able to just lie. That's ridiculous. Okay. That agent Balance was the individual who actually did the location work does not render the detective's statements intentionally or recklessly false or even misleading. While defendant asserts that the detectives both claim to have done the work, they do not. They state they were able to determine the locations after consulting with FBI CAST. Oh, I guess I got to go back and like pay attention to that because the wording does matter. Both detectives explained in their respective affidavits that CAST was the FBI's cellular analysis survey team. Thus, it was made abundantly apparent to the magistrate that the detectives were relying on work performed by more specialized law enforcement agents in determining the cell phone locations. In sum, as to the statements encompassed in issue 2, defendant has not established that a misrepresentation was made. Moreover, even if the challenge statements could possibly be construed as false, there is not a shred of evidence they were intentionally or recklessly false. Finally, even if the statements were intentionally or recklessly included, defendant has not established they were necessary to establish probable cause. In a common and massive investigation such as this, which specific member of law enforcement actually discovered the knife sheath or performed the location work using CSLI is irrelevant to probable cause. And it quotes Wilson. What is important is that the information came from other law enforcement personnel, which is a reliable basis for the warrant. Consequently, a Frank's hearing is not warranted on the issue. And then goes to number 13. Defendant makes a cursory allegation within issue 2 regarding an email Agent Valance sent to Detective Payne, identifying the dates and times of prior occasions that defendant's cell phone was using cellular resources consistent with it being in the area of 1122 King Road. And again, those cell phone towers have 10 to 20 mile radiuses. So who cares? Defendant contends the dates in that email were different than those in Agent Valance's cast reports. Okay, so that means that they have proof of it. That we already know about the 7-minute difference here. We already know about the 7-minute difference. So this is just more proof that they actually do have it, like actually documented, to be able to prove that this is wrong. However, defendant has not identified a search warrant affidavit that included these allegedly inconsistent dates. Well, that's because the date that's wrong is put in the probable cause order, and the date in the probable cause order is supposed to match the cast report. It's not supposed to be 7 minutes different. So why would the incorrect information be in the probable cause order? There wouldn't be a search warrant affidavit with the wrong information. Is he serious? This is just as stupid. Honestly, for real. This is just as stupid as Ann Taylor thinking that the fact that there was no connection in his apartment, in his car, or all the things should have been told to the magistrate for probable cause whenever none of those things were even tested for or conclusions known of until after the probable cause was already executed and he was arrested. So just the fact that there was no blood or none of the things like that would be irrelevant to probable cause because all of that was found out after the fact. And this isn't the same thing because the incorrect dates would not be in a search warrant. So why is he even using that as a thing here? He just doesn't make sense. He doesn't make any sense. Why would there be inconsistent dates in the warrants? That's not the point. The point is the information used for the warrants is not the information that's actually coming from the data, like coming from the actual evidence. It's not being interpreted correctly. 7 minutes is a huge difference. 7 minutes is a huge difference. The fact he's just being so stupid. Annoying. Defendant has not met his Frank's burden on issue 3 or 10 eyewitness statements. Oh, here we go. This is probably where the vacuum's coming in. You ready? This might be it. Issues 3 and 10. Oh, wait, no, let's read 14. Insofar as the challenge pertains to omissions regarding DM's reliability and consistency, it applies to all warrants. Insofar as it pertains to her non-recognition of defendant, it applies to warrants issued after December 30th of 2022. Yeah, because whatever she did see that night, Bryan didn't look like that guy, according to what she's telling people anyway. Defendant has not met the Frank's burden on issues 3 and 10. I read that part. Okay. In issues 3 and 10, defendant challenges the probable cause statements insofar as they set forth witness DM's interview descriptions of things she heard and saw on the night of November 13th of 2022. And of course, there's another footnote. DM was a roommate of the deceased and was in her own bedroom at the time of the homicides. She didn't stay there, though. Defendant claims that law enforcement failed to inform the magistrate that DM's accounts describing the suspect were variable, that she questioned her memory, and that she did not recognize defendant when provided with a photo of him after his arrest. They didn't even ask her. They didn't even ask her until after they arrested him. That's what we were looking for. We were looking for that time. Was it before or after? Now we know. Now we know. Wow. Defendant also contends that law enforcement misrepresented statements made by DM, Dylan, that would have demonstrated her unreliability. These allegedly false statements and omissions, according to defendant, were exculpatory and material. I want to know about that. While defendant's challenge may be fodder for cross-examination, it is not the proper subject of a Frank's motion. Defendant's own proffer establishes that Dylan's accounts were remarkably consistent throughout her multiple interviews with law enforcement, and further, the probable cause affidavits are very consistent with her accounts. That's not what was said. Though her claiming that she had memory issues, that she thought her mind was playing tricks on her, that she had been inebriated, intoxicated on something that made her brain or made her feel like her brain was making her see things, that she didn't know whether it was a dream, that she didn't know if it was real. Those things are consistent. But that is not at all what's in this freaking PCA. And Ann Taylor never said that either. She said everything else was consistent, but that everything in the PCA wasn't really what Dylan said. Okay. Whatever you say, Hippler. Second, Dylan's interview statements that her memories were fuzzy and dreamlike and may have been affected by being tired or under the influence of alcohol. Bro, you are trying to save her, aren't you? Jesus Christ. Do not call into question her reliability to the extent Frank's would require disclosure. Yes, it does. I mean, maybe not the Frank's thing, whatever the hell you're trying to say, but don't even sit there and act like she's reliable or credible at all. Just stop. Just stop. Finally, Dylan's failure to recognize the photo of defendant is of no consequence, given that the intruder she saw, that doesn't matter. It doesn't matter that he had a mask on. His eyes are shaped a certain way. They're a certain distance apart. Y'all literally threw everything on the table for some bushy-ass, caterpillar-ass eyebrows that he doesn't have. So it doesn't matter that who she saw was wearing a mask, because we were told that this is what the mask showed. So if this wasn't recognizable, how does it not matter? How does it not matter? Did he seriously just say, he was in a mask? Well, the type of mask does matter. And it's not like he was in full on everything and just little bitty eyeballs sticking out. This is a big identifying portion of the face. I'm just wow. Wow. Okay. I think we're getting into some stuff now, because we're getting into statements. Okay. Diem's accounts were consistent and accurately summarized in the Exhibit A's. Okay. Now, this is apparently stuff from the draft exhibit that we don't have access to. The draft Exhibit A, circulated by law enforcement, included the following description of statements Dylan made during her interviews with law enforcement. Circulated by who? Oh, I guess because they were going back and forth with it, doing their drafting stuff. Okay. Dylan made statements during interview that indicated the occupants of the King Road residence were at home by 2, reportedly asleep by 4. This is with the exception of Kernodle, who received a DoorDash order at the residence at approximately 4. Dylan stated she was awoken at approximately 4 by what she stated sounded like Goncalves playing with her dog in one of the upstairs bedrooms. Okay, is this all going to be the exact same thing, like verbiage from the PCA? I'm not going to reread it. I guess I maybe have to, though. Okay, I guess just in case he throws something in there. A short time later, Dylan said she heard who she thought was Goncalves say something to the effect of, "There's someone here." A review of forensic records associated with a download of Kernodle's cellular phone indicated she was likely awake and using the TikTok app at approximately 4:12 a.m. I wish that they would throw in some information about that situation, because we have nothing at all worth a shit when it comes to Ethan and Xana, and that is really like the biggest just wow to me. Dylan stated she looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. Dylan stated she opened her door a second time when she heard what she thought was crying coming from Kernodle's room. Dylan then said she heard a male voice say something to the effect of, "It's okay, I'm going to help you." At approximately 4:17 a.m., a camera at 1112 King Road picked up audio of what sounded like a struggle coming from off camera. The security camera is less than 50 feet from Kernodle's bedroom wall. The struggle lasted less than 1 minute, and unintelligible sounds can be heard from the camera. That audio, if they play it, it's going to be really hard to listen to, if they even play it. Thank you, Lisa. Lisa just gifted 10 memberships. Thank you so much. That's very kind of you. Thank you. Congratulations to those of you who get those. Okay, let's go. Dylan stated she opened her door for the third time after she heard the crying and saw a figure clad in black clothing and a mask that covered the person's mouth and nose walking towards her. Dylan described the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. The male walked past Dylan as she stood in a frozen shock phase. As the male walked towards the back sliding glass door, Dylan locked herself in her room after seeing the male. Sure, she didn't stay there. This portion of the draft Exhibit A was incorporated in varying degrees into Blaker's Exhibit A, Payne's Exhibit A, and Mowry's Exhibit A. When these Exhibit A's were submitted in support of search warrant applications, Dylan had set for at least 3 interviews with law enforcement. 2 on November 13th, 1 with Nunez and later with Detective Mowry, and 1 on November 17th of 2022 with Detective that guy. I'm not saying that one. And number 16, the interview with Officer Nunez is exhibit. Okay, so it's just labeling the exhibits. But then it also says that she interviewed with Detective Lake after the arrest, and that would have been whenever they showed her the photo, and she said that she didn't recognize that portion of his face. Oh, here it is. Here it is. While she did not tell Officer Nunez that she noticed the intruder carrying a vacuum-type object in his hand, she did convey that information to Detective Mowry later that day, as well as to Detective that thing a few days after that. She also told that detective that she remembered the suspect's eyebrows were bushy, but could not remember their color. Dylan likewise told Detective Mowry she could not remember the color of his eyebrows. Yeah, we know that. More importantly, not only are Dylan's statements consistent with each other with regard to the intruder's description, they were accurately included by law enforcement in the Exhibit A's set forth above. There is not one statement in the affidavits regarding the intruder that cannot be traced directly to Dylan's words. Consequently, defendant has not demonstrated an intentional or reckless false statement or omission of a material exculpatory fact with regard to law enforcement's recounting of Dylan's descriptions of the suspect. But we don't know that. We don't know that because we don't know what she said. So at this point, I can't trust you, broski. I don't know what you're talking about because you have been ridiculous this entire time. So I can't even trust your interpretation of those things. There's no way. No way. Defendant also asserts that Exhibit A watered down Dylan's statements about hearing Kaylee Goncalves around the time of the homicide. According to defendant, Dylan was unequivocal in her 3 interviews when she reported that at approximately 4 a.m., she heard Miss Goncalves walk upstairs with her dog before running down the stairs saying someone's here. Why was she downstairs? See, whenever that was mentioned in court, I could have, it sounded more like it was about Xana. It sounded more like she was talking about Xana because they said up and down. So how is Kaylee in her room at 4 o'clock? Her room is upstairs. And she had Murphy with her? So Murphy was with Kaylee downstairs and then ran upstairs with the dog saying that somebody's there? 18. And I guess it's just exhibit freaking weird stuff. Okay. I'm already aggravated. I mean, I've been aggravated, but I'm aggravated. Miss Goncalves walk upstairs. So she walked upstairs with her dog, saw somebody upstairs, and then ran back down the stairs saying that somebody was there. Well, that would almost make it seem to me as if the suspect was already up on the 3rd floor while the freaking DoorDasher was knocking on the door or knocking on the slider or ringing the doorbell or doing whatever the hell is supposed to be happening here. So she was upstairs on the 3rd floor and then was downstairs for some reason with her dog. Did she answer the door for the DoorDash? There's a lot here. So Kaylee was not in her room. This is proof right here that Maddie and Kaylee did not fall asleep in the same bed. So there's that. Because she's awake and downstairs with her dog, not asleep in the same bed. So whatever ended up happening, she didn't know that there was a person there until she went up the stairs, and then she came running back down yelling about there's somebody being there. This changes like so much things. This changes a lot because the Goncalveses should know this. And they've been hounding down this love story between Kaylee and Maddie that didn't need to exist. Okay, it's sad and tragic enough. They didn't have to do all that. And I've questioned this whole time. That entire scenario. So that doesn't mean that they fell asleep in the same bed. She could have easily been fighting the person and got thrown onto that bed after everything was over. Wow. Okay. Okay. Hold on. Okay. This is wild to me. Like everything in my head is like playing differently because like I said, I always knew that they didn't fall asleep in the same bed, but in my brain, I saw her in her room with the dog, maybe hearing something, maybe feeling like something was going on or hearing something coming from Maddie's room. She walked out of her room, went to Maddie's room. Instead, this is something that brought her downstairs. So did she, it's almost like she answered the door for DoorDash. Because you're downstairs around the exact same time. It's approximately 4:00. Did you go answer the door or did you go get Xana's attention and be like, hey, your DoorDash is here? Like, what happened to make you not be on the 3rd floor? And again, the Goncalveses know this. They're not, they know these things. They were told this stuff. So why are they coming out here playing mind games with people? Trying to emotionally pull things that don't need to be pulled, saying, oh, they fell asleep in bed together after a drunken night. No, they didn't. This is proof that they didn't. So why lie? Why lie? Ooh, okay. Okay. Defendant argues the addition of the words thought is false, and further, defendant surmises it was intentionally false to cover up the fact that Dylan was wrong about what she heard. Defendant points out that Miss Goncalves was killed in the upstairs bedroom where she was found the next morning. Thus, it could not have been her who Dylan heard running down the stairs at 4:00. And I always said Anne was wrong about that. I always said Anne was wrong about that. Just because she ended up somewhere at the end doesn't mean she wasn't running around the house first. I called that out the day that she said it on the live. I said, that doesn't mean that. That doesn't mean that at all. Defendant contends that Dylan's misperception, had it not been covered up by law enforcement, would have cast doubt on her reliability and therefore probable cause. But I don't really see how that would have done anything against probable cause. Because just because Kaylee might have been on the 2nd floor, went up the stairs with Murphy, and then ran back down yelling that somebody was there, that doesn't really do anything for guilt or innocence either, because it's not like she's like recognizing him. She's not saying anything that could alert anybody else to who this person was or people were. Okay, there's nothing there. There's nothing there for that. However, the statement challenged by defendant can be read in 2 ways. One, that Dylan said, I think it was Miss Goncalves, which is how defendant apparently reads it, and which he claims is inconsistent with Dylan's interview statements. Or 2, that Dylan said she heard Miss Goncalves, but law enforcement had reason to think it could have been someone else. Well, the PCA literally states it could also have been Xana, like it's actually in there. It's actually in there. When the statement is viewed in context, the latter makes more sense. In their respective Exhibit A's, Detective Payne and Sergeant Blaker immediately followed up the challenged statement with the following. A review of records obtained from a forensic download of Kernodle's phone showed this could have also been Kernodle, as her cellular phone indicated she was likely awake and using the TikTok app at approximately 4:12 a.m. Okay, but Xana wouldn't have had a dog with her. And even if you are on something, you've been drinking, whatever, okay, whatever Dylan is claiming to have seen consists of the dog. Consists of the dog. Which would mean that the dog was just running around freely in the middle of all this weird, crazy insanity and still didn't get no blood on him. Is that what we're supposed to believe? Wild. Bonkers. Absolutely freaking bonkers. Through this explanation, Payne and Blaker are effectively conveying to the magistrate why they believed Dylan's statements of who she heard was questionable. Thus, the court cannot conclude there is anything false or misleading in this regard. Well, it also doesn't prove anything when it comes to probable cause either, whoever was heard. It doesn't matter if it was Xana or if it was Kaylee. It doesn't prove anything when it comes to Bryan. I mean, it doesn't. In addition, even assuming it was a false statement, defendant has not established that it was an intentional or reckless attempt to hide Dylan's alleged misperception. And how we have another one. Based on defendant's proffer, it is not a foregone fact that Dylan was mistaken when she said she heard Miss Goncalves. Dylan reported it was approximately 4 a.m. when she heard Miss Goncalves walk upstairs and then run back down saying someone is here. Saying or screaming? Saying or screaming. I mean, you'd think that if you just walked up to the third floor where you probably just came from, I believe that you would be screaming about somebody being there. Miss Kernodle received a DoorDash delivery at the residence at 4 a.m. At 4 a.m. or at approximately 4 a.m.? Which one? It is entirely possible Miss Goncalves ran downstairs when she heard the delivery person and then went to bed, after which she was killed. No, that doesn't make sense either. I mean, hold on, it might. No, it doesn't make sense either. Because there'd be no reason for her to have been running back downstairs. Like, if you were already where the door was and you were going back upstairs, you would have said something about there being somebody there as you were taking your dog back upstairs. But you get all the way up to the stairs and then you run back down saying somebody's here. That does not sound like the DoorDash guy that she's answering the door for, or person that she's answering the door for. It sounds like she went upstairs, noticed that somebody was up there, freaked the shit out, and then ran back down and had Murphy running wild in the house the whole time. And we're also supposed to believe that, like, the front and or both the front and the slider were both just wide ass open for 8 hours, and the dog didn't run away, but is found in Kaylee's room with the door wide open. How come nothing makes sense? Like, not even the way the dog behaves makes any sense. Let's be for real. Okay. Or that her actual statement was exculpatory or otherwise material to probable cause. I mean, I agree. It really doesn't do anything either way. A Frank's hearing is not warranted with regard to statements in the relevant Exhibit A's regarding Dylan's account of what she saw and heard. 2, there is no evidence law enforcement intentionally or recklessly omitted information bearing on Dylan's reliability or that such omissions were material to probable cause. Defendant next asserts that the probable cause statements omitted important information bearing on Dylan's reliability. Defendant notes that Dylan qualified her interview statements on several occasions by questioning her memory of the event. For example, she told Detective Mowry, everything was kind of blurry. Like, I don't fully remember it, I would say. A few days later, while recounting the events to Detective, Dylan stated, again, I believe I was also very drunk. I don't know how much of this is real. Like, I don't know if my mind was like doing whatever. I don't know any of it. Like, half this stuff, I don't know if it's a dream or if it's real. I just have no clue. That's the part that Ann Taylor read in court. She also said her memory was fuzzy and cloudy, and she could not differentiate if anything is real or if anything is a dream. This information was not included in the Exhibit A's. According to defendant, this information was crucial to allow the magistrate to properly evaluate DM's reliability, and its omission was material and exculpatory. The law does not favor defendant in this argument. Probable cause is determined by examining the totality of the circumstances and making practical common sense decision. Please, whether given all the circumstances set forth in the affidavit before the court, including the veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place, except you've found nothing. You've looked in all the places. You've found nothing. So you might want to rephrase that last one. Whether the hearsay supplier is reliable is dependent in part on their status. Unlike an informer from the criminal milieu, crime victims or witnesses are presumed reliable and may be relied upon without independent corroboration. I don't see how or why, literally at all. A detailed eyewitness report of a crime is self-corroborating. It supplies its own indicia of reliability. Despite this presumed reliability, police must always be alert to whether other facts which have come to their attention raise doubts about the veracity of the witness. Such facts might include a motive to exaggerate or falsify statements made to law enforcement, or when the hearsay supplier is a young child or suffers from psychological delusions. In such circumstances, corroboration is required to establish reliability, and now we have a 21. And it says to see Wesley versus Campbell, no probable cause based on uncorroborated essay claim by 7-year-old who had a history of psychological problems. Where officer knew alleged victims were being evicted and likely bore a grudge against their landlord, it was unreasonable to arrest the landlord on the victim's report alone without further corroboration. So in this case, a 7-year-old came out and outcried that a landlord had touched them. And because the landlord was kicking them out for not paying the bills, they didn't believe the kid. Okay. I don't think I can get any more pissed off. However, this is not a burdensome requirement. The corroboration of even innocent minor details can support a finding of probable cause. Any omissions of facts bearing on an individual's reliability will only be considered misleading under Franks if the omitted facts cast doubt on probable cause. Misrepresentations or omissions that could impact the credibility assessment of a witness do not trigger a Franks hearing where probable cause is nevertheless established through other evidence. And then we have 22 State versus Peterson. Although officer failed to include in search warrant affidavit that juvenile informant had lied to the officer in the past and was expecting favorable treatment in return for providing information to police. No Franks violation because these omissions were not a sufficient magnitude. See, that's some crap right there too. Like, you can't sit there and act like somebody has a history of being a snitch and getting away with things because they're a snitch and then not question their motive for the next time they come and say something. Every time they do it, the things that they say get a little bit less credible because they're doing it for selfish reasons. So there's that. I'm just going to continue. None of Dylan's qualifications during her interviews reasonably placed her presumed reliability in dispute. She was a direct witness and was able to consistently articulate the details she remembered throughout each interview, especially as to the facts relied on in the search warrant affidavits, despite the fact that she claimed her memory was fuzzy, or that she felt like it was a dream, or that she was still intoxicated. Further, even if her reliability were in question, there was other evidence included in the Exhibit A's that corroborated her account. For example, For example, the security camera from 1112 King Road picked up audio of a struggle at 417, which coincides with when Dylan stated she thought she heard crying coming from Kernodle's room and a male voice speaking. But see, that's longer because if it's like 4 o'clock in the morning and Kaylee has now walked downstairs walked upstairs, ran back downstairs. Then we have 17 minutes in between that 4 o'clock. And they're wanting us to believe that this all happened in like 7 to 9 minutes. None of their stuff makes any sense. Okay, picks up the struggle at 4:17 a.m., which coincides with when Dylan stated she thought was crying. I think it's supposed to say stated when Dylan stated she thought what she heard was crying. There's words missing. What she thought she heard was crying coming from Kernodle's room and a male voice speaking. It was shortly after this she opened the door for a third time and saw the suspect walk by her towards the sliding glass door, which corresponds with the surveillance video showing the suspect vehicle leaving 1122 King Road at 4:20 a.m. In addition, law enforcement corroborated Dylan's description of defendant through its vehicle identification efforts, which led investigators to defendant's driver's license information. But it didn't. Not until you had the damn name from the feds. No, it didn't. No. If you would have had his driver's license information before you sent everything off to the feds, I could let you make it on that one. But you're lying. You're lying. The Exhibit A's note the defendant's physical description was consistent with Dylan's accounts, except she doesn't recognize that freaking eyebrow or them sets of eyes or those cheekbones or the nose. Okay, Kohberger doesn't have no little bitty old nut the nose. He's got a big nose, like a prominent nose. So you don't even recognize the nose? That's wild to me. The defendant has shown no objective indication that Dylan's interview statements were unreliable, particularly given the other corroborating evidence, and therefore no reason for law enforcement to include her qualifications in the affidavit. For this reason, it cannot be said that law enforcement intentionally or recklessly omitted this information. Further, the Exhibit A's inferred that Dylan was traumatized when they noted that she stood in a frozen shock phase when she saw the intruder. This necessarily alerted the magistrate that Dylan's memories were colored by trauma and shock, which goes to the issue of her reliability, the defendant's targets in this motion. Okay, this whole thing about her standing there, like a little bit shocked for a second, makes a tiny bit more sense to me, if any truth to it, because now they're claiming that she saw the person holding something in their hand. But not a weapon? But not a weapon? A big thing that looks like a vacuum? Sure. Finally, even had the Exhibit A's included Dylan's qualifications to her memory, it would not have significantly undermined her credibility. It would not have been negated probable cause. It would not have negated probable cause. It would be no surprise to the magistrate that a person experiencing what Dylan must have experienced would be shaken by what happened and would have questioned the reality of what she perceived. This does not render her unreliable. Additionally, the bulk of probable cause came from other sources, including the extensive vehicle identification efforts. Really? You mean how you identified a car that was going the wrong direction at the wrong time on a road that wasn't King? Great work, guys. Super freaking A freaking plus. Thus, even if the magistrate questioned the reliability of Dylan's account, she had sufficient grounds through other evidence to issue the warrants. No. The only reason why that freaking warrant even got issued is because the freaking FBI gave Moscow the name. They wouldn't have gone and done all this crazy shit if it wasn't for that. They know that. In sum, defendant has not shown that Dylan's various qualifications to her memory or material exculpatory facts that were intentionally or recklessly omitted and that would have affected probable cause. It is evident from the applicable Exhibit A's that Dylan's account was largely relied upon to establish the timing of the homicides and a general description of the perpetrator, not to identify defendant specifically. That freaking description fits every man that was outside in the Banfield. Let's be for real. Pretty much like 90% of those people that were out there is the description that Dylan gave. Her statements on these matters were consistent. While any perceived weaknesses in her memory may be fodder for cross-examination, they do not negate probable cause, which is not oh my God, I can't even talk. That is not an inaccurate statement. Not an inaccurate statement. It is enough for probable cause. Just like I said, the sheath DNA is enough for probable cause because it's there. It's at the crime scene. But when it comes to the cross-examination, she's going to be proven not credible because she's not going to be able to look at Bryan and say, yeah, that's the eyebrows. Yeah, that's the set of eyes I saw. Yeah, that's the nose. She's not going to be able to say anything. Like, Dylan's sort of pointless here. Like, all the way around. Pointless. And all of this still, like, you cognitively are seeing somebody coming downstairs with their dog, running, like going back upstairs with their dog, freaking out about seeing a person and running back down, talking about how there's somebody there. You hear all of these things, and then you see somebody walking around with something in their hand, and you're still not doing what you're supposed to be doing. You're still not calling 911. You're still not getting out of the house to get to safety to call 911. You're not trying to get the rest of your roommates out of the house. You're not trying to go and drag Bethany out to go and save her or do anything like that. You're calling everybody in the house. You know, you just saw Kaylee freaking out. You're calling her phone. She's making this whole thing is just so stupid. Dylan's non-recognition of defendant is immaterial. Defendant also contends that law enforcement's failure to include Dylan's non-recognition of defendant in the Exhibit A's warrants for Frank's hearing. During her December 30th, 2022 interview with law enforcement, Dylan was shown defendant's mugshot and asked by Detective Lake whether defendant was the person she saw in her house. Dylan responded, "I have no clue. From what I remember, I just remember seeing this figure that was more of like skinnier tone build and some mask on." So right then and there, she's saying that Bryan's too big. Bryan's too big to be the guy. And some mask on. I don't know if it was covering his mouth, his nose, or below his mouth and nose. I just remember he was white, but I didn't know how he was white. I just knew he was. And I knew he looked at me because of the bushy eyebrows. What the frickin' frick? What the what? I don't know how he was white. I just know he was white. Well, normally you're born that way, honey. Unless you're Michael Jackson, you are born that way. What do you mean? That is an odd-ass statement. Like, is she trying to say that he had some, like, white face? White face? Was he in white face? Like, is that what she's trying to say? What a strange statement. I don't know how he was white. I don't know how he was white. What? I don't know. How else do you be white? I don't understand. Weird. Okay, however, the fact Dylan could not identify defendant is hardly exculpatory or material to probable cause, which is true because they didn't even show the photo of Bryan until after his arrest. Give me a second. Again, it does make sense to the probable cause orders that they're talking about now because the picture was not shown to Dylan until after he was already cuffed. So again, you knew for like, they got it on the 19th. They showed her this on the 30th. So they knew for like 11 days. 11 days. They couldn't have shown her a picture from his license or his anything anywhere before the arrest to see what she said? Or did they purposely wait because they knew that she wasn't going to actually be able to recognize him and they didn't want it to be a problem for the PCA? Because now I just don't trust anything even more than I already didn't trust anything. So there's that. However, let me read that part. Okay, so then it says to see United States versus Coakley, from 1990, holding that omission of non-identification from photo spread was not material, and that the Fourth Amendment does not require an affiant to include all potentially exculpatory evidence in the affidavit. Her interview statements consistent described a black-clad, masked person who was not someone she thought she knew or could identify. Her inability to recognize defendant unmasked is expected, not really, no. Sorry, I don't care what y'all try to say, no. Particularly where her description is relied in Exhibit A's described a mask that covered the person's mouth and nose. Thus, because her non-recognition is not material and exculpatory, defendant cannot demonstrate the failure to include this fact in the probable cause affidavit warrants a Franks hearing. I agree, because again, they didn't show her the photo till after he was arrested. Defendant has not demonstrated law enforcement omitted it intentionally or recklessly, or has he shown how including the information would have affected probable cause? Well, if the main witness that you're freaking relying on in the entire damn probable cause says that she doesn't recognize the guy that you're trying to arrest, I'm pretty sure it would actually hold some weight. Let's be for real now. They knew that. That's why they didn't show her until after, because they knew she wasn't going to be able to recognize him. They can lie somewhere else. Okay. Lie somewhere else. One simply cannot say that had law enforcement included a statement that Dylan, unsurprisingly, was unable to recognize defendant from a photo, the magistrate would have not found probable cause. A Franks hearing is not warranted on this issue. 17 more pages. Let's go. Defendant has not met his Franks burden on issue 4, vehicle identification. Issue 4 applies to all warrants, according to the 23rd footnote. In issue 4, defendant takes issue with Exhibit A insofar as it describes the suspect vehicle captured through various surveillance cameras. It states, law enforcement officers provided video footage of suspect vehicle 1, which I've always had issues with there being a number there, to vehicle specialists with the Federal Bureau of Investigation that regularly utilize surveillance footage to identify the year, make, and model of an unknown vehicle that is observed by one or more cameras during the commission of a criminal offense. After reviewing the numerous observances of suspect vehicle 1, the vehicle specialist initially believed that suspect vehicle 1 was a 2011 to 2013 Hyundai Elantra. Upon further review, they indicated it could also be a 2011 to a 2016 Hyundai Elantra. And now this is coming from the draft exhibit, the one that Balance helped write. Defendant claims there are two material... Oh, hold on. There's a 24th footnote. Similar statements were made in Blaker Exhibit A, Mowry. Okay, yeah, whatever. Okay. Where we go? Okay. Defendant claims there are two material and exculpatory omissions in this paragraph. First, he asserts law enforcement should have disclosed the FBI's vehicle specialist felt more comfortable with the 2011 to 2013 date range of the suspect vehicle. That matters. Considering the year that Bryan's car is, that matters. That like hella matters. They can quit pretending like it doesn't matter. Second, he asserts that the specialist opinion expanding the date range was predicated on the erroneous use of a video taken from Ridge Road, which law enforcement knew or should have known was not the suspect vehicle. Remember, we were told wrong time, wrong direction when it came to Ridge Road like months ago. Maybe longer than months ago. Like it's been a while, like a super long time since we've heard that part. I have to go back and see because I know damn well I probably titled the title of the video is probably something about that. Defendant also faults the officers for failing to provide the magistrate with the footage reviewed by the specialists, which, according to defendant, would have demonstrated to the magistrate that a vehicle identification could not have been reasonably made, meaning that it was too blurry, you can't see anything, there's nothing to actually define the vehicle. The court finds defendant's challenges are unsupported by his proffer and do not warrant a Franks hearing. That the FBI specialist may have been more comfortable with a narrower date range than that represented in Exhibit A is unsupported and immaterial, but it's not. This is just them literally making every excuse in the book for why it's okay that they reverse engineered this entire situation. This is gross. Defendants claim that the FBI vehicle specialist felt more comfortable setting the year range of 2011 to 2013, and law enforcement knew their specialist was of the opinion the car was also certainly between 2011 and 2013, is based on an email chain between that specialist, Agent I feel ancient. Agent Anthony Emile and another FBI agent about their investigation. However, the email chain does not support his argument. What the email chain shows is that on November 26th of 22, Agent Emile directed the FBI to open up their search to 2011 to 2016. In doing so, he discussed the changes to the Hyundai Elantra in 2014 and 2017 and stated that he wanted a better shot of the vehicle's front fog lights and rear reflectors. He further added, rather not leave anything out, better safe than sorry. 5 minutes later, he sent another email stating, yeah, I see the change in 2014, and I'm not really a fan of the 2014, much prefer the 2011 to 2013, but wanted to lay that out. Have a good night. We'll keep looking and send any new info I can come up with. Better safe than sorry. Blah, 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 blah. I still much prefer 2011 to 2013. What do you mean this doesn't support the defendant's argument? To me, that supports the argument. This supports the argument. These emails demonstrate that it was Agent Emile's decision to open the date range to 2011 to 2016, despite his preference for 2011 to 2013. That's because there was nothing that was not blurry or not wrong or not the wrong time or not the wrong date that they could go off of. That's what we've been being told this entire time. There's a reason why Ann Taylor is telling us in court that they have to stitch together all of this freaking car evidence. There's a reason why the identification of the vehicle wasn't done at the King Road car, that it was done way down the road. There's a reason for all this stuff. There's a reason for all of this stuff. And everything that I just read that is in this email does support Bryan's argument, in my opinion. In my opinion. While Exhibit A did not call out that Agent Emile preferred narrower time frame, defendant has not shown his omission to be exculpatory and material. Considering that that's not the year of Bryan's car, I don't see how it wouldn't be a little bit, just a teeny bit, Exhibit A is replete. I don't think I've ever seen that word either. Deplete with evidence linking defendant's vehicle and cell phone to suspect vehicle 1. Actually, no, it's off by like a few minutes each time. Like they're not in perfect sync with each other. Considered as a whole, it cannot be reasonably concluded that Agent Emile's preference for a narrower date range would have derailed the magistrate's finding of probable cause had it been included. But it probably would have, because there's distinguishing things that prove one way or another. Probable cause is not an exact science and does not require that law enforcement establish with absolute certainty that the facts alleged in search warrant affidavits are in fact true. Meaning you can lie, it's fine. It's not important enough. It's not the final evidence gathering, so it's okay if it's false, basically. Simply because Agent Emile may have felt more comfortable with earlier years within the range he provided does not mean he felt uncomfortable with the later years. Man, but it kind of does, bro. He's telling you what he wants to say based off what he knows from his expertise, but he's expanding it just to cover all their bases and cover their asses, basically, while still telling you, but this is where we probably should look. I mean, it seems pretty clear to me. I'm just saying. Thus, it is highly unlikely the magistrate would have disregarded the specialist's identification of the larger date range or otherwise declined to find probable cause simply because Agent Emile preferred the narrower range. Narrower. I always feel funny saying that word. Further, there is no evidence the information was intentionally or recklessly omitted. That sounds like a personal opinion. Thus, a Franks hearing is not warranted on the issue. Now, there's a 25 footnote. Defendant infers that it was intentionally or recklessly omitted by pointing out that one of the earlier search warrant affidavits and ISP's November 25, 2022 BOLO bulletin indicated the suspect vehicle was a 2011 and 2013 Hyundai Elantra. He posits that it was only after he was identified through investigated genetic genealogy that the date range of the Hyundai was opened up to include the model year of defendant's Elantra. However, the court is not willing to accept defendant's interference. Not interference. I read that word wrong. Inference. See, I'm glad I double checked. Discrepancies between these documents and the later Exhibit A's challenged by defendant merely reflect that there was an initial belief that the suspect vehicle was a 2011 and 2013 that was subsequently revised. It is not indicative of an intentional or reckless omission. Further, the FBI emails clearly show that the specialist expanded the date range on November 26, 2022, well before defendant was identified through IgG in mid-December of 2022. But he didn't want to expand it, is the point here, broski. He didn't want to. For some reason, he felt like he had to. But he pretty much kept his consensus that this is where he wants it, even though he sees this thing apparently. But what's the change? Like, I wish they would have been specific on that. What was this little change of 2014 that they're talking about? Now that's what I want to know. All right, where was I? Okay. Thus, a Frank's hearing is not warranted, blah, blah, blah. Okay, number 2. Defendant has not demonstrated a false representation or omission with regard to identification of the suspect vehicle. Defendant's next challenge, Exhibit A, on grounds that the FBI vehicle specialist identification of suspect vehicle 1 as a 2011 to 2016 Hyundai Elantra was based on video footage from Ridge Road that law enforcement knew or should have known was not suspect vehicle 1. Defendant states that he knows law enforcement based its identification of the vehicle on the Ridge Road footage because we have the emails from the FBI specialist who explains on November 23rd of 2022 that their team is mainly looking at the window configuration. Something these other images do not. But later that day, the FBI agent sends them images from this video, calling it a great one. Okay, so there is like a cut in the back window that's like a certain angle, and I wonder if that's what he's talking about. The window configuration. I wonder if that's what he's talking about. However, defendant's proffer does not show the FBI specialist identification was, in fact, made on the Ridge Road footage. The FBI emails defendant contends support his position contain no mention of Ridge Road footage and no mention that the FBI was mainly looking at the window configuration. See number 26. Defendant's lack of citations to the record was the reason the court required defendant to submit an amended Frank's memorandum and exhibits. Defendant's continued failure to cure the problem on this issue indicates there was no evidence showing the vehicle identification was based on the Ridge Road footage. In any event, the court will not scour the record to find factual support for defendant's argument, meaning they probably just didn't label it. They probably just didn't label it because she looked like she was reading off of something whenever she was talking to us, talking to the court about Ridge Road. So I'm going to have to definitely go back and re-listen to the way that it was said and what she was doing at the time. Like, where was she reading something? Was she looking at something? I'm going to need to look at all of that stuff. Okay, let's see. Where was it? Defendant asserts that the email stating got a great one attached images from the Ridge Road footage, but there is nothing in the proffer establishing that images were in fact attached, and importantly, that what those images were. Well, we were also told that they were given a bunch of stuff, like not in chronological order, not in sequential order. Like everything was pretty much just like put all together, and then they were like here. And we've heard that some of it literally has nothing to do with literally anything. Like Brian's car is not at the cannabis shop. They can't put his car actually at the location. That's a big problem. They can't pretend like it's not a big problem. Okay. At the pre-Franks hearing, the court inquired further into defendant's support for his position that the identification of suspect vehicle 1 was based on the Ridge Road footage. Counsel again referred to the FBI emails and unlabeled screenshots produced on page 17 of defendant's amended memorandum that defendant claims were from Ridge Road footage. Well, look, I'm going to tell y'all now. They made it very clear in court that they did not label, relabel, correct anything. They gave everything over in the way that it was given to them from the defense. That's how I understood it. But if they were trying to prove their case, they probably should have gone in and corrected some of those things, because now we're here. Now he's, oh, well, it's not labeled, it's not attached. Well, I don't know if we can still blame that on the state whenever the defense is supposed to be the ones trying to put everything together. Like, you should just be like, came in with no label, corrected to be an attachment. You know what I mean? Like, they should have done something different than that. Okay. This is insufficient to establish beyond speculation the Ridge Road footage that was the basis for the identification. Even assuming it were, however, defendant has still failed to carry his burden under Franks. Because the vehicle identification came from the FBI, which was disclosed to the magistrate in the Exhibit A's, there is a presumption of reliability. And then this Ventresca from 1965. Observations of fellow officers of the government engaged in a common investigation are plainly a reliable basis for a warrant applied for by one of their number. They said that before too. Thus, at a minimum, defendant must establish that the search warrant affiance knew the FBI specialist identification was based on incorrect footage, yet intentionally or recklessly relied on it anyway to obtain warrants. There is no evidence to this end. Assuming the Ridge Road footage was, in fact, not of suspect vehicle 1, the affiants were not part of the FBI email chain, which allegedly evidences the use of the Ridge Road footage to make the identification. Further, there is no evidence law enforcement provided the Ridge Road footage to the FBI for identification purposes. Oh, with like knowing that it was not a suspect vehicle 1. Okay, whatever you want to say. Defendant has not met the Franks burden on issue 5, which is a misleading timeline. That's the biggest, like, out of all of it, is how screwed up the timeline is. They completely shifted this by like over an hour. Okay, they shifted this by an hour from what their original story was, because their original timeline with the missed calls to Jack off both the girls' phones and all this stuff made hella sense until they did this, and now everything don't make no sense at all. They arrested Bryan and tried to finagle the timeline, and now nothing makes any sense. Wild. Okay. In issue 5, defendant claims that law enforcement created a false narrative of their investigative timeline in Exhibit A so as to make it appear that defendant was identified through their investigative efforts and not, in fact, through IGG. That is the truest statement in every single one of these documents that we've read so far. It's not, and that's not a false statement either. The feds literally did everything and handed it over to Moscow and said, okay, now take the credit. They know that this is true. They can lie somewhere else. They can lie somewhere else. In other words, he argues that law enforcement, having already identified defendant through IGG, tailored their Exhibit A to support probable cause for an already identified suspect, not an unknown suspect. Defendant provides 2 examples of what he contends are misleading timelines about his identification, but these examples fall short of the Franks standard. Oh, everything falls short for you, Hippler. You probably fall short in lots of things. I'm just saying. First, defendant notes that in Payne's Exhibit A, Detective Payne states that on November 29th of 2022, officers from Washington State University queried white Hyundai Elantras registered at the school and pulled up a 2015 white Hyundai Elantra with Pennsylvania plates that was registered to the defendant. Exactly, but what did we hear? That they didn't even know about that tip until after they had the name from the feds. They did not go and look into that car miraculously within a day or so of getting that tip from WSU. They did not know shit about it, per what was said on the stand by, I believe it was Payne. They didn't know crap about this 1129 tip until after the feds gave them Bryan's name. So they've already told us that in court. They literally told us that in court. We all heard it. Pretty much everybody that was in here was listening along with me at the live and were also in here whenever we did the live review. We all heard it. We all heard it. Okay. They pulled up. I read that part already. Okay. That same day, Detective Payne states another WSU officer was patrolling the area by defendant's apartment and located a 2015 white Elantra with Washington plates. He ran the plate and it returned to defendant. Defendant points out that Detective Payne was not even aware of the WSU officer's findings in this regard until December 20th of 2022, after defendant was already identified by IGG. She said that there was correspondence to prove this, okay? So we're going to find out. He better have some actual information in here and better not just say a bunch of doo-doo, because she says there's correspondence. So let's find out. Okay. However, he contends Payne's Exhibit A makes it appear the defendant was identified in part through the WSU queries. Second, defendant takes issue with Detective Payne's focus on suspect vehicle 1's lack of front license plate. In Payne Exhibit A, he discussed his review of surveillance footage, noting, a review of camera footage indicated that a white sedan, hereafter suspect vehicle 1, was observed traveling ... westbound on Steiner Avenue at Idaho State Highway 95 in Moscow at approximately 3:28 a.m. On this video, it appeared suspect vehicle 1 was not displaying a front license plate. Detective Payne later points out that defendant registered his 2015 white Elantra with Washington State on November 18th of 2022. He noted that previously the vehicle was registered in Pennsylvania, which, unlike Idaho and Washington, does not require a front license plate to be displayed. Defendant contends that although Exhibit A makes it appear that law enforcement was focused on the lack of a front license plate early on, it was not until after he was identified through IGG that it became an object of inquiry. Correct. That's correct. In neither example has defendant established Detective Payne's investigation timeline to be misleading or false. What? But that's a lie, Hippler. If you read the PCA, you're expecting to read it in the chronological order of the way that things freaking happened. And the way that they have the tip from 1129 in there does make it sound as if they were onto him from way back then. And that's a freaking lie. That's a freaking lie. We already know it's a lie. How are you going to sit here and gaslight the entire world? Jesus Christ. What's that dude say? Jesus Christ on a motorbike. Y'all listen to him? He's so funny. He's so funny. I don't remember his name. Some of y'all probably have heard that before. He's hilarious. Anyway, let's get back to this lie. There can be no question that defendant was identified in part through the WSU officer's queries and through the suspect vehicle's lack of a front license plate. No, as observed in surveillance videos from the night of the murders. Okay, but you know what? The people that look at the freaking picture of the car from the gas station, they are so cracked out in the head over this case that they think that the car is being pulled in a tow truck because you can't see the tires. Not realizing that, the way the world works is that something's spinning so fast, you can see straight through it. So if you're watching a car drive past you at, normal speeds, you don't see the design of the rim. You don't see if it's 5-spoke, 6-spoke, 8-spoke, got a design in it. You can't see anything except the brake calipers, mostly if they're colored. So this whole thing about there being no possible license plate, can they actually see that? Like, can they actually tell that if the road is like this and the camera is like this and the car is going this way and it's dark in the middle of the night and the cameras are crap? Can they actually see if it does or doesn't have a front license plate? I don't think they can. I really just don't think they can. They're going to have to show this shit. They're going to have to prove it. They're going to have to show all of this in court and hope that it backs up their bullshit. So ridiculous. So ridiculous. And this whole thing, there's no question the defendant was identified. You didn't do anything to identify him in this way. You already inputted the Moscow traffic stop as identification purposes. So no, this is crap. And this is more crap. And more crap. The fact that law enforcement had additional DNA evidence tying defendant to the crime does not render it improper for law enforcement to rely on independent evidence accomplishing the same. But they didn't. Because they didn't even know about the damn tip until after they had his name. If they would have been on it, looking into it, and actually doing something with it prior to that, again, I could let you make it on it. But they didn't. They have no proof that they did. They didn't even go and talk to the people until after they had Bryan's name. They didn't even check up on it. Not even an initial checkup. And it was right there at WSU. How much were they really looking for the suspect? Seriously. How hard were they really looking? Especially then, what else did we find out? What else did we find out? That the private driver that lived close to Bryan also turned in Bryan's car? So you're telling me that you've got 1129 WSU and private driver dude, I think on December the 10th. You didn't check up on either one of those? You didn't bother until the feds gave you his name? Y'all weren't doing shit. That's why I said that I was disgusted with freaking Chief Fry trying to use this investigation as a leg up for his freaking election for the next place, his next position that he wanted to go in, because homeboy did nothing. Homeboy did nothing. Absolutely nothing. It would arguably be irresponsible for law enforcement to rely solely on DNA evidence without making an effort to corroborate it. You haven't. Everything that you've tried to corroborate it with is no go. No connection, nothing on his phone, nothing in his car, nothing in his apartment. Everything you're saying is nothing but a big failure, Hippler. Like, this is so ridiculous. Absolutely ridiculous. I cannot believe him. I cannot believe these lies. This is ridiculous. Okay. Talks about United States versus Taylor from 2023. Convenient last name there. Observing that requirement under Franks that search warrant affidavit be truthful and complete does not require that every facet recited therein be correct or that every detail of investigation be provided. So things can be wrong and lies and it's fine. Sure. Indeed, what is important to probable cause is the totality of the evidence once all gathered and examined in light of what was what that collection of evidence shows, not looking at it in isolation as each piece of evidence was separately gathered. Moreover, had law enforcement indicated in Exhibit A the WSU query and lack of a front license plate only came across its radar after defendant had been identified through IGG, defendant has not explained how this would have eroded probable cause because it did nothing to put him at the scene. Cool, you proved he lived at those apartments and worked at the school. Good for you. Like, is this guy serious? This is so ridiculous. Ridiculous. Absolutely ridiculous. I'm just like... This is ridiculous. Like, I'm still like I'm speechless, but I'm mad and I want to keep talking, but I'm speechless at the same time because this is ridiculous. This is wild to me. Okay. Moreover, had law enforcement indicated in exhibits, I think I read that part already. Yeah. Indeed, as discussed below, including the IGG evidence, would have provided more, not less, probable cause supporting the search warrants. No, it wouldn't. What are you talking about? Okay, so the IGG itself would have provided the probable cause in itself. Well, then why are you asking Washington to not even bother with it then? This is ignorant. Okay. E, defendant has not met Frank's burden on issue with the dog barking, and we go to 28. This applies to all the warrants. Okay. In this issue, defendant challenges omissions pertaining to the barking dog referenced in Payne Exhibit A. It states that at 4:17 a.m., a security camera located at a nearby residence on King Road picked up distorted audio of what sounded like voices or a whimper, followed by a loud thud. A dog can also be heard barking numerous times starting at 4:17 a.m. And then there's a 29. This same security camera shows the suspect vehicle departing from the area of 1122 King Road at 4:20 a.m. Yeah, we pretty much knew that. The only other information in the Payne Exhibit A pertaining to a dog refers to the fact that Kaylee Goncalves' dog Murphy was found in her bedroom by first responders, which with the door wide open apparently. Defendant contends that Detective Payne failed to include 3 allegedly important pieces of information pertaining to the dog. 1, that the dog heard on the security camera continued to bark for 30 minutes after the suspect left. That's very wild. 2, that Detective Payne conducted a test to determine that the dog was likely outside while barking. I heard that. You heard that. So Murphy was with Kaylee going down the stairs, going back up the stairs, then running back down the stairs, however the hell that ended up happening, was found in her bedroom with the door wide the hell open. The test shows that Murphy was barking from freaking outside. And that Murphy was found without any blood on him, even though the bedroom doors were open when the decedents were found. But found by who? Not by the people, because we've been told the opposite about Xana's freaking door. So there's that. There's that. So let's read this part one more time. Where is it at? Because there was just a thingy. Okay. So we have this footnote 30 that says Exhibit D13 is a police report authored by Detective Mowry describing the test he and Detective Payne performed to ascertain whether the dog heard on the audio was inside or outside. Okay. But how on the outside are they supposed to be able to tell if it was actually Murphy? Because there's other people that own dogs in that neighborhood. And just because the dog is barking doesn't mean that it was Murphy. This is wild. This is crazy. I am shooketh. I am shooketh by this information. Okay. Okay, yeah. So Jack lives right down the street. Jack lives right down the street. Yeah, I am like, wow, he was outside barking for that long. And nobody like came outside of their house to like say something about this dog barking at 3, 4 o'clock in the morning. Let's read that again. The dog heard on the security camera continued to bark for 30 minutes after the suspect left. The suspect vehicle left at 4:20. 30 more minutes is 4:50. Almost 5 o'clock in the morning. Detective Payne conducted a test to determine that the dog was likely outside while barking, and that Murphy was found without any blood on him, even though the bedroom doors were open when the decedents were found. And then this states the police report indicating Murphy did not have any blood on him. And Exhibit D15B is a screen capture of Officer Nunez's body camera when he arrived at the house, showing that Murphy was lying on Miss Goncalves' bed with no blood on him. Well, that's the thing, because we had a neighbor that told us in the very beginning, before we knew anything, whenever rumors were flying and nobody knew what was going on, that they went on a walk and that damn front door was wide the hell open around like 8:45, 9 o'clock in the morning. I remember that. I'll always remember that. But then we have the Goncalveses, or at least Christy, coming out a long time ago and telling Drunk Turkey Dude that it was a slider that was left open all night. Was it both? It was both. So that kind of like tells me a little bit maybe that as the person or people left, they did leave a door wide open and Murphy did get outside. And then what did he do? Just like bring himself back in? Because it's going to be some shit if we find out that Dylan and Bethany were running outside looking for Murphy and then magically put him back inside the freaking house. But he's just hanging out, chilling on Kaylee's bed. No, I'm sorry. This don't make no sense. I don't know what to think now. He was running around with Kaylee, was free range during the entire incident, somehow got nothing on him. Somebody wrote this. I'm over this life. Somebody wrote this shit. This is wild to me. According to defendant, this omitted information would have revealed that whoever was in the house brought the dog back inside after the suspect vehicle left, which is probably freaking true because how else? And I also did hear people originally have like some sort of rumor going around that the dog was outside at some point. This is insane. Okay. He further argues this information is material and exculpatory because it undermines the narrative and timeline that supports probable cause. I mean, lots of things do. However, defendant's argument assumes without proof there were no doors left open in the home after the suspect left. This assumption is not only speculative, but contrary to evidence in his proffer that the sliding glass door to the residence, the same door towards which Dylan reportedly saw the suspect walk, was left open. So for sure, that's like proof right there. Evidence in his proffer that the sliding glass door to the residence was left open. So they do have proof that the back slider was open all night, is what that says. Thus, if the dog heard barking was in fact Murphy, it could well have come back inside through the open door and gone into Miss Goncalves' room on his own, where it evidently remained. It is a he, Mr. Sir. There is simply no evidence to adopt defendant's speculation that someone brought Murphy inside after the suspect left the residence. Consequently, defendant has not shown that the failure of law enforcement to so speculate was a material and exculpatory omission that was intentionally or recklessly excluded. I mean, my brain is just like mush at this point. It's after 2:00 in the morning. It's like 2:30 in the morning. And I am shook. So he was like outside running around barking for half a freaking hour and then just came back inside where he abruptly stopped barking? Or was he barking because nobody was letting him in the freaking house and then he abruptly stopped barking because somebody finally let him in? This is insane. And the crazier part is that the Goncalves know all this and they're still pulling their shit. This is so wild to me. Okay. Defendant has not met Frake's burden for cell phone data. And it applies to warrants issued after December 23rd. Issue 7 challenges Exhibit A insofar as it discusses data from defendant's phone and conclusions drawn therefrom. He asserts that Exhibit A falsely implies defendant's location on the night of the murders based on improper speculation, misrepresentations, and omissions about 4 topics. The geofence return, which showed nothing. The timing of the second AT&T warrant, which is insanely too short for what it's supposed to have actually been, concluded there. The time defendant's phone stopped reporting, 7 minutes different apparently, and cell tower coverage area. We have a 33. Defendant included a subsection on CSLI data, indicating that it supports a finding that defendant traveled south from Pullman sometime after 2:42 a.m. This appears to be duplicative of the section regarding the time defendant's phone stopped reporting to the network. Well, that's because it all is valid. I don't like this dude. I don't like him. Defendant's proffer on each of these topics is insufficient to warrant a Frank's hearing. Of course you think it is. The geofence return assertion was not a false or misleading statement. Defendant first takes issue Detective Payne's assertion with Detective Payne's assertions regarding the geofence return. In Payne Exhibit A, Detective Payne informs the magistrate that a query of the 8458 phone in these returns did not show the 8458 phone utilizing cellular tower resources in close proximity to the King Road residence between 3 and 5 a.m. He then states, we know exactly what the PCA states. I'm not going to repeat the PCA. Defendant contends that Detective Payne's claim that criminals will turn off or leave their cell phone elsewhere before committing crimes is highly speculative and conclusory. He argues that it is just as likely the phone was not present in the area. Defendant has not demonstrated the statement was deliberately or recklessly false. What Payne Exhibit A shows is that Detective Payne, based on his training and experience, drew one conclusion about the lack of a return to the exclusion of other possibilities. Okay, well, they also claim that the car must have had to have gone this way because of the lack of evidence on camera this way. Like, literally go read the dang thing. We've gone over it. Because there's no camera footage this way, even though there's no camera footage this way either, because there's none over here. It just has to be that way, even though there's none over there either. Like, that's literally what the damn thing says. I cannot believe this is just the way that they think this stuff is supposed to happen. So not normal. Not normal. While there certainly may be other reasons for the lack of a return, meaning nothing came of it, the mere fact that the affiant did not list every conceivable conclusion does not taint the validity of the warrant. Further, Detective Payne's conclusion was expressly based on his training and experience in conversations with other experts, which further belies? You know what? Whatever. Any suggestion that it was deliberately or recklessly false. If Frank's hearing is not warranted on the issue. Challenge to timing of the second AT&T warrant is conclusory. Defendant next challenges the 1 hour turnaround time from the law enforcement received the warrant on the first AT&T warrant and submitted the application for the second AT&T warrant. Wasn't it more like 53 or 57 minutes? It was either 53 or 57 minutes, something like that. Okay. According to defendant's expert, Thomas Slovinsky, remember whenever they like fat fingered his name and the only thing that was found on the search engine was the document where they fat fingered this guy's name because it was like so screwed up. It takes 1 to 2 days at the minimum to secure call detail records from AT&T and then convert, analyze, and peer review them. He surmises that the fact that Detective Payne was able to complete these tasks in 1 hour means that the FBI has already secured and analyzed the information and provided their analysis to Detective Payne, who simply reported to the magistrate that he was told without telling the magistrate the truth about how the investigation truly unfolded. What? He surmises that the fact Detective Payne was able to complete these tasks in 1 hour means that the FBI has all... Oh, okay. So because it had a 1 hour turnaround time from the first one coming in to the second one being issued, they basically believe that they had all the information already and they didn't actually have to look at the stuff that came in from the first one. Is sort of is I think how that sounds. I think that's what they're talking about. I think that's what they mean. Franks does not contemplate such conclusory accusations. The challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. Mr. Slovinsky was not involved in the investigation, and his attempt to input on towards conduct to law enforcement lacks any foundation. As Detective Payne testified at a prior hearing in this matter, he received the return from the first AT&T warrant and immediately turned the material over to FBI agent Balance to begin deciphering it while Detective Payne started on the second search warrant application. While defendant may wish to cross-examine Detective Payne on this issue, it is not a basis for a Franks hearing. Further, even if the FBI had already secured the records prior to receiving the return on the first AT&T warrant, defendant has not shown how the inclusion of this information in Exhibit A would have negated probable cause. Well, wouldn't that mean that it was all gotten illegally? I mean, that's kind of like what that sounds like to me. Defendant has not shown the alleged misstatement regarding when defendant's phone stopped reporting was intentionally false or exculpatory, but it's there. but it's there. That statement, that title tells me it's there. Man, defendant next asserts that Detective Payne misrepresented the time defendant's cell phone stopped reporting to the network to imply that defendant was traveling towards Moscow between 2:47 a.m. and 2:54 a.m. when he was not. On this point, defendant relies foremost on the affidavit of his expert, Mr. Slavinsky. Affiant has found inaccurate information in Officer Payne's affidavit for search warrant and application for an order for a PIN registry or a trap and trace device. See, if the timing is incorrect and that incorrect timing is what they use to get all of these things, and how is it not being granted? Sure. I'm so tired of all this. Like, none of this makes sense to me. It's just wild to me this is happening. And like, my brain is like, there's no way they think this is right. There's no way that they can actually sit here and think that all this is accurate. Payne makes a false statement in his affidavit. Payne states in his affidavit, Bates 003772, that at approximately 2:47 a.m., the 8458 phone stops reporting to the network. This statement is erroneous. Payne has failed to advise the court of the following. The 2:47 a.m. traffic is a continuous 7-minute stream on multiple towers that ends at 2:54 a.m. Payne does not document this 7-minute traffic. 7-minute traffic. What does that mean? 7-minute traffic. Like actual traffic, like cars? Like actual traffic? Or is that something to do with phones and the way that the towers communicate? I don't get it either, you. The 2:47 a.m. traffic is a continuous 7-minute stream on multiple towers that ends at 2:54 a.m. Okay, multiple towers. So it isn't traffic like cars. It is that. So are they trying to say that he didn't actually come off tower till 2:54? I think that's what I think that's what they're saying. Payne did not inform the magistrate about these handoffs. Oh, the handoffs to the towers. Okay, yeah, that makes sense now. Okay. Which would have clearly indirectly shown him the fact that on November 13th, 2022, from 2:47 to 2:54, Mr. Kohberger's device was not heading to Moscow as purported by Payne, but was indeed heading southbound from Pullman, Washington. The fact that Payne either disregarded or was not aware of the handoffs and the direction of travel of Mr. Kohberger's device gives this affiant grave concern over the lack of training and experience Payne has in mobile forensics and the credibility of his affidavit. Okay, but I got to be honest. What did we learn? That you could be going this way, but your cell phone tower that your phone attaches to is the opposite direction. And we can't be biased in that way when it comes to the way that we know that these things work. So I'm going to assume that the handoffs have something else backing them. I'm going to assume that the handoffs have something else backing them. Defendant's other cellular expert, Cy-Ray, so there's two. Cy-Ray likewise contends he has reviewed multiple search warrant affidavits prepared by Detective Payne, and his statements that defendant's cell phone stopped reporting to the network at 2:47 a.m. is blatantly false and not supported by the AT&T data. In addition to these two expert affidavits, defendant includes in his proffer the AT&T call detail records that purportedly reveal that the actual time the phone stopped reporting to the network was 2:54 a.m. Did he call somebody? Did he get a phone call? Did he call somebody? As an initial matter, defendant has not provided the search warrant affidavit identified by Mr. Slavinsky with his proffer. The only search warrant affidavit is authored by Detective Payne that defendant has provided with his proffer is Payne Exhibit A, which is dated December 29th, 2022, and accompanied an application for a warrant for defendant's arrest. The court cannot consider the effect the alleged misstatement would have on probable cause without the correct affidavit before it. So would that be the cast report that he's talking about? Is he trying to say that he doesn't have the cast information that actually shows the right timing, and so he can't compare it? That sounds like that's what he's saying. I could be wrong. That's what it kind of sounds like. The court cannot consider the effect, however, the search warrant affidavit referenced by Mr. Slavinsky is otherwise part of the record in this case as to other motions, and the court will take judicial notice of it for purposes of deciding this issue. What? Okay, well, they decided no. It says to see the pin, trap, and trace. They decided no already. Oh, well, whatever. The court does not find defendant's proffer deserving of a Franks hearing. You just don't deserve it. You don't deserve it. First, defendant has not established the challenge statement is a misrepresentation. Detective Payne expressly qualified his statement by noting it was an approximation only. As he testified to at an earlier hearing in this matter, Detective Payne is not an expert in deciphering CDRs. Thus, I am getting really tired. How many more pages do we have? Okay, shouldn't be too bad. Thus, he provided the records to FBI Special Agent Balance to analyze and relied on Agent Balance's analysis in drafting the PIN register affidavit. That affidavit disclosed both Detective Payne's reliance on Agent Balance's analysis and Agent Balance's training and experience to the magistrate, but it didn't because his name is not the person being, like, his name is not in there. It just says an FBI guy with this kind of training in CAS, but it doesn't give his name. So that's not true either. That's not true. To the extent the approximation was off, a 7-minute discrepancy, particularly one occurring more than 1 hour prior to the homicides, it doesn't matter. It's around the time that y'all are claiming that he left his freaking apartment to start the journey to the bullshit. So yes, it matters. Oh my God. This judge is stupid. This judge is stupid. Okay. Is not so far outside the approximate window as to render the statement false. Yes, it is. Because y'all are claiming he left Pullman and did all these things. And because this is in the time frame that y'all are putting in the PCA for when his car went from A to B, according to you, it doesn't matter that it was an hour before the crime. It matters that it's in y'all's information and that it's smack dab in the middle of what y'all are claiming happened here. Like, this is insane. Absolutely insane. Further, even the statement could be characterized as false. Defendant has not shown it to be intentionally or recklessly so. So he's not technically stating that it's not technically false. I mean, because he's even given it leeway. Like saying, even if it could be, he's not showing any proof that it was done on purpose. Well, he is, but you kind of just like choose to ignore the fact that this was completely reverse engineered and that they took whatever they could and they lied about whatever they had to lie to make it fit around the non-tip that was given to them by the actual lead investigators of the case. Can we stop pretending? Payne and Mowry were not the lead investigators on shit. The feds were the lead investigative team. Let's be for real. They can quit playing. This isn't the 80s, the 90s, or even the early 2000s. We are aware of the boo-boo. They can stop. They can literally freaking stop. In fact, not even Mr. Slavinsky goes so far impute this mens rea to Detective Payne. Rather, he points out that Detective Payne either disregarded or was unaware of the handoff data that would have revealed the correct time the phone stopped reporting. Okay, well then it's Balance's fault. Then it's Balance's fault. Let's put the blame where it goes, on the investigator, the actual lead investigators, not the little tipsters, the actual lead up here agency. Then it's Balance's fault that it's wrong. Then it's Balance's fault. Based on Detective Payne's self-described lack of expertise in analyzing CDRs, it is reasonable to infer the latter, which amounts to, at most, negligence. No, It's because he was following instructions from somebody who was supposed to know better, and that person purposely misled him. That's what it sounds like to me. Further, Detective Payne relied on agent balance to decipher the CDRs, which he is entitled to do in executing probable cause affidavits. But he's not allowed to have the work completely done for him and not understand what he's doing, not understanding what he's also putting on a paper. He has to have some sort of level of understanding. He has to, and it doesn't sound like he does. Finally, the defendant has not shown Detective Payne's mistake in identifying the handoff data to be exculpatory. I guess it just all depends what the data actually says. Mr. Slavinsky claims it was exculpatory because a correct interpretation of the data would show the device was not heading to Moscow as purported by Payne, but was indeed heading southbound from Pullman, Washington. Well, then it's exculpatory because you can't put him over there. And this is saying that he wasn't even heading in that direction, just like they've been saying this entire time. There are two problems with this assertion. First, the PIN register affidavit presents that the device was traveling south at 2:47 a.m. when, according to Detective Payne, it last reported. I mean, yeah, that's technically true. It did say that it was going south, but what they meant by that was south from his apartment, not south from Pullman, south from his apartment. That's what that meant. Through Pullman, not south of Pullman, which is what they're claiming, south of Pullman. Payne is saying south through Pullman. The state is saying from Pullman. I mean, the defense is stating from Pullman, and the state is stating through Pullman, and there's the difference. And we're not going to read all of this because it's from the PCA, but this is what I'm talking about. Traveling south through Pullman. And that's a little bit different. The wording, like this one word, is a huge difference in that statement. Thus, because the exculpatory information identified by Mr. Slavinsky appears to have been represented in the affidavit, but it wasn't, the court is at a loss as to how a correct statement of the time the phone stopped reporting to the network would affect probable cause. This dude's a joke. Dude's a joke. Second, even if the PIN register affidavit did misrepresent the defendant's cell phone was headed to Moscow between 2:47 and 2:54 a.m., as opposed to southbound from Pullman, a correction would have no effect on probable cause. Traveling southbound from Pullman at 2:54 a.m., more than 1 hour prior to the homicides, does not disprove the defendant could have driven to Moscow after 2:54 a.m., after his phone stopped reporting to the network. Bullshit. There's no proof that he was at King Road. And we can go further. No hair, no DNA, no blood, no social media, no stalking, no nothing. And we can keep going. We can keep going. We can keep going. As the affidavit points out, footage from multiple videos obtained from the neighborhood around 1122 King Road showed several sightings of a vehicle matching the description of defendant's vehicle starting at 3:29 a.m. and ending at 4:20 a.m. Yeah, so did the cop car that was over at the Banfield and like 20 other different vehicles in that neighborhood and probably thousands of others, considering that Chief Fry himself out of his own face said there was over 20,000 vehicles that fit the description in that area. So that doesn't really tell me nothing either. What's the population? Divide that by 20,000. There's your ratio for how many of those freaking cars that you're probably going to see, the percentage of how many of those cars you're going to see. This is stupid. Given the proximity of Pullman to Moscow, the fact that defendant may have been traveling southbound in Pullman at 2:52 a.m. does not exclude him as the potential driver of the suspect vehicle from a probable cause standpoint, which they probably put that ginormous gap in there. Bro, how about this? This just popped into my brain. Like, there's like a reason I feel like they're not telling us the time of death. They're giving it at like noon for no reason whatsoever, other than the fact that that's whenever the cops got there. But they have all this stuff on camera and like all these other things, right? So if they're going to do like a bunch of this reverse engineering shit, then it just feels like they broadened this like for a reason, because that's how it fits. I mean, I know that there's apparently some sort of struggle like in the 4:00-ish hour on the camera. I don't know. That whole thing doesn't make any sense. That whole thing doesn't make any sense. That whole thing about the dog just kind of like blew my mind. Like seriously, just kind of blew my mind. So I guess that wouldn't really matter, because if there really is like a struggle on the cameras and they can prove the timing. But if that's the case, then why can they still not give us proper time of death? And they can't really keep blaming it on the 8-hour delay and the doors being open and the temperature and blah, 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 because there's like technology. If you can fossil date stuff back millions of years, you can figure out exactly when all this happened besides all of this. Like you have all of this stuff that you claim you have, but you still can't give us time of death. So maybe it doesn't take away probable cause because it is such a vast amount of time, well over an hour and a half-ish, a little bit less than an hour and a half. But if you cannot put him there, then it doesn't matter. It could have been literally just in enough time to get there and go back in 20, 30 minutes. And if you can't prove that he was over there, then it doesn't really matter. So I don't completely disagree with this, because it is such a stretched out amount of time. But if there's no actual proof of this happening, then the possibility goes away. The possibility completely goes away if there's no evidence backing this up. If you can't see him, if you can't put him there, if his location is not actually putting him there, if there's no proof of any of it, then none of this matters. It can all be speculative. It can all be circumstantial all day long. But if there's no actual evidence to concretely stand on, then it's just as stupid as saying he went this way just because there's no cameras that way, and so it has to be that way, which is exactly what they said. None of this shit makes any sense that they're trying to pull here. Moreover, the strength of the other evidence described in the PIN register affidavit cannot be overlooked. The affidavit describes how CSLI data showed that defendant's cell phone left his apartment at approximately 2:45 a.m. and started traveling south before it ceased reporting to the network, approximately 90 minutes before the homicides occurred. The phone then started reporting to the network again, approximately 90 minutes after the homicides occurred, at which time it was traveling south on Highway 95, just south of Moscow, before looping back north into Pullman via Highway 195. Again, the same thing I just said about the cell phone towers, and the same thing I said again about the cell phone towers, we're going to say it again. That whole little loop-de-loop thing is literally just where his cell phone was connecting to towers. It doesn't technically have anything to do with his location, especially if he was in an area where he had no service. His phone would be trying to reach for everything. That's why the other portion that even the defense said here, they've got to have to back that up with something else besides the phone tower, besides whatever they're claiming about the phone traffic or the tower traffic. They're going to have to back that up a little bit more than that. Because if I'm going to say that to the state, I have to be fair and say the exact same thing to the defense. Okay, consistent with the CSLI, surveillance cameras from the Pullman area showed a white Hyundai Elantra consistent with defendant's vehicle returning to the area of the defendant's apartment at 5:25 a.m. As Detective Payne pointed out, individuals commonly turn off their phones prior to committing a crime to avoid alerting law enforcement of their presence near a crime scene. But somebody smart who's been doing this and studying this for over 10 years would have turned that shit off before he left his apartment. And they definitely wouldn't have kept on their boo-boo, knowing that they turned it off after their apartment. That's not going to happen to somebody who's been studying all this. They can... Come on. As Detective Payne pointed out, individuals commonly, blah, 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 I already read that. The obvious inference is that defendant turned off his cell phone to avoid detection until he was clear of the crime scene. And there's no proof of that. In addition, the affidavit described footage from multiple surveillance videos that captured a vehicle consistent with defendant's make 3 passes by 1122 King Road between 3:29 a.m. and 4:20, at which time it departed from the residence at a high rate of speed. And that car apparently isn't caught anywhere else and can't be identified as for what it actually is, besides it being a white 4-door vehicle. On one surveillance camera, according to Detective Payne, the suspect vehicle did not appear to have a front license plate. We already talked about all that. Finally, CSLI evidence shows that approximately 9 a.m. on November 13th, this is the part that I want more information on. This right here. And I've talked about this from day one, no matter what I've thought. Everyone that's been here forever knows this. This has been my biggest thing when it comes to phone data. CSLI evidence shows that at approximately 9 a.m. on November 13th of 2022, a mere 3.5 hours after defendant's return to his apartment, he again left his apartment and returned to Moscow, utilizing cellular resources that provided coverage to 1122 King Road from between approximately 9:12 a.m. and 9:21 a.m. before traveling back to the area of his apartment at 9:32 a.m. This is consistent with defendant to returning to the scene of the crime. This is the stuff I want proof of. Because if they have daytime video at 9 o'clock-ish in the freaking morning when the sun is up, okay, of his car driving, you can see at that point who's driving the car. So if there's concrete evidence, surveillance camera footage proof that he actually went to King Road between 9 and 9:32, I don't know how I would really interpret that. Because I've always had a lot of things in my head for if he was the guy. But then there's always been like a little bit of that in the back of my head about like people knowing ahead of time stuff. But I really just don't feel like it was that far ahead of time to where this would have been. But then again, I don't know who the hell them people were talking to. But then again, there's no connection. So it's not like he would have been on the contact list of people that were being contacted in the middle of the night. You know what I mean? Like they've already proven that that's not a thing. That's why this part right here has always been like, I want to know what this is. You guys already know this. This is not a shock or surprise to anybody who is here knowing that I don't think that Bryan is the guy. Okay. This right here has always been questionable to me. And this is what I want proof of because it's daylight hours. You can see the car, you can see the license plate, you could see anything that was a determining factor in changes in model, and you should damn well be able to see who the hell's driving it. So I don't want to hear just about cellular resources. That tower ping could be anywhere, even with these times. I want to see camera footage of him being at King Road. I don't care that he was around a coverage area. I want to know that he was there. I want to see footage. Detective Payne also noted that defendant's height, weight, and ethnicity were consistent with Dylan's descriptions of the perpetrator. Except I'm pretty sure we know why Bryan's white. Such a strange statement. I don't know how he was white. I just know he was white. How freaking strange. He informed the magistrate that defendant was a PhD student in criminology in Washington State University and had studied how technological data is used by law enforcement. The inference to be drawn from this information is that defendant knew particularly from a technological perspective how to cover his tracks, but then didn't turn his phone off till he left his apartment. According to you. Does that sound like somebody who can cover their tracks? No. When the extent of evidence recounted in the PIN register affidavit is considered a whole, it is evident to the court that had Detective Payne stated defendant's cell phone was traveling southbound from Pullman when it stopped reporting to the network at 2:54 a.m., there was still enough probable cause linking defendant to the homicide to justify the issuance of a search warrant, which is probably accurate. Let's be for real. The way they're writing it, it's accurate. The search warrant sought by Detective Payne through the PIN register affidavit was for historic CDRs and CSLI for defendant's cell phone for the preceding 6-month period, as well as authorization for a PIN register and trap trace device. Yep. Consequently, if Frank's hearing is not warranted, of course not, because you're a jerkface, defendant has not shown any omission regarding cell tower coverage area was reckless, intentional, or material. The final claim raised by defendant is that Detective Payne omitted important information about cell tower coverage in Moscow when he stated the records for the 8458 phone show the 8458 phone utilizing cellular resources that provide coverage to the area of 1122 King Road on at least 12 occasions prior to November 13th of 2022. According to Mr. Slovinsky, the two towers that provide AT&T service to King Road also provide coverage to all of Moscow, including the areas defendant is known to shop. Meaning they have proof that he goes to Moscow and shops at places that also use the towers at King Road. That means there's proof. Thus, defendant claims Detective Payne misled the magistrate about the location of defendant's cell phone on these 12 occasions. I believe so. Yes, I do. The accusation here is one of omission, specifically whether Detective Payne recklessly or intentionally withheld from the magistrate that the same towers providing service to King Road also provided coverage to all of Moscow. There is no direct evidence that Detective Payne intended to mislead the magistrate, nor can it reasonably be inferred given that defendant was not shown the omission to be material and exculpatory. While including the information may shed some doubt on whether defendant was actually in the vicinity of King Road on these 12 occasions, as opposed to some other nearby location, it does not disprove Detective Payne's statement or otherwise exculpate defendant. Okay, but it's also like you're being an asshole. You're being an asshole. If you have proof that he goes and shops at all these certain places and proof that those certain places use the exact same tower, then you're fibbing. You're fibbing and you're full of it, and you know that you're full of it. Given the breadth of exculpatory evidence included in Payne's Exhibit A, it is difficult to ascribe ill intent to this alleged omission. Further, and importantly, probable cause did not rise and fall on the evidence of defendant's 12 prior visits to Moscow. Don't sit there and act like putting that in the damn thing doesn't make it sound like he's been stalking them. We already had this discussion in court whenever Thompson had to stand up and throw a Santa-sized temper tantrum about how that was a false statement. Why is he acting like he doesn't know any of this? The defendant has not met Frake's burden on issue number 9, the footprint outside of Dylan's door, which is number 36. Maybe we'll finally get a shoe size. This applies to warrants issued December 29th, 22 and later. Okay. Defendant challenges as false a statement made in what? Defendant challenges as false a statement made in the Payne Exhibit A about a footprint found outside DM's door. I feel like that sentence is not accurate, but I'm also really tired, so I don't really know. During the proceedings of the crime scene, investigators later found a latent shoe print. The detected shoe print showed a diamond-shaped pattern similar to the pattern of a Vans-type shoe sole just outside the door of DM's bedroom, located on the second floor, consistent with Dylan's statement regarding the suspect's path of travel. But it's not, because according to Ann Taylor, it's in the threshold. So he would have had, somebody would have had, the person would have had, whoever would have had, to have ran up on her, halfway walked into her bedroom door, like through the threshold, for that latent shoe print to show up where it was, with no trail or footprints leading or going from it, which is absolutely ridiculous. Defendant contends the last sentence is false, noting that the footprint is closer to her bedroom door than she reported the suspect to be. There are no other prints before it or after it, like I said, and it is not positioned towards the sliding glass door, which is where DM said the suspect walked after passing by her. Number 37, Exhibit D22 shows the footprint at the threshold of Dylan's bedroom door. Like I said, it's right there in the frame on the door. Defendant further claims it is an intentional or reckless statement because its only purpose was to corroborate Dylan's unreliable statements, which is true. There was nothing false or misleading about Detective Payne's statement. I'm sorry, but if it's not facing the direction of the sliding glass door, then yes, it is. Yes, it is. The shoe print was consistent with Dylan's account. She told law enforcement she saw defendant walk past her bedroom door after she opened it for a third time. And then I opened the door again and the guy is right here, right there. Okay, but like he would have to have been like in your face and then took a step in order to be where that door was before this. Thank you for the $9.99, Meg. Thank you for still being here at 3 o'clock in the morning. I'm surprised I'm even able to talk, honestly. I don't think I've ever been live for this long. I think close to this long for some other documents, but I don't think I've been on live for 8 hours before. I'm tired. Are we almost done? We're on page 30. We're almost there. Okay. Dylan's bedroom door is immediately at the landing at the base of the stairs leading to the upstairs bedroom. The shoe print was, therefore, reasonably within the suspect's path of travel as described by Dylan. No, if her door was closed, how the hell would the foot have gotten where it was? This guy's dumb. This guy's dumb. Further, the fact the footprint was located only in one spot and there were not others before and after does not make Detective Payne's statement false about the path of travel. You can't tell a path of travel with just one thing. You have to have more. For it to be traveling, there has to be more than one little step thing. No, that's crap too. Consequently, defendant has not shown Detective Payne's statement was false or otherwise misleading. Additionally, defendant has not established that Dylan's interview statements were wholly unreliable as discussed supra, or that there was otherwise a need to bolster her credibility in the magistrate's eyes through false corroborations. Consequently, even if the shoe print was not totally consistent with Dylan's account, defendant has not demonstrated that the statement was made deliberately or recklessly. Moreover, defendant has not articulated how excision of the statement would have any bearing on probable cause. Okay, I have an issue with this. We about to be honest. Y'all ready for something you might not want to hear? Why aren't they arguing that it's not the right size? How come they're not arguing that it's not the right size? That would make more sense for their argument, that it wasn't Bryan Kohberger's shoe size. And I'm told y'all I'm honest about stuff. And that's the first thing that came to my mind reading this, was that they haven't given us a shoe size for what size shoe they believe the latent shoe print is. And they're not arguing that this is not his shoe size. They're arguing the direction. Honey, if you knew my ex, you would know I'm not a size queen. I'm just going to say. Good night. I know, I'm tired too. Yeah, his was a size 13 as far as I understand from the inventory reports. I really wish they would have been like, it ain't my size, bro, because then that would have made sense. So, I mean, I'm going to question that. We're honest here. We're going to question that. I don't know how I can either. I'm sure I'm missing stuff in the back of my brain. But yeah, I mean, I'm gonna question that because I feel like their stronger argument would have been it doesn't match his shoe size. So we will continue. Put a pin in it, but we will continue. Defendant has not met the Frank's burden on issue 11, which is the grand jury subpoenas. You mean all the ones that are not like allowed to be seen by anybody? Ridiculous. Okay. Issue 11 faults law enforcement for omitting information in the Exhibit A supporting the search warrant for Amazon records, which was issued May 8th of 2023. And now we have a 38. Defendant does not provide the search warrant application for Amazon or the warrant itself. Well, isn't that because it's from the feds and they don't have it because it was a federal grand jury warrant? Nope, this is May 8th. It would be MPD. But he didn't put it. Why wouldn't you have put that in there? Because it's available. They should have the unredacted versions. Specifically, he asserts the affiant, Detective Mowry, requested the warrant in reliance on federal grand jury subpoena issued by the FBI to Amazon, but did not tell the magistrate information about the timing and scope of information obtained and relied upon. Defendant further states he is unable to ascertain whether the omission was material and exculpatory because the grand jury subpoenas have not been disclosed. Defendant has not established that this issue is the proper subject of a Franks motion. He has not provided the search warrant affidavit at issue, has not identified any false statement, and the only omission he challenges is that Detective Mowry did not disclose unidentified particulars about the timing and scope of information obtained from the grand jury subpoenas. He admittedly cannot show this omission was material and exculpatory, and therefore cannot establish that probable cause would have been affected had the omitted information been included. What this challenge appears to be is an attempt to use Franks as a means for discovery, which is not its purpose. Consequently, the Franks hearing is not warranted. Yeah, nothing's warranted with you. Defendant has not met Frank's burden for issue number 12, which is the lack of connection between defendants and victims. I already know what he's going to say here. That it's not necessary for there to be a connection between victims. We know that. We talked about the Gainesville Ripper here plenty. We did a whole thing about it. So this again, it matters in the way that they're trying to present the case. But in the end, we all know that it honestly doesn't matter. Because there's plenty of people that go real stupid on people that they've literally seen for like 2 seconds. So again, this doesn't really mean too much either. On issue 12, defendant challenges law enforcement's omission in their exhibit A's. Let me take that back. The connection between him and the victims when it comes to social media and all that stuff, I get, like, because of the Gainesville Ripper and like anonymous attacks and blitz attacks and stuff like that. But when it comes to the lack of everything after, the lack of being able to put him at the location, the lack of anything in his car, the lack of anything in his apartment, the lack of anything after the fact, like there's no proof of a cleanup, there's no proof of anything getting deleted or scrubbed or anything like that, because nothing is really truly deleted. They can find it if it belonged there, if it was ever there, they can find it. And they can't say any of that so far. And that's the stuff right there that matters to me. The stuff that they can't find but can't prove was deleted on purpose or hidden or anything like that. It just literally means it's just not there because it's not there. It's just naturally not existent. It doesn't materialize in the way that they want it to. In issue 12, defendants challenges law enforcement's omission in their exhibit A's of the fact that their investigation failed to reveal any connection between defendant and the victims. Defendant claims this information was material and exculpatory because it sheds doubt on law enforcement's theory that defendant was the right person. I mean, it does, according to what they said, because they swore that this was some sort of targeted attack, and the Goncalveses are out here acting like Kaylee Goncalves is the star of the show. And again, I don't have nothing against her. I'm here for her justice just as much as the other three. It's her family that causes issues. Kaylee deserves her truth. And they're not allowing her truth. They knew all this stuff. Her running around with the dog and Murphy being outside, barking his freaking head off and being on her bed and all the things. They knew all this. And they still came out and told the world this crazy boudet story about how the girls fell asleep in their bed together because they were besties. This is tragically ridiculous enough. There was no reason for the lies and the exaggeration. Literally none at all. It's not necessary. We were already here before all of that. We wouldn't have left just because we didn't know that they fell asleep like little besties. We wouldn't have like disappeared from the case. We wouldn't have not cared. I just don't understand why like the extra unnecessary things doesn't really make sense to me. It really just doesn't make any sense to me. Okay, number 40. Defendant's argument presumes that Franks requires law enforcement to disclose that evidence does not exist or has not been found. This is not a realistic burden, particularly given that search warrant affidavits are typically executed under rapidly unfolding circumstances. Indeed, there is no requirement under Franks that law enforcement disclose every detail of an investigation or describe every wrong turn or dead end they pursued. And then it talks about United States versus McMurtry from 2013. Certainly, then, there is no requirement to disclose a lack of evidence, particularly when the obvious inference to be drawn from the absence of any mention of such evidence is that it does not exist or has not been located. No, it just doesn't exist. Y'all had too long. It doesn't exist. Let's be serious now. Let's be for real. Thus, he cannot establish it was intentionally or recklessly omitted. Moreover, this omission was not material or exculpatory. Had law enforcement found a connection between defendant and the victims prior to applying for search warrants, it is reasonable to assume the connection would have been disclosed in the search warrant affidavits. Exactly. The fact it was not disclosed necessarily allowed the magistrate to reasonably infer that no connection had yet been found, yet she still found probable cause to authorize the search warrants, as was reasonable to do. Consequently, defendant has not carried his burden under Franks on the issue. Okay. Defendant has not met his Frank's burden on issue number 13, the lack of victim DNA in apartment or vehicle. My issue with that, I mean, my whole thing with that is the lack of an explanation for how that's possible. And this applies to anything issued after January 5th of 2023. Similarly, defendant challenges law enforcement's omission in the Exhibit A's of the fact that lab testing performed by the Idaho State Police did not reveal the victim's DNA in defendant's vehicle or his apartment. Defendant contends the lack of DNA is devastating to law enforcement's theory of the case and was intentionally or recklessly omitted. However, as with the prior issue, defendant has not established when law enforcement knew of the lack of victim DNA in defendant's vehicle and or apartment. See, this is that argument that they had that made no sense to me, that I said Ann Taylor needs to just stop because she sounds dumb, because none of this was figured out until after he was already arrested, after the probable cause. This would have been stuff that would have been brought up if we would have had a preliminary hearing in October. But you can't use something to try to fight probable cause for something that didn't happen until after the probable cause was already executed. You know what I mean? This is exactly the same thing that I was talking about. The 3 ISP lab reports relied upon by defendant were issued on March 2nd, March 8th, and March 23rd of 2023, respectively. Thus, it cannot be said that law enforcement knew of the lack of DNA until the last report was issued. Defendant has not provided or identified any search warrant affidavits submitted after May 23rd of 2023, much less explained why the lack of DNA was material to probable cause for those warrants. It wasn't. It all happened after the fact. In his reply, defendant claims that the actual testing for DNA was performed by ISP long before the 3 lab reports were issued, which is true, because they would have done all that shit the second they had it. Not, when was it, May? No, they would have done it way before that. He asserts he has reason to believe that the results of the testing were verbally transmitted to law enforcement at the time. However, the evidence submitted by defendant does not support this assertion, his assertion. First, defendant submits the ISP lab notes from lab report 28 and claims that the testing was done on February 13th of 2023, 3 weeks after the report was actually issued. A closer review of those lab notes revealed that testing of the various items at issue in lab report 28 took place between February 13th and February 24th. The final report was issued 4 working days after the last test. Thus, this evidence does not show that law enforcement knew well before lab report 28 was issued that there was no victim DNA on the tested items. This is at best defendant speculation. Again, I think the reason why they might be trying to use this portion of it towards probable cause is maybe because of the grand jury situation, showing that all of these things were proven already, but then somehow not maybe properly given over to the grand jury that had to decide all this. Maybe is how they're trying to do this. Defendant also submits lab reports from a hair and fiber analysis performed by the FBI lab. Yeah, it literally says on the exhibit list, documents, no connection. Like it's literally like labeled that. The first lab report, dated January 27th of 2023, revealed that hair and fibers collected from the crime scene were not consistent with defendant's hair sample. The second lab report, wait a minute. Okay, yeah, it wasn't his hair, but it wasn't one of their hairs either. The second lab report, dated February 28th of 2023, revealed that hair and fiber samples collected from defendant's vehicle and apartment were not consistent with the victim's hair samples. And there's the exhibit. Again, this evidence does not support defendant's assertion that law enforcement knew of the lack of victim DNA in his vehicle and apartment as of January 5th of 2023. I don't know about that. I don't know about that because they did everything on the 29th and the 30th. And that's like 6 days. So they might have. (42) Defendant also submits what appears to be a worksheet from the DNA handling on January 23rd and 24th of 2023 by the ISP lab. It is entitled Differential DNA Extraction. There are no findings or conclusions made in the worksheet, nor is there any indication of what DNA samples were handled and what DNA extractions means within the worksheet. Thus, it is unclear how this worksheet supports defendant's argument. Well, because there's nothing there. It's discovery and it's blank. There's no answers. There's nothing there. There's no findings. That's the point. There's nothing there. There's no conclusions. There's no matches. That's why it's there. Thank you. At best, it can be said that law enforcement was aware as of February 28th of 2023 that the FBI's testing did not reveal the victim's hair fibers in defendant's apartment or vehicle, but it is evident from the various lab reports that law enforcement's investigation with regard to DNA was still continuing. Therefore, there was no basis for law enforcement to definitively aver there was an absence of victim DNA in the vehicle and apartment until the final reports were issued. In other words, defendant has not demonstrated an omission, much less that it was intentional or reckless. Further, defendant has not demonstrated how including this omission would have affected the magistrate's finding of probable cause. He contends that it would affect all warrants issued January 5th, 2023 and beyond, but he has not provided any search warrant affidavits from this time period for the court's consideration. However, based on the Payne Exhibit A that is included in defendant's proffer, the probable cause as of December 29th of 2022 included, among other things, it's a good thing that was empty, that the DNA profile obtained from the trash pull of the Kohberger family's trash was determined to be from the biological father of the source of DNA left on the knife sheath at the crime scene. Given this evidence, no reasonable magistrate would conclude that the lack of victim DNA in defendant's vehicle and or apartment weeks after the crime would negate probable cause. Thus, a Frank's hearing is not warranted. I mean, I agree because I didn't even find that out until after the fact, like I said. Defendant has not established for Frank's elements by a preponderance on issue 8. Defendant's identification by IGG. 43. Defendant does not identify what search warrants this issue applies to, but presumably it includes all warrants issued after defendant was identified through IGG. Yeah, I mean, common sense. Issue 8. Almost there. My throat's starting to hurt. Like, you know that like filling right before you get strep throat? That's where I'm at. That's where I'm at. Defendant challenges law enforcement omissions in Exhibit A that defendant was identified through an allegedly unconstitutional use of IGG. He contends law enforcement should have disclosed in Exhibit A that 1, the methods used by Othram Labs, and we have 44. Othram Labs was the company Idaho State Police contracted with to perform the IGG testing. Yes, we know. Okay. The methods used by Othram Labs to conduct the IGG testing allegedly did not meet minimum standards. 2, that the FBI failed to document its own IGG search using Othram's data. And 3, that the FBI manipulated Othram's data to create a much larger DNA profile. And 4, that the FBI violated its own policy and that of the commercial IGG databases it used when it uploaded the DNA profile to databases restricting law enforcement use. Defendant contends these omissions from Exhibit A were purposeful. He also argues the omissions were material and exculpatory because they would have undermined probable cause by exposing law enforcement's false narrative of the investigation. And we go down to 45. Again, defendant tries to place the focus of the probable cause evaluation on the narrative of the investigation. What is important for probable cause purposes is what the evidence is at the time the warrant is applied for, not the time sequence in which the evidence was developed. Okay. Where were we? Where were we? Okay, at the end of that one. As mentioned, the court permitted a full Frank's hearing on this issue. The court's findings of fact on the evidence and testimony presented and its conclusions of law are fully set forth in its memorandum decision and order on defendant's motion to suppress genetic information, filed contemporarily herewith and incorporated herein. As the court determined in that order, law enforcement's use of IGG to identify defendant as a potential suspect was not unconstitutional. The court found that regardless of whether the FBI arguably contravened its own policy and contravened that of MyHeritage and GEDmatch when it uploaded the DNA profile to their databases, it was not of constitutional importance. Like it just makes me sick. Moreover, defendant has not established that the search warrant affiants knew when submitting their respective Exhibit A's that the FBI or Othram did anything untowards with regards to their IgG searches. Well, thank you, Artillery Amy. 9:15 a.m. now here in the UK. Been here all night. Yeah, it is 3:17 a.m. here in Texas. I got to be up in 5 hours. I worked 8 hours. I got off at 4:30, jumped on here at 7. Been on here this whole time, put basically a whole nother 8 hours. And now I'm about to go to bed for a few hours and then go to work. So, but I really have like insomnia. So I guess it's fine. It'll work. It'll totally work. We might go live again tonight. Just all depends on what's going on with everything. Detective Payne testified that he knew the FBI was handling the IgG search after Othram Labs ceased work, but said his communication with the FBI about the issue was sparse and limited to check-ins to ensure the IgG search was continuing. He testified that on December 19th, 2022, the FBI provided him only with defendant's name and instructed that it was to be considered solely a tip. Of course they told you that. Y'all listened to everything these idiots said to do, and now y'all are suffering the consequences for it. At some point after defendant was identified through IgG, the FBI walked Detective Payne through the details of the family tree it had developed from its search, but that was all. Further, he testified to having no familiarity about the IgG databases or rules that applied to them. Given the lack of evidence, Detective Payne knew or even had reason to know that Othram or the FBI did anything unconstitutional in their IgG searches. Defendant cannot establish any omission. Defendant cannot establish any omission in this regard from Exhibit A was intentional or reckless. Even assuming Detective Payne had been privy to the methods in which Othram and the FBI conducted the IgG search, Franks does not require law enforcement to divulge every detail of their investigation and describe every lead followed or rock unearthed for evidence. Probable cause affidavits are neither designed nor intended to be an opportunity for the reviewing magistrate to grade the police work on the case by requiring law enforcement to show every step that led to the evidence relied upon. It should. It freaking should. As observed by one circuit court, there is no legal requirement that a police officer recite every fact that he knows in a search warrant affidavit, so long as what he does say is sufficient to support a judicial officer's finding of probable cause. An affidavit must be more than wholly conclusory, but it need only provide the magistrate with a substantial basis for concluding that probable cause exists. It need not present all the relevant information known to the police at the time. In other words, the Fourth Amendment does not set forth some general particularity requirement. It specifies only two matters that must be particularly described in the warrant: the place to be searched and the persons or things to be searched. And that was United States versus Grubb. Thanks for the $10, Faupair. Oh my God, Jules, you must be exhausted. It's bedtime. Thank you for clarifying all this BS for us. You're amazing as always. Rest up for the next shit show. Can you get enough rest for these shit shows? You can try for sure. Have a good night. Brownsville, that's by the prison. That's where my cousin was a correctional officer for a while. Some scary stuff down there, that's for sure. Likewise, there is no requirement that police include evidence as a straw man simply so that evidence can then later be attacked. A warrant application is judged on the adequacy of what it does contain, not on what it lacks, on what a critic might say should have been added. The focus of an application for a search warrant is whether, based on the evidence that is presented, there is probable cause that evidence will be found in a particular place, not whether an evidence-gathering technique used was potentially unconstitutional. It should matter. It should freaking matter. United States versus Leora from 2019, noting that when a magistrate issues a warrant based on potentially illegally obtained evidence, typically the manner in which the affidavit evidence is obtained is not before the magistrate, and the magistrate is not asked explicitly to endorse the evidence gathering procedure. While this may be fodder for a later motion to suppress, he loves that fodder word, doesn't he? Fodder. It is not a basis for a Franks challenge. Franks, in cases of omission, asks simply whether the affiant left out evidence which, if known, would negate the inculpatory effect of the existing evidence and leave an insurmountable deficit in proof of probable cause. Defendant has not established that omitting defendant's identification through IgG evidence or the means in which IgG was performed had this effect. Indeed, had the IgG information been included, even with the problems complained of by defendant, its only effect would have been to add to probable cause, not detract from it. Well, it was there in Washington, which is just still absolutely crazy. And here we go. Here we go. We finally did it. We did it. We did it. We finished the shiitakes in 8.5 freaking hours. My eyeballs and my voice. Holy crackamole. We did it. I need to see if we have some cough drops. Like, I know I'm not sick, but damn, it feels like it. I need to get some cough drops. Yeah, crazy. Crazy. Yeah. Well, I think we knew that. I mean, you'd think so. Okay, because we did like understand the fact that there's multiple unknown DNAs. And now we have, you know, like these 4 brothers that were some sort of weird low match, you know, that they're talking about now. You know, then they try to say that Othram didn't actually have any information, but then they actually did have some information. Holy crap. Oh, I'm about to go make me some sleepy time tea. Meg, don't you do it. I'm gonna go make me some sleepy time tea. I mix my sleepy time tea with a thing of chamomile tea and then put some local honey in it to help my allergies. So maybe that'll help my throat feel better in the morning. I'm tired. And I gotta wake up my dog and tell him to get out of my way because he's in my bed where I'm gonna go to sleep. Dimmy. He don't want none of my shit. Okay. I'm gonna get off of here. Probably put on an episode of Grey's Anatomy so that my brain will cool off, and then go to bed and get up 5 minutes before I have to clock in. Holy crap. Well, good morning. Yeah, I'm just now getting off this. Like, we just now done. Thank you for the $20. We just now done. Okay. I'm going to watch Grey's and lay down. We might go live tonight. We shall see. If I can take a nap after work, then we probably will, just to try to discuss the fact stuff that we have now with all the crazy information, the dog being outside, the dog being with Kaylee, running up and down the stairs, all the crazy shit. That's what we need to be talking about separately now that we've gone through all of this. Y'all have a great night. Thank you so much for y'all being here this entire time. Like, we've been between like 5:50 and 6:30 strong for like hours. There's so much information. Thank you for all the super stickers, all of the super chats, all of the members who joined themselves, all of the members that gifted memberships, all the people that gifted memberships, all of the things. You guys are great. Thank y'all for caring enough to even sit through all of this. Insanity. Like, I'm trying to think of another word. Insanity is the only thing I can come up with. Y'all have a great night. Sleep tight. Don't let the bed bugs bite. All the things. See y'all.